will have to be given in this particular case. So case-to-case basis po talaga yun based on the assessment of the court on an individual basis, depende po sa circumstances of the victims.
At ito po ba ay kailangang mag-file ng claim para makuha yung ganitong reparation din?
I think it's already part of the fact na basta na ano ka na parang na-accredit ka na ng court, no, that you're part of the victims, the list of victims na who were allowed to participate in the proceedings, then parang you will be entitled
so
to
in this case 497, if I'm not mistaken, ano po yung pinayagan ng korte na maging mga biktima.
Kapag ganun po ba din, kasi meron mga kaso, prior cases sa ICC na may mga victims or mga biktima, testigo na biglang umaatras. Pag ganun yung sitwasyon, ano nagiging impact or implikasyon nun dun sa kaso?
Depende po yun if you can still establish the case, no, based on the available evidence. For example, kung marami namang witness and then kung magre-retract or magwi-withdraw yung ibang witness, as long as it does not affect the main case, na may sufficient evidence and witnesses pa rin to establish the allegations or the charges, so wala po magiging impact. Of course, it might affect, no, it can probably weaken the strength of the evidence, but at least basta may sufficient pa rin na naiwan na evidence and witnesses, so okay pa rin po yan.
Din, base po sa nakita ninyong ebidensya ng prosecution so far, at nasabi natin yung mga possibilities, ano, pag ito ay na-confirm, pag hindi na-confirm, assuming the scenario, ma-confirm po itong charges and we go to trial, base ho sa nakikita ninyong direksyon at dami ng mga ebidensya, are we looking at a very protracted trial dito po sa kasong ito?
Siguro, normally, mga ganitong proceedings, normally 2 years, 3 years. Depende rin po sa ano yan eh. But normally, mga ganun po. So we are looking at siguro mga 3 to 4 years, mga ganun. Fair na estimate.
3 to 4? So mahaba-haba pala talaga to.
Oo, mahaba-haba. Although parang yun na yung standard, di po ba?
Yes,
Kasi nga, although syempre rin kasi yung nature of the cases that are being tried sa ICC talagang bukod sa very high profile, that yung charges, di ba, parang very intense. Kaya talagang napapahaba yung mismong trial. Pero kayo po, Dean, I mean, you know, historically speaking, kasi syempre para sa atin, napakalaking bagay nitong kaso na to. I mean, first time that we have a Filipino official, former Filipino official, na charged to the ICC. Pero sa tingin niyo po ba, in the international community, malaking o significant case din po ba ito?
Opo. I think this is making waves sa international community. Marami ang talagang nagpa-follow and talagang nagmo-monitor ng case na to. May mga friends ako na talagang who are asking me ano ba talagang updates and they're asking me for context, background and everything. They want to understand yung Philippine situation, yung context lang. Yung mga hindi nila nakikita sa media, hindi nila nakikita sa presentation of evidence, sometimes they wanted to know the background and the context of this situation. And then normally when you go abroad and then nila, when you are a Filipino, either ma-identify nila is Manny Pacquiao, Alexandra Ayala, or now it's the former President Duterte naman. So sabi na, okay, you're a lawyer now, your president is on trial. Ganun. So, you know, so parang naging ano to, parang ano, this will have a big impact on the on international law and especially na talagang ano to, no? So, and of course, yung mga previous na mga context nito, normally mga political crimes, may mga genocide, may mga war crimes, may mga pinag-away ng mga religious na mga conflicts and everything. But in this particular case, special to unique to walang religious aspect dito, hindi to parang walang war or parang armed conflict na nangyari dito. This is not a war between government troops and an armed group or mga rebel groups na in the process may mga crimes against humanity or mga war crimes na nakomit. So this was committed supposedly during peacetime and pursuant to an allegedly supposedly parang valid operation against drugs. But then eventually it resulted to a lot of killings, and then that's what we have to determine right now, no? So kung has that been can we say now that that policy parang it was actually a policy of killing rather than a law enforcement and eradication of the drug problem. So was it eradication of the drug problem or eradication of drug addicts? So yun yung magiging issue doon.
So kumbaga din, ano man ang maging kahinatnan ng kaso ito yung magiging isa sa mga halimbawa na pag-uusapan sa mga legal classes.
Actually, out of the sheer novelty of the case, attorney, ano? I mean, Dean, ano? Kasi tulad nga na nabanggitin nyo sa kanina, yung mga law students, this is an actual track that you can take in your legal career dahil it can actually happen na ang isang world leader ay litisi o i-charge sa International Criminal Court.
Dean, I'm curious as to your opinion. No? Pagdating po sa paglilitis na ganitong kalibre na isang mataas na opisyal, gaano kalakas sa tingin nyo or gaano kalaki ang kahalagahan ng political will? I mean,
political will from which angle po? Political will from whom?
On the part of yung kasalukuyang administrasyon. Kasi syempre may mga iba namang kaso against world leaders like Russian President Putin, Israeli Prime Minister Benjamin Netanyahu. Pero hindi naman po sila maaresto. In this case, di ba? And which is actually what the supporters of former President Duterte have been saying. Nagkaroon kasi ng pagkakataon na ma-serve yung warrant of arrest dahil sa administrasyon.
Well, technically po, no? So, of course, kung nangyari ito, let's say, for example, kung lumabas yung warrant at the time that the former president was still the sitting president, of course, hindi mangyayari ito, just like what happened insofar as other, national leaders are concerned who are facing criminal prosecution. And in fact, may mga warrant na before issued by the International Criminal Court, but they cannot be brought to the International Criminal Court because the warrants cannot be implemented against them. Like for example, kung sitting president ka or naging effective din yung mga withdrawal nila or they're not actually part of the International Criminal Court. So yung walang system whereby to implement the warrants of arrest against them.
More on that point, Dean, for politics to be used as a defense, na sinasabi po ng depensa, like pointed out by Attorney Kaufman yesterday, na ito ho'y nangyari because of politics dahil inalaw o pinayagan ni Pangulo Marcos na mangyari ito. Dean, nakamute po yata. Dean Sarmiento, sir? Dean Sarmiento, nawalan po kayo ng audio.
Alright.
Dean Sarmiento. At balikan po natin si Dean Sarmiento na kanina naputol yung audio niya. Dean, are you there?
Opo.
Ayan.
Nandito po.
Dean, naputol tayo kanina doon sa tanong. Defense, yung politics as a defense. Tulad po ng na napanood natin na report kagabi, yun yung pinupunto ni Attorney Kaufman eh.
Yung portion po ng speech na yon, no, I think technically it has no bearing on the case itself, no, kasi the parang ano yun that is with respect to the jurisdiction over the person of the former president because it talks about parang betrayal of the previous na mga statements and assurances of President Bongbong Marcos na he will not surrender the former president to The Hague in case na magkawarrant siya, no. So pero technically that's only with respect to the jurisdiction over the person of the accused, in this case the former President Duterte, pero technically walang bearing yon sa presentation of evidence for purposes of confirmation of charges.
Pero hindi ho ba, tulad na nabanggitin nyo, dead-end argument na itong jurisdiction?
Well, technically, pwede pa nilang, pwede nilang actually erase, no, yung question of jurisdiction for whatever it is, no, just to parang magbigay lang ng context about it, but technically it has already been decided. Kasi normally yung ginagawa ng procedure before mga international criminal courts is first decide muna kung may jurisdiction talaga and whether the case is admissible. So that is the first hurdle of the prosecution. Kasi it's useless to go on trial if eventually wala naman palang jurisdiction yung court. So normally the court may principle po tayo sa international law na tinatawag na competence. It is the parang the court has the authority to determine its own competence and jurisdiction. So normally that's the first thing that they would do. First determine kung may jurisdiction sila so that efforts will not come to waste kung magkakatrial and then eventually pala walang jurisdiction.
Prosecutor, please please continue with your presentation.
President, Your Honours. My name is Robin Croft and I will address two topics today. First, I will present on the contextual elements of crimes against humanity. And second, I will set out some of the prosecution's evidence on Mr. Duterte's individual criminal responsibility for the crimes alleged in this case. Turning first then to the contextual elements. Your Honours, the contextual elements of crimes against humanity are established in this case because, first, there was an attack against the civilian population in the Philippines. The attack targeted civilians alleged to be involved in drug-related crimes and other forms of criminality. The Rome Statute crimes alleged in this case formed part of that attack. Second, the attack was widespread and systematic. And third, the attack was carried out pursuant to or in furtherance of a state or organisational policy. This policy was to neutralise alleged criminals in the Philippines through violent crimes, including murder. The evidence establishing the contextual elements are set out in paragraphs 71 to 86 of our pre-confirmation brief. In relation to the requirement of an attack, our case is that from at least the 1st of November 2011 to the 16th of March 2019, the Davao Death Squad, or DDS, and/or the National Network carried out an attack which targeted civilians alleged to be criminals. Your Honours have heard from my colleagues how from 2011 until 2016, the attack was concentrated in Davao City. Then, in 2016, when Mr. Duterte became president, he and his co-perpetrators expanded the attack nationwide. They used the national network to do this, which, as Mr. Jeremy has explained, was comprised of state actors, such as law enforcement personnel, as well as non-police assets and hitmen. Your Honours, the locations of the murders contained in counts 1 to 3 of our document containing the charges are indicated on the map on your screens. They include 76 murders, which themselves satisfy the threshold of multiple acts making up a course of conduct. However, as Mr. Nichols has noted, the crimes in count 1 to 3 are representative and emblematic of a larger killing campaign. And the prosecution relies on a range of evidence to establish that the attack was made up of thousands of killings and other violent crimes under Article 7.1. This evidence includes datasets and the statements of documentation actors, the evidence of insider witnesses, expert analysis, and the admissions of Philippine state agencies in their public reporting. I will take your honours through some of this evidence now. During Mr. Duterte's mayoral period, hundreds of civilians alleged to be criminals were killed in Davao City. On your screens is a chart with data on extrajudicial killings in Davao based on public reporting. The data is recorded at tab 116. It shows that between 2012 and 2015, there are at least 274 extrajudicial killings in Davao City. This data is corroborated by DDS insider witnesses. Several DDS witnesses say that they each killed hundreds of alleged criminals while with the DDS. Your Honours can see on this slide quotes from one DDS witness. They estimate that, I quote, between 1,500 and 2,000 people, end quote, are buried at Laud Quarry. The quarry was only one of several places that the DDS dumped bodies in and around Davao. That's at tab 37. This witness said that they personally killed hundreds of people. They described their job as the DDS as being, quote, just to kill small criminals, petty criminals. Out of the almost 300 people that I have killed, I never actually got to kill a drug lord, end quote. That's at tab 34. This witness's words make it clear that the target of the attack was people alleged to be criminals in Davao. Your Honours, another DDS witness who also killed hundreds of people said that the DDS targeted, I quote, suspected criminals in Davao City, including shabu users and pushers, end quote. That's at tab 58. Your Honours, as you have heard previously, Mr Duterte has himself publicly admitted that he killed around 1,700 people while he was mayor of Davao City. I quote, they say I killed 700, they undercounted, around 1,700, end quote. That's at tabs 10, 10.1, 10.2. This evidence, the data collected by independent organisations, the statements of insiders on the hundreds of people that they have each killed, and Mr Duterte's own admission of having killed 1,700 people while mayor of Davao, all show that the attack was widespread in the mayoral period. And the attack continued to be widespread after Mr Duterte became president, when it expanded across the country. The victimisation expanded, with the hundreds killed during the mayoral period becoming thousands in the presidential period. Your Honours can see a map of the Philippines on the slide. The colours which will emerge show the locations and density of the killings in the anti-illegal drug campaign. Purple dots indicate an area with 1 to 10 killings, while yellow indicates 500 killings. This is how the killings progressed throughout the presidential period. Your Honours, this map is based on data collected by an independent organisation which recorded at least 5,823 anti-drug killings during the presidential period. This data is recorded at tab 104. The data shows that the attack during the presidential period was widespread. As Your Honours can see from the map, it occurred across the country. It occurred over multiple years, and thousands of civilians were killed. Mr Duterte's administration effectively admitted to the large volume of the attack. They admitted that thousands of individuals were killed in anti-drug operations while Mr Duterte was president. For example, in the Duterte administration's 2017 year-end report, which you can see on your screens, the administration admitted that 3,967 drug personalities died in anti-drug operations in the first year and a half of Mr Duterte's presidency. That's at tab 106. Similarly, the Philippine Drug Enforcement Agency, or PDEA, admitted that 5,281 drug personalities died in anti-drug operations in the first 2.5 years of Mr Duterte's presidency. This is at tab 98. These admissions corroborate the widespread nature of the attack. They show that thousands of individuals were killed. Your Honours, in addition to being widespread, the attack was also systematic. from its origins and throughout the charge period. The features of DDS operations demonstrate this systematicity during the mayoral period, and these features can be found in our brief at paragraphs 35 to 36 and 88 to 98. Insider witnesses described how time and time again killing operations followed the system set out on the screen. The same hierarchical structure was followed. As Mr. Nichols explained, the orders flowed from Mr. Duterte at the top, through a combination of other co-perpetrators, to the handler of the relevant DDS team, and finally to the physical perpetrators at the bottom. The DDS teams composed of police and non-police assets and hitmen who carried out the killings. The features of the killings were also often markedly similar. The identity or whereabouts of the victim was provided to the DDS by an informant. The perpetrators would frequently arrive to or flee the crime scene by motorcycle. They shot or stabbed their victims at close range. The victims were targeted on the basis that they were alleged to be drug users, pushers, or other criminals. And the DDS received a sum of reward money for each kill. When the attack expanded during the presidential period, it continued to be systematic because it remained highly organised, planned, and coordinated. Similar systems to the one I've just described in Davao were deployed during Mr. Duterte's presidency to implement the killings. Your Honours can see some of those features listed on your screens. As in Davao, victims were targeted on the basis that they were alleged to be drug users, pushers, or other criminals. The process for killing the targets was often markedly similar. First, the victims were identified by state actors as targets and listed. As Mr. Jeremy has outlined, high-value targets were often listed on the PRRD list. The targets of barangay clearance operations were often listed on local drug lists, such as local police station lists. Second, targets were killed in the context of so-called law enforcement operations. Police often tried to legitimise the operations, so they would stage a nan-laban or fight-back scenario to make them appear to have been in self-defence. They would also plant evidence, such as drugs and guns, on the victims' bodies. And third, as in Davao, police and those working with them were often paid reward money per kill. Your Honours, these killings were not random or coincidental. Quite the opposite. Targets were pre-identified, listed, and then subject to operations based on that list. This clearly demonstrates the systematicity of the attack. Your Honours, the last point I would like to make about the attack relates to the evidence of an expert witness who specialises in political violence in the Philippines. This expert analysed data relating to armed encounters between the PMP and supposedly armed suspects. He compared data from before Mr. Duterte's presidency to during. And based on this comparison, he found that in the first 25 months of Mr. Duterte's presidency, the number of suspects killed by police increased by 590% across the Philippines. And that finding is at tab 68. Your Honours have heard Mr. Jeremy speak about Bulacan, a province immediately north of Metro Manila, where Mr. Duterte praised the killing of 32 civilians in police operations in 24 hours. The expert witness found that in Bulacan, police killings rose by 1,600% when Mr. Duterte became president, and that's at tab 121. The expert also compared data on Bulacan Police's use of deadly force to other countries and cities across the world. He used the metric of police killings per 100,000 population. The chart on your screens shows this comparison, which is at tab 121 again. The data on Bulacan is orange, while other countries and cities are blue. The orange bar on the left shows police use of deadly force in Bulacan before Mr. Duterte became president. You can see that with a fatality rate of over 1, it was already comparatively high. The orange bar on the right shows the dramatic increase in killings in Bulacan by police after Mr. Duterte became president. The expert concluded that, quote, "The only plausible explanation for such an extreme ratio is a widespread policy of extrajudicial executions." End quote. That's also tab 121. Your Honours, this leads us to the policy requirement for crimes against humanity in Article 7. Your Honours, the attack in this case was carried out pursuant to a policy to neutralise alleged criminals through violent crimes, including murder. The policy was also known as the Davao Formula or model. Your Honours have heard about the origins of the policy in Davao City and how it was implemented by the local executive government. Mr. Nichols explained how Mr. Duterte, when Mayor of Davao City, established the Davao Death Squad to carry out the policy and kill criminals. The evidence establishing the state or organisational policy in this case is set out at paragraphs 77 to 84 of our brief. As the policy and the common plan were both to neutralise alleged criminals via violent crimes, there is some overlap between the evidence on each. I will set out some of that evidence now while discussing the policy, and then some later while discussing the common plan. The evidence includes Mr. Duterte's many public statements and speeches outlining the policy. It also includes the Command Memorandum Circular, which Mr. Jeremy mentioned earlier, witness accounts, speeches and statements by other co-perpetrators, the high level of coordination between state actors. Sorry, Your Honours. I will start with Mr. Duterte's own speeches. Your Honours, Mr. Duterte made no secret of the policy, as is shown by the references in our brief to his many speeches outlining the policy. He made these speeches as Mayor of Davao, as a presidential candidate, and then as President of the Philippines. One example of a speech that Mr. Duterte made as Mayor was at a meeting on peace and order in Davao in October 2015. That is tab 13. Thank you.
8 hours yung mga nagdi-distribute ng droga sa Boulevard. Giving you 48 hours. Pag nakita ko kayo, papatayin ko kayo dito.
These are Mr. Duterte's own words. I quote, "I will kill you. That's the only formula that worked in my city." End quote. That is tab 133.
Prangka-prangkahan talaga. I will kill you. Kayong na mayor ako ngayon, presidente, yun din ang, that's the only formula that worked in my city.
Your Honours will recall that yesterday, Mr. Nichols played a series of Mr. Duterte's presidential campaign speeches. I want to take a moment to reflect on some of the key features of those speeches, which are at tabs 8, 12 and 14. First, Mr. Duterte frequently said that if elected as president, he would stop drugs and crime in the Philippines in 3 to 6 months. He frequently referenced his experience in Davao, where he admitted that he had killed criminals. He said that if elected, he would order the military and police to do the same nationwide. And he expressly stated that this would entail killing. Your Honours, Mr. Duterte's speeches make it clear that there was a policy to neutralise alleged criminals by violent means, including murder. And Mr. Duterte was not the only member of the Common Plan who disseminated the policy through public speeches and statements. In this video at tab 9, co-perpetrator Mr. De La Rosa addresses a crowd of self-confessed drug addicts in Bacolod City and urges them to kill drug lords and burn their houses.
But on Thursday, National Police Chief Ronald De La Rosa's rhetorics were far from toned down, as he told hundreds of self-confessed drug users and pushers in Bacolod City to kill drug lords.
Mr. De La Rosa made this speech on the 25th of August 2016. At the time, he was the chief of the Philippine National Police. Your Honours, the existence of the policy is also shown by the police directive which Mr. Jeremy spoke about earlier, Command Memorandum Circular number 16 of 2016. This is at tab 112. As Your Honours have heard, the day after Mr. Duterte became president, he appointed his longtime friend and colleague from Davao, his co-perpetrator, Mr. Ronald De La Rosa, as chief of the Philippine National Police. On the same day, Mr. De La Rosa formalised the anti-drugs component of the policy by issuing this directive to the 180,000 police officers under his command. The circular directed police to pursue the neutralisation of illegal drug personalities. As Mr. Jeremy has outlined, the evidence shows that within law enforcement, neutralise meant and was understood as meaning to kill. Your Honours, the Command Memorandum Circular shows there was a policy to neutralise through violent crimes such as murder. I will now turn to part 2 of my presentation on Mr. Duterte's individual criminal responsibility. The prosecution's evidence on this is set out at paragraphs 5 to 70 of our brief. The prosecution alleges that Mr. Duterte indirectly co-perpetrated the crimes, ordered and/or induced the crimes, and/or aided and abetted the crimes. Today, in the interest of time, I will focus on indirect co-perpetration, and we rely on our brief for the other modes of liability. Your Honours, Mr. Duterte is an indirect co-perpetrator of the alleged crimes because, first, he agreed to a common plan to neutralise alleged criminals. Second, he and his fellow co-perpetrators jointly controlled a structure of power, namely the Davao Death Squad and the National Network, which they used to pursue the common plan. Third, Mr. Duterte made an essential contribution to the crimes within the framework of the common plan. And fourth, he did this with the requisite intent. Your Honours can see on your screens an excerpt from paragraph 4 of our document containing the charges. This sets out the scope of the common plan The plan was to neutralize alleged criminals in the Philippines, including those perceived or alleged to be associated with drug use, sale, or production through violent crimes, including murder. As Mr. Nichols has explained, Mr. Duterte and his co-perpetrators agreed to this plan in Davao City. Photos of the co-perpetrators in Davao City are displayed on your screens. They're a combination of trusted police officers, an individual from Mr. Duterte's mayoral office, an officer from the National Bureau of Investigation in Davao Region, and a lawyer who acted on behalf of certain members of the Davao Death Squad. In 2016, when Mr. Duterte became president, the members of the Common Plan remained largely the same. They were joined by a further two individuals, a senior police officer and a long-time colleague of the group from Davao City, who had worked with the DDS before the jurisdictional period. I will take your honours through some of the evidence which shows both the scope of the Common Plan and the co-perpetrators' agreement to it. In the interest of time, I will address some co-perpetrators and we rely on our brief for the rest. That's at paragraphs 9 to 23 of our brief. On your screens is a photograph of Mr. Ronald De La Rosa. When Mr. De La Rosa was Davao City Police Chief, he developed Tokhang operations. As your honours have heard from Mr. Jeremy, Tokhang was a blueprint for police to implement killings later in the presidential period. When he was announced as Mr. Duterte's chosen PMP chief in May 2016, Mr. De La Rosa gave this interview, which is at tab 101. It shows that he wholeheartedly agreed to the Common Plan.
Patayan sa drugs. Patayan talaga ito sa drugs. Kaya kayong mga drug lord dyan, humanda na kayo at talagang sasagasaan ko kayo.
On this slide is a photo of Isidro La Peña. Like Mr. De La Rosa, Mr. La Peña was well known to Mr. Duterte because he too had worked as Davao City Police Chief. In his case, from 1996 until 1998. In 2016, Mr. Duterte appointed Mr. La Peña as Director General of the Philippine Drug Enforcement Agency, or PDEA. PDEA is the lead anti-drug enforcement agency in the Philippines. 2 days after Mr. La Peña took his oath, he gave a speech to his PDEA subordinates. There is an excerpt from that speech on the slide. Quote, "Under then Mayor, we implemented strict law enforcement against illegal drug activities in Davao City. The President wants to replicate and expand what is being done in Davao. And that is precisely what I intend to do." End quote. That's tab 101. Also like Mr. De La Rosa, Vicente Danao was Davao City Police Chief during the mayoral period, in his case from 2013 to 2016. In November 2018, he was appointed Police Chief of Manila Police District, and he told reporters, quote, "If I discover anyone involved in drugs, especially those who distribute or just throw them around, son of a bitch, I will go after you, goddamn. I will kill you. Blatantly, I am saying that. Sons of bitches." End quote. That's tab 96. When Mr. Duterte became president, he appointed Vitaliano Aguirre II as Secretary of Justice. Mr. Aguirre has also publicly acknowledged the Common Plan and his agreement to it as a member of Mr. Duterte's administration.
Well, which do you want? We build first. Do we build the prison facilities first, or do we go against these people? Choose. If you're in the Philippines, we will choose to kill these drug lords.
Quote, In the Philippines, we will choose to kill these drug lords, end quote. That's tab 125. Your Honours, these speeches of co-perpetrators show both the scope of the common plan and those co-perpetrators' agreement to it. Your Honours, the next element of indirect co-perpetration is control of a structure of power. In the mayoral period, Mr Duterte and his co-perpetrators controlled the DDS, which they used to pursue the common plan. There is a diagram of the DDS hierarchy on your screens. As the mayor of Davao City, Mr Duterte sat at the apex of the formal and city structures. The law gave him formal operational, supervision and control over the police in Davao City. In addition to this de jure power, insider witnesses spoke about his de facto power over police and the DDS structure. Under Mr Duterte were a combination of co-perpetrators from the Davao City Police Office and the Mayor's Office. Together with Mr Duterte, they controlled the DDS teams beneath them. They controlled the will of the DDS perpetrators through a range of mechanisms. And these are set out in paragraph 38 of our brief and include threats to kill and actual killing. To illustrate this control, there are quotes from one witness on your screen. This witness said that when he was first told to kill, he did not want to. But, I quote, "I felt like I didn't have any other choice but to follow their orders. Duterte is the most powerful person in Davao City, and you had to do what he wanted. It wasn't possible not to not obey his command." End quote. This is tab 51. When Mr Duterte became president, the co-perpetrators continued to control a structure of power. One of the first things that Mr Duterte did with his new presidential powers was to appoint his co-perpetrators from Davao to national positions in government and law enforcement, which were key to the common plan. And after he appointed Mr De La Rosa as chief of the PMP, Mr De La Rosa used his new powers to move other police co-perpetrators into key policing roles. These new appointments expanded the geographic powers of the co-perpetrators and allowed them to create a larger network of individuals they controlled. Your Honours can see that structure of power on the chart on your screens. The co-perpetrators controlled the executive, they controlled the police, they controlled the Drug Enforcement Agency, the National Bureau of Investigation, and the Department of Justice. And they used this control to ensure that their subordinates carried out the plan to neutralise alleged criminals through violent crimes. For example, as PMP chief, Mr De La Rosa now controlled some 180,000 police officers, who, as you have heard, he directed to neutralise drug personalities. Mr. La Peña now controlled 1,800 Philippine drug enforcement personnel. They used these subordinates as physical perpetrators to commit the crimes. Mr. Aguirre, as Secretary of Justice, now had control of the National Prosecution Service. He used this control to ensure that, except for a handful of low-level perpetrators in notorious cases, the crimes were not prosecuted, and a climate of impunity prevailed. And the co-perpetrators controlled the will of the physical perpetrators. As in Davao City, low-level members of the national network risked losing their jobs or being killed if they did not comply. For example, Your Honours can see the evidence of a police insider on your screens. He said that if his boss did not kill enough people during police operations, he would lose his post and be replaced. I quote, "We were told that there should be 5 to 10 deaths per month. The regional director called him and told him that if there were no deaths or no recorded killings, then he would be relieved of his duty." End quote. That's tab 124. Now on your screens is the evidence of an individual who police suspected of involvement in drugs. He surrendered to police to avoid being killed. The police held his status as an alleged drug pusher against him and recruited him as an asset. They made him kill other civilians who were alleged to be involved with drugs. He said, quote, "I surrendered myself to them. I knew that they wanted to kill me, so I became an asset of theirs." End quote. That's at tab 22. Your Honours, I will now turn to the requirement of an essential contribution. Mr Duterte made an essential contribution to the crimes within the framework of the Common Plan. And the prosecution has set out 10 of Mr Duterte's contributions in our brief at paragraphs 44 to 58. Many of these have been discussed in the prosecution's presentations. For example, Mr Nichols spoke about how Mr Duterte designed and disseminated the policy in this case, which is point A on the slide. He also spoke about point B, how Mr Duterte established and oversaw the DDS. I have just addressed point E, on the appointment of key personnel to positions which were crucial to the execution of the crimes. Mr Jeremy has spoken about point J, how Mr Duterte publicly named so-called high-value targets who were then killed. And all members of the prosecution have touched upon point H, Mr Duterte's public statements authorising, condoning and encouraging killing. Your Honours, without Mr Duterte's essential contribution, the crimes in this case would not have been committed, or they would have been committed in a significantly different way. We can see this in the evidence of low-level members of the Davao Death Squad and the National Network, who said that Mr Duterte's conduct had a causal effect on their perpetration of the crimes. You can see on the screens, one low-level perpetrator during the mayoral period said, I quote, "I was confident to continue killing people because anyway, we wouldn't be arrested for that." End quote. That's tab 38. A low-level police perpetrator during the presidential period was asked about the impact Mr Duterte's public speeches had on his team, including when deciding to kill someone. He responded, quote, "It did have an effect on me because it's like I was saying to myself, well, even the president, he himself is ready to do something like this, and who am I?" End quote. That's tab 142. A senior police officer during the presidential period was asked why his police unit started killing in July 2016. He responded, I quote, "Because of the directive of the president." End quote. That's tab 120. Your Honours, from everything you have heard over the past 2 days, there can be no doubt about Mr Duterte's knowledge and intent. Mr Duterte meant to engage in the conduct that has been charged in this case. He intended that the crimes would be committed, and he was aware that they would be committed as a result of implementing the Common Plan. Mr Duterte knew about the fundamental features of the Davao Death Squad and the National Network that enabled the co-perpetrators to control the physical perpetrators. And he was aware of the factual circumstances that enabled the co-perpetrators to control the crimes. Mr. Duterte knew because he himself established the DDS to kill people. He repeatedly broadcast his intention to implement the common plan nationally if elected president. He made it clear that this would involve killing. Once he was president, he moved his trusted co-perpetrators from Davao into key national positions. And as the number of killings rose, Mr. Duterte persisted with the common plan. He praised the 32 killings in a one-time big-time operation in Bulacan. He publicly named so-called high-value targets. He promised to protect police. And as Your Honours have heard, Mr. Duterte has admitted to many of these things. Your Honours, I will conclude my presentation by recalling 2 items. The first is Mr. Duterte's presidential campaign promise that he would stop drugs and crime in the Philippines within 3 to 6 months. And the second is the spread of killings during the first 6 months of Mr. Duterte's presidency.
I promise you, hindi naman believe yung ibang tao. Sabi ko, I would stop drugs and crime, criminality in 3 to 6 months.
That concludes the prosecution's submissions on the merits. Thank you, Your Honours.
Josh Motach. Thank you very much.
Papawalang sala ang ma-disprove ang mga alegasyon laban sa dating Pangulo. Balikan natin si Dean. Ma'am, may tanong ka kanina. In fact, yan din ang tanong ko eh. Dean, magandang gabi ulit sa inyo. Yung karaniwang sagot ng depensa, in fact, we have been hearing this from the presidential spokespersons during the time of the former president. Yan ang lagi nilang yan ang lagi nilang linya na alam niyo naman yung presidente, palabiro yan. He didn't mean what he said.
Parang nami-misunderstand
Correct.
lang. Binibigyan ng kulay yung sinasabi niya.
Will that hold? Ay, sorry. Dean, naka-mute po yata kayo?
Ay, sorry po.
Go ahead.
Po talaga sa nature ng mga statements, no? Yung statements po dito, technically, hindi po conclusive. May probative value po for purposes of establishing yung intent and knowledge, no? So, yung ginagawa ng prosecution dito is to accumulate the evidence. So, if they can establish na may cumulative na mga statements na ganito, yun yung parang strategy nila to establish the existence of a plan or policy for purposes of conducting this parang crime against humanity of murder. Kasi kung it's not conducted as a matter of plan or policy, if they cannot able to establish that, so yung mangyari noon, parang isolated lang yung mga killings na to, parang walang relation yung nangyari sa Davao, walang relation yung nangyari sa Bulacan and everything. So parang sasabihin nila, isolated lang mga incidents na to, na talagang walang core policy or mga ganun. But of course, so depende rin yun sa no? So they were able to initially present the memorandum with respect sa yung operation Tokang and everything, no? So at the beginning of the presidency. So I think that's one important evidence. So I'm titingnan natin mamaya kung how will the defense respond to that particular memorandum na na-present nila. Because that's one important link in establishing yung policy consideration na these were not isolated, na talagang ginagawa ito as a matter of state policy during the presidency, from the mayoralty, and then during the presidency. So yun yung on the part of the prosecution. So titingnan natin, no? So this is getting exciting. Titingnan natin kung ano mangyari dito.
So, Dean, yan, yung binabanggit po ninyo, sabi nyo kanina, hindi pwede yung based lang sa inference. Certain words were uttered, and then certain events followed. Pero hindi pa natin ma-establish directly yung linkage ng mga events na yan. So, kung hindi ho sapat yung inference lang, ano ho yung sasapat? Ano ho yung dapat ipresenta ng prosecution?
Well, number one, they will have to establish na kada statement na binanggit ni former President Duterte, dapat may contemporaneous link yon sa isang killing or isang operation. And
Kasi
then,
kung ginagawa
so,
nila,
parang,
no? Parang ganun yung nagiging direksyon.
Dun sa
Tama?
mga
Yeah, yun yung
HVP
parang I
particularly,
think strategy na ginagawa ng prosecution na yun. And then they will have to establish it was directed at certain state actors. So para ma-consider siya na parang order. Or at least kung hindi siya talagang direct na order, at least it's an parang encouragement or parang gano'n na gawin nyo to. So they will have to establish and they need to convince the court na those statements convinced the actors, the alleged perpetrators to commit the killings. Kasi ultimately, ang tingin ko dito, the defense will not actually question the fact na may mga killings na nangyari.
Yes.
So what they will be establishing here is, okay, may killings na nangyari, but you cannot attribute these killings to the former President Duterte. So yun yung magiging core strategy of the defense in this particular case.
Din, ano po sa tingin niyo yung pinaka may impact dun sa lahat ng iprenesenta ng prosecution kanina?
I think yung mga direct statements na, for example, yung sinasabi na papatayin kita, papatayin ko kayo, mga direct na mga statements. Although, of course, parang rhetoric yun. They were very strong statements. So, yun yung ano doon. So, kahit na sinabi mo yun, but still, we need the nexus. We need the link to parang ano. So, kung walang link yun, so still, magiging parang rhetoric lang yon. So at most, it can establish intent. Parang kung cumulative na talagang there's an accumulation of mga rhetorics na ganito. So parang the court may be convinced na okay, talagang may intent kasi talagang sinasabi niya paulit-ulit ang ganito, no, di ba? So pero ultimately, okay, so now may intent and then may killings na nangyari. So what the prosecution needs to establish now is the link. Yung mga statements ba na yun ang talagang nag-cause or may direct relation ba sila to the killings? So, did they killings or in parang conversely, can we say na the killing attributable or were caused by the statements? So, yung link dito, yung very important factor. So if the prosecution cannot establish that particular link or cannot convince the court na talagang may link dito, this is not only mere inference, na talagang link na to, so yun yung talagang magiging away dito.
Din, kanina po meron din sinasabi dun sa mga video clip na ipinalabas ni dating Pangulong Duterte na sasagutin ko lahat kapag merong pumatay, merong nangyari, sagot ko kayo. Kumbaga, pwede ho ba yun na, sasapat po ba yun na explanation na okay, hindi ako ang gumawa nito, merong mga policeman o kung sino man na gumawa nitong mga operation na ito.
But it was upon my orders
Oo,
that these were carried
sinabi
out.
ko ito at sinabi ko na ako ang bahala sa inyo. Kumbaga, I take on all the responsibility.
Okay, so yun naman, yung point naman yun, so they're trying to establish na parang he contributed, he enabled, he encouraged the commission of the crimes through his words. So ganun pa rin yung ano doon. So ultimately, yung question doon, okay, so ano yung direct causal connection nun, ng mga words na yon, yung encouragement niya, yung ba talaga ang nag-encourage sa mga police, to commit these particular killings. So the prosecution will have to establish that.
So, Din, ang babanggit nyo, dito ho, for purposes of confirmation of charges, hindi naman tayo guilt beyond reasonable doubt. Kumbaga, reasonable expectation lang na posibleng nga may nangyaring krimen at posibleng dapat itong magpatuloy sa trial. So far, with what you've heard, how is the prosecution faring towards this end?
Well, based sa pattern ng mga previous prosecutions before the International Criminal Court, this particular direction, more likely kasi, basta wala din solid evidence na, kasi dito is parang substantial evidence eh.
Yes,
So parang substantial ground to believe eh. So hindi pa naman na talagang dapat na ma-convince tayo na talagang responsible siya. So parang may possibility ba na responsible siya? Do we have, is an ordinary person, in the mind of an ordinary person, may substantial ground but to believe that these crimes may have been committed and that the former president, is responsible for or may have contributed to the commission of these crimes? So if the court is they will bring this to trial. Yun yung normal course of action. And then dun na lang sa trial yung actual na na war of evidence, with the presentation of all the witnesses and
Pero din yung diskarte ng prosecution at this point. Kasi uh, we know that at this point pwede na sila magpresenta ng mga testigo. Pero hindi pa nila ginagawa.
Normally po, hindi po nangyayari yun sa
Hindi sila nagpe-present ng witnesses talaga.
confirmation hearing. Opo. Yung procedure po natin dito, normally sa confirmation of charges hearing, what they present is just parang yung core theory ng kanilang case. And then they will be presenting yung kanilang summary evidence. And then, minsan may mga prior recorded testimony na nakuha nila. But yung actual presentation of the witnesses, normally nangyayari po yun sa actual na trial.
Sa mismong trial.
If this goes to trial, then dun na po yung mga presentation ng mga witnesses. But in this particular case po, yung sinasabi dito, hindi po ito question of the evidence, question of sufficiency. So parang ina-assume natin na assuming na totoo lahat yung mga evidence na presented by the prosecution, so would this be enough to bring him to trial? Parang ganun. But of course, if the defense can also attack the credibility or reliability of the evidence. Pero kung, like for example, in this particular case, these are publicly available na mga videos and everything. So I don't think they will be questioning yung credibility kung totoo ba tong video na to. So I don't think there will be questions of that nature, or there will be a challenge to the evidence of that nature. So paano mangyayari dito? Okay, assuming na ganito yung evidence, totoo lahat yung present ng prosecution na evidence, would this be enough for us to be convinced na may substantial ground to believe that the crimes were committed and that the former president is responsible for these crimes, or this can be attributed to him?
Din yung pagtatapos po nung presentasyon ng prosecution kanina, yung parang appeal to the emotion siya, di ba? Na binanggit po si Kian de los Santos at yung iba pang mga bata at menor de edad na napatay during the duration po ng war on drugs. Yung po bang mga ganito, may bigat ba ito sa pagdedesisyon ng ICC judges? Or talagang ang emosyon, isasantabi muna natin, talagang hard facts lang po ang titingnan?
Well, normally, yung qualification po and competence ng mga ICC judges, of course, mga ano po to, mga high profile na mga practitioners, yung iba po mga judges din po ng mga high-level courts sa kanilang mga respective countries. And normally, they are known for their skill in determining, in determining evidence, in parang removing the emotion from the hard facts and the hard evidence. So, tao lang naman yan. Of course, it may have some impact. And but based on judicial parang ethics nila and everything, and pursuant to the rules of procedure, normally it is expected that they will on hard facts and the evidence presented by.
Okay. Din, natapos na po yung si Mr. Edward Jeremy, isa sa mga prosecutor. I think may in-expect pa tayong isa from the prosecution. Tama ho ba?
Yeah, I
so
think
what can we
yung count
expect from
one,
that
yung
presentation?
i-present nila, the next prosecutor who will be speaking, will be talking about the count one. Yung count one, yung incidents while the former president was a mayor of Davao.
Or wait, parang yun yata yung kahapon din, no? I think count 3, if I'm not mistaken, ito na po yata yung
To
ipipresent.
and
But
three, oo.
are we expecting more of the same? Sa tingin po ninyo, ganun pa rin
I think yung pattern
given the direction?
will be the same. I think the pattern will be the same it will continue na ganito. So cumulative evidence yung ipipresent nila to establish intent, to establish yung
Attribution.
widespread and systematic attack. They will have to establish yung policy. Very important kasi yung policy.
Yes.
Yep.
Yung nakikita natin so far, Mav, wala tayong nakikitang fireworks. So, walang sagutan. Ganun ho talaga ang in-expect natin dito, Din? Parang, parang take turns lang.
Wala pa pong cross-examination dito na mangyayari.
Yeah.
But there, in some exceptional cases, may possibility na magtanong po yung mga judges. But normally, based on mga previous na mga proceedings nila, medyo rare po na nangyayari yun. Normally po, kung may mga clarificatory sila na mga questions lang or parang matters of mga procedure and everything. But normally, wala po mga masyadong mga tanong.
Din, mamaya, inaasahan din po natin na magsasalita yung depensa. Sa tingin po ninyo, paano naman nila sasagutin? Ito nga pong mga ibinato ng prosecution dito po sa unang pagsasalita ni Edward Jeremy.
Well, I think yung main attack of the prosecution will also be on, number one, establishing na walang intent. Number two, establishing na walang knowledge. And of course, yung question of attribution and yung question of direct link or nexus. Yun po din, I'm sure, yung magiging punteriya ni Nicholas Kaufman.
Din, kahapon lang sa day 1, ilang beses binalikan ng prosecution yung mga naging pahayag ng dating Pangulo. Again, siguro po dahil dito heavy yung prosecution, ganito ba talaga kalaki ang impact nito sa tinatakbo so far ng mga hearing? Ang sinasabi kasi ng depensa, cherry pick lang doon naman itong mga to eh. Only to support the narrative that they're trying to push.
Well, ultimately, whether they are cherry-picked or not, no? So, makikita naman po yun. Kahit na cherry-pick, technically, depende rin po yan. So, it will now be on the part of the defense to establish na may mga speeches din siya, may mga statements din siya na, for example, telling the police or telling yung mga subordinates niya to ensure respect for the law or respect for the rule of law, to protect themselves and to shoot only when necessary, only in cases of self-defense and everything. Now, yesterday they were saying na parang they were making a count, no? Kung ilan yung mga ganitong statements and ilan yung mga contrary statements talking about yung parang mga statements na he was trying to tell the policeman you have to respect the rule of law and everything, mga ganon. So ultimately, titingnan natin kung ano talaga yung number nun. And for every statement na mape-present ng defense na former President Duterte parang tried to parang ensure compliance or respect for the rule of law, in effect, sa legal advocacy, that will now be casting doubt on the strength of the evidence of the prosecution. So yun yung magiging purpose nito. Kasi parang madidilute yung strength ng prosecution evidence eh. So sasabihin nila, okay, di ba, ganito yung sinabi mo, but on the other hand, sinabi niya rin na ganito. So you have to take this holistically. Ano ba talaga yung taken as a whole, ano ba talaga yung stand ni former President Duterte? Talaga bang joke lang ba yun? Or matter of policy? Talaga bang gusto niya maging ganito and everything? Or talagang he was just talking of the consequence na pero he did not actually intend it to happen. Parang pwede mo sabihin he intended the result, but he did not actually intend the means. Parang ganon. And the prosecution will also try to establish na to his mind, the police officers were parang respecting the law. To his mind, the defense will try to establish na to his mind, the police officers were only shooting or were only using their weapons as a matter of self-defense. Kasi sabi niya, that was my instruction. Parang gano'n. So while I was telling as a matter of rhetoric na ganito, papatayin natin lahat ng mga addict and everything, but he did not intend the parang unlawful means of achieving that particular purpose or consequence. So yun yung magiging strategy naman ng defense.
Di naungkat din po yung tungkol sa mga co-perpetrators. Ano po yung bigat nun? At sa tingin niyo po ba ay kakasuhan din sila? Isa pong partikular na nabanggit dito ay si dating PNP Chief, Senator Ronald Bato de la Rosa, na siya po yung naglabas, siya yung nakapirma dun sa order ng PNP double barrel.
Normally po kasi as a matter of practice, alam niyo po in reality, yung cost of conducting this trial, the entire proceedings, medyo mahal po to. And this is being paid for by all the member states of the International Criminal Court. And yung mandate for criminal court is only to charge and only to go after the the highest ranked leaders. So normally they do not go for the lower tiered na mga personalities po.
Opo.
Kikita natin dito.
Opo, very interesting kasi mula Nobyembre, hindi na natin nakikita si Senator De La Rosa dahil nga po nagkaroon ng ugong-ugong na may warrant of arrest na laban sa kanya. So, you're saying di na sa karaniwan po ay yung pinakamataas lang talaga ang hinahabol ng ICC.
Opo. Normally po. Pero depende pa rin po 'yon. Depende po yan. For example at the level of senator, so they will look into yung alleged contribution and participation niya. So would that be parang in practical terms, yung point po kasi dito is to prevent impunity and to ensure na yung mga international crimes do not go unpunished. So yung titingnan nila dito, taking for practicality reasons yung cost of prosecution, logistics and everything, would it be practical to bring this para mga subordinates of the president, of the former President Duterte, to trial at The Hague? So if you already have the former president, so would the conduct of an entirely new and separate proceedings for the subordinates, would that still be justified by the cost, by the practicality of the reasons? So may possibility din dito na they will have to wait first for the conclusion of the case against the former President Rodrigo Duterte. Kasi po, for example, kasi di ba may possibility na either yung options po dito, yung possible outcomes after the confirmation of charges hearing is either for the court to confirm the charges or may possibility din na the court will decline to confirm the charges. So if the court declines to confirm the charges, so wala nang basehan to still go after the other kasi kung hindi mapuprove ng prosecution yung substantial ground to believe that the crimes were committed, so there's no point na to go after the subordinates or the other perpetrators.
So dun sa subordinates, Dean, kailangan po panibagong kaso ito, no? They have to start from scratch. Hindi sila pwedeng gawing co-accused dito sa kaso laban sa dating Pangulo.
Technically po hindi na kasi naka-start na po yung proceedings.
Yes.
If the sabay, it will just be one parang joint trial or proceedings. Pero kung separate sila, like the jurisdiction over the persons of the other co-perpetrators is acquired or secured by the International Criminal Court much later, so it will now require the conduct of another parang complete proceedings. So back to square one po, parang new trial talaga.
So sorry din, tutukan lang namin itong punto na to, no? Kasi parang ilang araw o ilang linggo nang pinag-uusapan itong posibilidad ng paglalabas ng warrant sa mga co-perpetrators. Since they were named. Kasi dati redacted yung mga pangalan nila. And then very recently, I think last weekend lumabas yung mga pangalan ng 8, including 2 sitting senators, De La Rosa and Go, and then former high-ranking police officials.
Dating Justice Secretary
dating mga naging cabinet, high officials din ng Duterte administration. So if they were to ask your legal advice, should they rest easy? Dahil nabanggit nga po ninyo, malabo akong pag-aksayahan ng panahon at resources ng ICC. Tama ho bang pananaw yun sa tingin ninyo?
Well, if you have to be careful, let's say for example on their part, may possibility na, as the rumors, were going around, na may warrants na against sa kanila even previously. So kung may warrants na given to them previously after the preliminary examination or preliminary investigation was conducted by the office of the prosecutor, so may possibility na may warrant na talaga. Now kung may warrant na talaga sa kanila na either it was issued just right after the issuance of the warrant against the former President Duterte, so they could no longer avoid the fact na may warrant na. So it's just a matter of executing those warrants. Now, assuming na wala pa talagang warrant, why were their names disclosed for purposes of the proceedings na parang nawala na hindi na na-redact yung pangalan nila? Because they are part of the narrative to complete the narrative of the prosecution against the former President Rodrigo Duterte. So kailangan yung participation nila because they will complete the narrative. So hindi pwede na they will not be mentioned as co-perpetrators. Right. So parang yun yung direction na that the prosecution is going to.
Just to complete the narrative but not necessarily to hold them accountable for the same crime.
Possibility. Yun yung isang possibility.
Yes.
Pero din sa kasaysayan po ba ng ICC, nangyari na ho ba na meron din silang hinabol na, ayan po, police chief o member ng gabinete o talaga pong yung state leaders lang talaga ang pinupuntirya po
Heads
nila?
of state. Oo.
Hindi naman po. May mga cases din po ng mga lower na mga officials. Pero kung mga rank and file lang po talaga, normally hindi. So normally you have to occupy a parang malaking leadership role in the government. Parang important roles po talaga. Pero like a senator, like former PNP chief or something, may mga time na they can be included as co-perpetrators. Pero at the time of the investigation, if the International Criminal Court actually intended to bring them to The Hague as co-perpetrators, dapat po nasama na sila technically sa warrant.
At saka kasi...
To complete the narrative. Pero hindi sila nasama sa original na warrant. So the original warrant only contained the name of the former president. So I don't know what was the intention or what was the strategy of the Office of the Prosecutor at that time, whether to have a separate trial for them. Pero kung nakita mo na at that time, after concluding your investigation into the drug war, and then nakita mo na yung kanilang participation, there was no point in immediately securing a warrant for them.
At saka din kung maalala natin kay dating Pangulong Duterte, secret pa nga yung arrest warrant niya. Tapos made public lang parang 2 or 3 days after. Pero ngayon, ibinulatlat na lahat ng pangalan. Kaya nga parang, kumbaga may warning na sila kung sakaling mabibigyan man sila ng arrest warrant.
Opo.
Ayan. Din, maiba lang po ako. Lagi pong nauungkat yung bilang ng mga kaso na dinala sa ICC. Pwede po ba nating ipaliwanag ulit kung bakit po mula sa libu-libong naitala na nasawi dun sa mga police operation, ganito lang po karami yung umabot sa ICC?
Well, number one yung mga documented na mga cases, yung sinasabi natin ng mga thousands and thousands. Normally, those are the records, mga estimates ng mga either mga NGO or mga human rights organization. But for purposes of prosecution, hindi mo pwedeng isama yung ganung number because that will be logistical nightmare because you will have to establish each and every of those killings if you will include them as part of the counts. So dapat mag-concentrate ka lang talaga to the actual killings na talagang pwede mong ma-prove with evidence and with... So you will have to ultimately decide ilan yung isasama ko sa count 1, count 2, and count 3 na that will still be enough to establish the crime charged. Parang gano'n. So, importante lang dito, this is not ordinary murder. So, crime against humanity of murder. And crime against humanity of murder, normally, yung normal na natin, is dapat may multitude of killings. Multiplicity of killings. So, kung sabihin natin 76, 70 plus, in some cases, pwede na yun, enough na yun, na you can establish that there has been a multiplicity of killings. So, you don't actually need to prove na 32,000 or several thousands in order to establish the crime against humanity of murder. So yun yung naging direction and decision ng prosecution. Let's just focus on a number that we can manage and a number that we can prove.
Din, para lang din maintindihan ng mga manonood natin, yung pag-redact sa mga pangalan, bakit ho may mga pangalang nire-reveal, may mga pangalang nire-redact?
Yung redacted po ng mga pangalan, those are normally the victims. And that is for the privacy and security of the victims.
But then some were revealed. Bakit po? Ano kaya yung basis for choosing which ones to reveal?
Yung ni-reveal po, yun yung mga victims na publicly known na po yun. So for example, kung sabihin mo si Kian, so that's already publicly known. So there's nothing more to hide, no? Pero yung actual na witnesses, like who will testify about this particular killing, so yun po yung nire-redact because we're talking about actual people who will be taken to The Hague or, who will be testifying either through video link or whatever, means that the International Criminal Court will use, no? So this is for yung redaction po nito, this is for their security and safety.
Okay. Din, susunod na yung submission of merits ng counsel naman po ng victims. Ano po yung aabangan naman natin sa kanila?
Yung based on the opening arguments, so binigyan na po tayo ng roadmap, no? So yung magiging major core argument nila will be to distinguish yung rhetorics and the arguments. So sasabihin nila yung mga rhetorics na to, kahit na very harsh yung language, kahit na very incendiary yung language, pero still, para mga hyperbole lang to, these are just exaggerations, they were not really meant to be taken literally. So I think yun yung talagang magiging direction nila. But I don't think they will still be questioning whether the murders or whether the killings were actually committed. No. So they will just be focusing on the language, and then they will be attacking yung question of attribution. Okay, so nangyari to, but can we really attribute it to the former President Duterte? So yun yung magiging attack nila.
Din, I think you're referring to the defense, ano? Pero ang kasunod po niyan, yung sa mga biktima naman, yung common legal representative of the victims. Kahapon po sa kanyang opening statement, si Attorney Joel Butuyan, isa ho sa mga binigyan diin niya ay yung kahalagahan that ICC acts on this. I mean, allows this to go to trial dahil it's the last boat, ika nga nila, for the voyage in search of justice. Bakit ho kaya ganun yung nagiging tema, yung tono ng abogado ng mga biktima?
Well, actually, I expected na talagang he would be going into the evidence, no? Kasi yung talagang rule ng counsel for the victims is normally to assist the prosecution, like highlighting certain evidence na talagang may impact, na talagang may relation to in establishing the charges. So normally, yung participation ng counsel parang dapat talaga din talaga evidentiary. So hindi na dapat talaga na parang rhetoric lang. Yes. Well, of course, as an appeal, you know, parang yung ginawa niya parang appeal lang to the International Criminal Court, appealing to them na talagang how important is the prosecution to them and the conviction to them, to the, you know, for the vindication of the victims and everything. So yun yung naging point niya.
At mahalaga rin po kayang patunayan.
Actually focus on the evidence.
Yeah. Mahalaga rin po kayang patunayan nila na hindi kayang litisin ang mga kasong ito sa Pilipinas. Kaya sila dumudulog sa ICC.
Well, technically po kasi yung question about jurisdiction and admissibility technically po na settled na.
Yes.
So the court has already previously decided na it has jurisdiction, and this case is admissible under the Rome Statute. So technically po wala na po yung yon. It was those issues were
dead end argument
decided.
Na yan.
Well, although of course pwede pa rin pong erase ni Nicholas Kaufman yung mga issues na yon. And in fact they were parang at some point, or I think at the beginning of his opening statements, na he alluded to the fact na walang jurisdiction yung International Criminal Court, na parang na former President Duterte was just hold to the parang mga ganun. So pero yung point dito, yung tapos na yung question about admissibility and jurisdiction.
Dean, maraming salamat po for your insights. Pansamantala, magpapasalamat ka sa inyo dahil mukhang magpapatuloy na. Ay, hindi pa.
Sige pa.
Ay, wait. Hindi pa. Naka-standby lang. Anyway, inaasahan nga po natin yan, yung susunod na, yung lawyer for the victims. We're not sure kung si Attorney Joel Butuyan pa rin ang magsasalita, pero nandun din si Attorney Gilbert Andres for the victims.
Dean, baka meron pa po kayong gustong idagdag doon po sa mga takeaways ninyo, personal na tumatak po sa inyo.
Observations, yes.
Doon po sa prosecution presentation kanina.
Well, at least sa mga law students, so message ko lang talagang tutukan nyo tong kaso na to. And this is a big opportunity, and nakita nyo na yung possibility that we now have some Filipino lawyers on the international stage, no? So this broadens yung mga opportunities for Filipino lawyers na when you go to law school, hindi lang parang yung dream should not be limited only to domestic practice of law sa inyong mga lugar lang, but as we have seen here, talagang may area of international practice that is ripe na and fresh, ripe na for Filipino lawyers na to take advantage of. So yung international law, particularly international criminal law, so it's one thing na talagang dapat nilang para maging magiging possible area of practice rin nila ultimately. And of course, for mga human rights lawyers and lawyers involved in the protection of the victims, so I salute you for that, no? So yung participation nila dito, of course, it's not easy, and so it's one thing, no? So ganito yon. So for mga new generation of law students, so watch out for this. So this broadens yung area of practice nyo. So this is something na talagang dapat tutukan nyo rin.
And after watching you tonight, marami hong gusto magpakadalubhasa niyan sa international law tulad ninyo. Babalikan po namin kayo. Dean
Sige po.
Ralph Sarmiento, thank you, sir.
Madam President, Your Honors, I am Gilbert Andres. My colleague, Ms. Masida, earlier submitted that Mr. Duterte's anti-drug campaign disproportionately affected the poor and marginalized. What were the conditions of the victims targeted by Mr. Duterte's anti-drug campaign? How poor and marginalized were his victims? The victims targeted by Mr. Duterte's anti-drug campaign were from low-income, high-density communities. In an urban setting, this meant that some victims live in an area of about 69,000 persons per square kilometer during the relevant period. A typical floor area of the house of a victim in these high-density communities was about 6 square meters. For some victims, their house was as small as the area of 2 tables in this courtroom. The victims' houses were typically made up of wood, used tarpaulin, plastic, light materials, and some broken hollow blocks. Any material that they could scavenge and utilize. As the victims lived in high-density communities, their neighbors knew them very well. The victims lived in close-knit communities. The victims' close-knit communities meant that they immediately knew if a person was an outsider to their community. And any traumatic event that happened to these victims in their close-knit communities was known and whispered throughout their community. As the victims were from low-income communities, to survive poverty, their houses were homes to multiple generations of their families to conserve their meager resources. For Filipinos, especially from low-income communities, their family is not just the nuclear family. It is not just the husband, the wife, the children. Their family extends to the grandparents, the lolo and lola, and the siblings of a spouse, the brothers and sisters. The breadwinner of the victim's family was usually the husband, the father of the children. The victims either worked as daily minimum wage earners or as wage earners below the prescribed daily minimum wage, or as part of the informal economy, such as a vendor. The victims worked if there was work available to earn for their family's survival. But most of the victims would not have completed their education, nor have the proper training to secure stable jobs as part of the formal economy. If they were fortunate to be employed as minimum daily wage earners, in the urban setting, this amounted to about 500 Philippine pesos per day, or approximately about 8 euros per day during the relevant period. But for most victims, the minimum wage was really the maximum that they can hope for. The victims only hope to earn at most about 8 euros per day. And for a family composed of the husband, the wife, and about 2 until 4 children, 8 euros per day is meager. There was also a cultural expectation for the breadwinners to help their elderly parents. The other spouse sometimes augmented this meager income by being a vendor or by taking temporary jobs. And if both parents were outside of their home, it was the extended family that took care of the children. Your Honors, the specific data may vary from victim to victim, but the victims hope that this data give the chamber a picture of their conditions under Mr. Duterte's anti-drug campaign. The already marginalized and vulnerable conditions of the victims exponentially multiplied the harm that they suffered, and they continue to suffer, which leads to our next submission. What were the grave effects and suffered harm of the victims, their families, and their communities resulting from the crimes charged against Mr. Duterte? Mr. Duterte's drug war campaign targeted the very humanity of the victims, of their families, and of their communities. In Filipino, the indirect victims expressed this in one sentence: "Inalisan kami ng dangal. We were stripped of our dignity." How so? First, Mr. Duterte publicly dehumanized the victims of his anti-drug campaign. This dehumanization of the victims was used to justify their eventual murders. On July 25, 2016, during his first State of the Nation address before the Philippine Congress, Mr. Duterte declared that, and I quote, "But human rights cannot be used as a shield or an excuse to destroy the country, your country, and my country." End of quote. What was chilling was that this portion of Mr. Duterte's speech garnered the most applause from members of the Philippine Congress and the public gallery. On August 17, 2016, during the 115th Police Service Anniversary at the Philippine National Police Headquarters, Mr. Duterte declared to the Philippine National Police that for those allegedly affected by drugs, and I quote, "And it has not only affected millions, but a lot of them are no longer viable as human beings in this planet." End of quote. On August 26, 2016, Mr. Duterte declared to a group of Filipino soldiers he visited in an army camp that, and I quote, "Crimes against humanity? In the first place, I'd like to be frank with you. Are they humans? What is your definition of a human being?" End of quote. These public speeches of Mr. Duterte served to condition the Filipino people on the excuse for the murder of the victims of his anti-drug campaign and how the murders were taken out, brazen, execution style. These public speeches of Mr. Duterte were emblematic of findings that atrocity crimes were often preceded by the process of dehumanizing the identities of others to justify the crimes. Second, the murdered victims were dehumanized by how they were murdered. During their actual murders, the targeted victims were summarily accused as drug users or pushers without the benefit of a judicial process just like the one before this chamber. The victims were then murdered inside their homes or within their own close-knit community. The victims who were murdered inside their homes were murdered in front of their family, their spouse, their children, or their parent, especially in front of their mothers. Some of the victims were forcefully separated from the physical clutches of their family members, protecting them from the direct perpetrators of Mr. Duterte's anti-drug campaign. This was what happened to the son of a victim in the early hours of a Thursday. At that time, this victim, her son, and her son's wife, who was pregnant and nearing delivery, were preparing to go to the hospital when 6 or 7 people dressed in black and who had guns suddenly entered their house. As recounted by this victim, and I quote, "My son kept repeating, 'Mama, don't leave me.' So I blocked the way. He pleaded again, saying, 'I will come with you, just don't kill me. Mama, don't leave me.' 4 officers were inside. One shouted at me, 'Get out of the way!' They pulled me down the stairs and yanked my hair. They had guns. My son pleaded again, 'Mama, don't leave me.' He was hugging, referring to his wife. They dragged me out into the street and put me on a motorcycle. Some victims begged the direct perpetrators for their lives, as witnessed by their family members. Some victims spontaneously took off their clothes to show to the direct perpetrators that they were clean. The home, which was supposed to be a shelter of security for the direct victims, became the crime scenes of their brazen murder. The targeting of the victims in their own homes is explained by the Philippine National Police Command Memorandum Circular number 16-2016, which was earlier referred to also by the prosecution. It was issued on July 1, 2016, by the then Chief of the Philippine National Police, Ronald Bato de la Rosa, appointed by Mr. Duterte. The relevant portion of CMC 16-2016 states that, and I quote, "The actual house-to-house visitations of suspected drug personalities shall be the highlight of Project Tonghang." End of quote. Project Tonghang refers to Mr. Duterte's anti-drug campaign on barangay clearance operations. Ultimately, the murdered victims were now known in their close-knit communities with the stigmatized label of natokhang and as drug users, despite the lack of any judicial declaration. Third, the murdered victims of Mr. Duterte's anti-drug campaign were further dehumanized even after their death by the false narrative of nanlaban. After the actual murder, the murdered victims were falsely portrayed as nanlaban, that they allegedly fought back against the police despite being the helpless victims. After the murder, evidence of illegal drugs and/or paltik guns were even planted on the murdered victims as part of the modus operandi of the anti-drug campaign to allegedly show that the victims purportedly fought back. Thus, the murdered victims were not only known as natokhang and as drug users, they were also now known in their close-knit communities with the false label of nanlaban, or someone who fought back. But for the surviving family members of the murdered victims, the suffered harms do not end there. The extreme trauma brought by the sudden murder of the Tokhang victims was further carried over to their surviving family members. Some of the surviving family members were even imprisoned and charged with fabricated criminal complaints while they were still grappling with the trauma of the sudden attack and the murder of their loved ones. For the victim I earlier referred to, after her son was forcefully separated from them, she and her son's pregnant wife were both arrested and detained in a police precinct. While under detention, she was told to get her son from the morgue. But they were not actually released from detention. They were actually photographed with the foils and rocks handed to them, and afterwards they were charged with fabricated complaints relating to illegal drugs, as that victim narrates. And I quote, "While in detention, I learned that the same thing had happened to all the other detainees. Their stories were the same. It took more than a year before this victim was released from imprisonment." The illegal imprisonment of surviving family members was part of the modus operandi to prevent the indirect victims from filing criminal complaints against the direct perpetrators of Mr. Duterte's anti-drug campaign. Thus, the document containing the charges in paragraph 19 refers to, and I quote, "other violent crimes under Article 7.1, end of quote. Further, as the homes of the murdered Tokhang victims were the homes of multiple generations, how the murdered victims were brutally shot at have been traumatically witnessed by their family members, by their spouse, their children, or by their parents. This extreme trauma is a daily struggle for the surviving family members as they still live every day in the scene of the crime, their homes. This extreme trauma of the surviving family members also occurs when they see or about to encounter a police officer, or worse, the direct perpetrator in their community. But the extreme trauma of the surviving victims does not end there. The surviving victims were socially stigmatized in their close-knit communities with the label, "Natokhang sila," or "May natokhang sa kanila," which loosely translated means they have a family member killed in a Tokhang operation. The surviving family members of the murdered victims were avoided and shunned in their close-knit community. The neighbors avoid the surviving family members, fearing for their own lives by reason of association with the murdered Tokhang victim. And the surviving family members usually mourn alone during the wake of their murdered loved ones. For some surviving family members who cannot endure this social isolation and continuing stigma, they eventually leave their close-knit community. The trauma and stigma are especially worse for the children of the murdered Tokhang victims. Aside from losing a parent, usually their father, who is the breadwinner, the children, as direct descendants of the murdered victims, were avoided at school or even bullied as the children of Natokhang. The children of the murdered Tokhang victims have to endure bullying, stigma, trauma, depression, and some even develop symptoms such as epilepsy. And because the murdered Tokhang victims were usually the breadwinners of their families, their death meant that their surviving family members were pushed toward further poverty. The surviving family members experienced extreme socio-economic dislocation with the murder of their breadwinner. Thus, Mr. Duterte's anti-drug campaign, aside from murdering victims from low-income communities, also brought about the breakdown of the families of the murdered victims. Mr. Duterte's anti-drug campaign destroyed the trust in the close-knit communities of the murdered Tokhang victims and ultimately destroyed the social fabric of these communities. Ultimately, Mr.
Magandang hapon po. Day 3 na ng Confirmation of Charges hearing ng International Criminal Court Pretrial Chamber 1 laban kay dating Pangulong Rodrigo Duterte. At para po yan sa kinakaharap niyang crimes against humanity, kaugnay ng madugong war on drugs ng kanyang administrasyon.
Buong puwersa pa rin ihahatid ng GMA Integrated News ang latest kaugnay ng pagdinig mula sa The Hague, Netherlands.
Ako po si PR Kanghel.
Ako naman po si Ivan Mayrina. Ito ang Duterte sa ICC. Special coverage ng GMA Integrated News. At ngayong araw nga po nakatakdang maglatag ng merits ang defense team ni dating Pangulong Rodrigo Duterte para kontrahin ang mga akusasyon para sa kanya o laban sa kanya.
At pangungunahan po ito ng Lead Defense Counsel ni Attorney Nicholas Kaufman na handa raw depensahan ang kanyang kliyente. Ngayon po kuha po tayo ng live update mula po sa The Hague sa the Netherlands at naroon si Marisol Abdurrahman. Marisol?
Pia, magandang umaga mula rito sa ICC sa The Hague, Netherlands. Gaya ng ating inaasahan, maagang pumila kanina ang mga papasok dito sa loob mismo ng ICC para tunghayan ang pangatlong araw ng pagdinig sa confirmation of charges kay dating Pangulong Rodrigo Duterte. But unlike ng mga nakaraang first and second day of hearing, ngayon wala tayong mga nakikitang pagkilos. Ito ay mapaantay o pro-Duterte man. But nonetheless, nagpapatuloy pa rin ang mga ilang taga-suporta at yung mga grupo na sumusuporta rin dito sa mga pamilya ng mga biktima. Kanina nga Pia, nakausap natin ang mga pamilya ng mga biktima. Meron daw silang kunting kaba sa magiging presentasyon ng depensa ngayong araw pero kampante pa rin naman daw sila sa prosecution. Bagamat umaasa silang mataas ang tsansang mauuwi sa confirmation, hindi nawawala ang kaba na baka hindi pa rin umusad ang kaso. Si Shira naman tiwala na makakamit nila ang hustisya. Sabi ng mga kaanak ng mga biktima, inaasahan daw nilang sisiraan sila sa depensa at kokontrahin lahat ng mga iprenisenta ng prosecution nitong mga nakaraang araw. Dumating na rin kanina ang mga kaalyado at abogado ng dating Pangulo at they're looking forward sa magiging presentasyon ng depensa. Kahapon nga nang atin silang makausap doon sa Duterte Street kasama ang ilang mga taga-suporta ng dating Pangulo, sinabi nila na politikal lang daw ito. Pero ganun pa man, titingnan pa rin daw nila ang magiging kahinatnan na magiging pagdinig dito sa ICC. Samantala Pia, narito ang mga pahayag ng mga pamilya ng mga biktima. Ano po ang mga ina-expect po ninyo na mga sasabihin po ng depensa ngayon?
Siyempre, kontra sa amin.
At napaghandaan niyo naman po ito.
Yes po.
Pero sa ngayon, ma'am, anong pakiramdam mo ninyo? Kampante pa rin kayo?
Medyo may kaba.
Ano ang kaba? Ano ang kaba niyo po?
Siyempre, sa mga sasabihin po na kontra sa amin. Siyempre, masakit po yun eh.
Do you have fear na baka hindi nga ito mauwi sa confirmation of charges?
Parang 3-4%. Or
3/4 yung positive.
Yes.
May 1/4 pa rin na agam-agam. Ano ang pakiramdam niyo po ngayon on its third day ng hearing? Kayo ba ay 100% kampante na magtutuloy-tuloy ito? Meron kayong konting agam-agam na baka nga hindi pa rin ma-confirm? May posibilidad pa rin po na gano'n?
Para po sa amin, matibay yung ebidensya na mayroon ng prosecution at actually hindi pa para po sa amin makita yung evidences na meron ang prosecution and we're confident na magiging fair naman po yung charges. So kung ano man po yung kalalabasan ay base ito sa evidences. Pero we hope na mag-push talaga ito to trial.
Pia, may mga nakikita na rin tayo dito ng mga taga-suporta ng dating Pangulo, pero kung ikukumpara ng mga nakarang araw, medyo kokonti pa sila ngayon. Although we understand na takatagda naman talaga sila magtipon-tipon dito, lalo na nabigyan sila ng permit na magstay dito from 9 o'clock in the morning hanggang alas 5 ng hapon, yan ay hanggang sa Biyernes rather sa last day ng hearing sa Biyernes. May mga nakita na rin tayo, syempre sabi nga natin earlier na may mga taga-suporta na rin ang mga pamilya ng mga biktima, but this time nandun na sila sa taas, sa public gallery at personal na tinutunghayan ang ikatlong araw ng pagdinig dito pa rin sa pagpapatuloy ng confirmation of charges hearing kay dating Pangulo. Pia.
Marisol, kanina nung nakausap mo yung mga kaanak ng mga biktima, sabi nga nila inaasahan nila na magiging mahirap dahil syempre kukontrahin yung mga naging pahayag ng kanilang kampo pagdating sa araw na ito. Pero ano ba yung mga nakwento ba nila? Kung ano yung mga paghahanda na ginagawa nila? Kung ano ba, meron ba silang estilo pagdating sa gallery? Kasi syempre bawal magpakita ng matinding emosyon o reaksyon kapag sila ay nariyan na sa loob ng courtroom.
Alam mo, Pia, mabuti natanong mo yan, kasi mabanggit ko lang, talagang ramdam natin ang kanilang emosyon to think na it's been years already, pero ramdam natin na talagang medyo may kabanga sila. In the past, nung prosecution pa ang sumalang, nakikita natin yung sobrang kumpiyansa sila at tiwala sila na mauuwi nga ito sa confirmation. At positive sila na magkakaroon sila ng hustisya. Pero kanina, alam mo, nagkaroon sila bigla ng agam-agam, ngayon nasasalang na ang depensa. Unfortunately, Pia, hindi natin natanong ang mga ganyang paghahanda, pero nakikita natin na parang their emotions, to think na matagal na panahon ito. Tapos eto ngayon, yung sinasabi nga ng abogado rin nila na si Attorney Nery Colmenares na just listening to the presentation na nandun ka mismo sa korte is, bringing back their memories na talagang nagiging emotional sila, hindi nila maiwasan na nanunumbalik ang alaala dahil nauungkat nakikwento ulit. And that's the emotion that we have seen kanina, Pia. Nakita natin na nagkaroon nga sila ng kaba at talagang ibang-iba ito sa emosyon na nakita natin noong nakarang araw na syempre it's their time. Tayo ng prosecution, parang everything was presented, but kanina talagang nung magprepresenta na they're about to witness sa presentation of the defense, talagang nagkaroon sila ng konting agam-agam na may possibility nga naman pala na parang hindi nga ito matutuloy sa confirmation. Although, kung sa 100% parang 3/4 na positive at 1/4 ang medyo nag-alinlangan sila na baka bigla pa rin maging paborable kay dating Pangulong Duterte ang magiging desisyon nga ng pre-trial Chamber 1, Pia.
Alright, maraming salamat, Marisol Abdraman.
At pinayagan ng International Criminal Court Pre-Trial Chamber 1 ang hiling ni dating Pangulong Rodrigo Duterte na dumalo sa annual hearing on detention bukas. Ayon sa ICC, walang legal framework sa korte na nagsasabing kailangan ng presence ng suspect sa pagdinig na ito. Alinsunod sa ICC Rules of Procedure and Evidence, kailangan magkaroon ng annual detention hearing para pag-aralan ang pagkakakulong doon ng isang detainee.
Mariin pong itinanggi ng International Criminal Court Office of the Prosecutor ang mga paratang na may mga politiko umunong nagpondo ng kanilang investigasyon sa bansa. Sa pahayag ng Public Information Unit ng Office of the Prosecutor ng ICC sa GMA Integrated News, sinabi nitong pinondohan ng kanilang korte ang lahat ng aktibidad ng Office of Prosecutor at aprobado ito ng ICC Assembly of States Parties. Transparent po sila sa lahat ng kanilang gastos at alinsunod ito sa ICC Financial Rules and Regulations. Nanindigan din ng ICC na nananatili silang independent sa pagkolekta ng mga impormasyon na kailangan sa investigasyon, sa paghahanap ng mga saksi at pagsuri ng mga ebidensya para sa drug war ng Duterte administration.
Kulang ang isang larawan para maipakita ang lawak ng war on drugs. Yan po ang ipinunto ng isang photojournalist na nag-cover ng kasagsagan ng gyera kontra droga ng Administrasyong Duterte. Isa sa mga ipinakita ng prosekusyon ang tumatak na imahe ni Jeneline Olaires habang kalong ang napaslang na kinakasama na si Michael Sharon. Kasama sa mga media na nag-cover noon ang photojournalist na si Rafi Lerma. Sabi ni Lerma, naging emosyonal siya nang makita ang mga larawan. Bagamat kulang ang isang larawan, mahalaga makita ng mga taong nangyari nung drug war.
Na makita ng mga tao yung sana man may empathy. But that photograph alone, for me, cannot explain the thousands of people who were killed in the span ng 6 years ng drug war.
Creator and head of the DDS.
Sa Hindi sinama ng prosekusyon sa mga kasong insidente pero ipinunto nila ang naging reaksyon dito ng Pangulo na tila minamaliit ito at sinabing gumagawa lang ng drama.
And then, there you are, sprawled on the ground, and you are portrayed in a broadsheet like Mother Mary cradling the dead cadaver of Jesus Christ. That's how they are creating dramas here. This is what he said.
Sa naunang 2 araw ng Confirmation of Charges hearing, iprinisenta ng prosekusyon at ng mga abogado ng mga biktima ang kanilang argumento at ebidensya. Sa Day 1, inilatag ni ICC Prosecutor Julian Nichols ang mga ebidensya ng umano'y pagpatay ni dating Pangulong Rodrigo Duterte sa libo-libong babae, lalaki at kabataan. At ang pagbuo ni Duterte ng DDS o mas kilala bilang Davao Death Squad. Sa Day 2, ipinakita naman ni ICC trial lawyer Edward Jeremy ang tinaguriang narco list o PRRD list ng high-value targets ng Duterte drug war. Idetalye rin ang sistema ng oplantokhang at ang reward system o promotion para sa mga sundalo at pulis na makakahuli o makakapatay sa mga high-value target. Ang trial lawyer namang si Robin Croft naglabas ng datos ng extrajudicial killings na naitala sa Davao City noong mayor pa lang si Duterte, na dumami raw nang maging Pangulo si Duterte noong 2016. Nagpakita si Croft ng mapa kung saan daw naganap ang malawakan at sistematikong pagpatay sa buong bansa noong Administrasyong Duterte, pati na ang listahan ng mga umano'y co-perpetrators ni Duterte. Binigyang diin naman ang kinatawan ng mga drug war victim na si Paulina Masida na ang tinarget talaga sa drug war ay yung mga galing sa mahihirap na komunidad kung saan naging coping mechanism na raw ng ilan ang shabu dahil sa hirap ng buhay.
At mga kapuso, makakasama po natin ngayon via Zoom, Professor ng International Law at Vice Chair ng Philippine Judicial Academy Department of International Law and Maritime Law, Professor Romel Regalado Bagares. Professor, good morning. Thank you for joining us. Good afternoon.
Magandang hapon po sa lahat.
Magandang hapon po, Professor.
Magandang hapon.
Professor, na ilatag ni Pia yung parang recap nung naging presentation ng prosecution. I'm sure minonitor nito the last yung 2 araw ng paglalatag nila ng kanilang argumento at ebidensya. Ano sa tingin ninyo yung pinakamatitibay na naipresenta ng prosecution?
Sa aking palagay, natuto na yung prosecution mula sa karanasan nito sa isang kaso noong 2019, ang kaso ng Bagbo. Kaghalintulad ito ng kaso ni Duterte, isang former sitting president, tried for violent rhetoric leading to deaths. Indirect co-perpetrator din ang charge, pero na-acquit mula sa trial chamber hanggang sa appeals chamber. Ang diferensya kasi dito kay Duterte ngayon, meron po tayong smoking gun. Ano po yung smoking gun? Ito po yung written policy na wala doon sa unang kasong nabanggit ko. Ano po yung written policy? Ito po yung circulars na na-issue para sa Oplan Double Barrel. At Oplan Double Barrel Reloaded, na ayon po doon sa prosecutor, actually kinopya lang doon sa isang existing policy nung si dating Presidente Duterte ay mayor pa ng Davao City. At itong policy na to ay buong Pilipinas, nakasama ang Pangulo, an essential figure in its drafting and execution and implementation. Kasama yung mga key figures din na naging bahagi din ng kanyang nung siya ay mayor pa ng Davao. So ito po ang mahalaga dito, yung smoking gun. Kaya meron pong focus yung prosecutor sa salitang neutralize. At sinabi ng prosecutor na walang dudang ibig sabihin nito, patayin ang lahat ng mga suspects, whether drug pushers or drug addicts, kahit na walang due process.
Ito po ba sa tingin ninyo, nabanggit nitong si ICC Prosecutor Julian Nicol sa isang punto na kahit tanggalin mo yung mga direct quotes ng Pangulo, ay tatayo pa rin itong kaso ng prosecution. Ito ba yung tinutukoy niya na dahil na-establish nila na may national policy creating the drug war?
Tama po yun, kasi yung pong ito is substantial grounds that the crime has been committed and it should go to trial. Ibig sabihin po kasi ng substantial grounds is that there should be a robust prima facie evidence or there should be a strong indicia of guilt that, if not rebutted, can lead to a conclusion of to a conviction, no? So kailangang i-rebut ito ng depensa, yung pong smoking gun na ito, no, na kahit wala yung mga statements ng presidente pero malinaw sa actions because it can be inferred from the actions resulting from the policy, no? At hindi lang yon, meron silang pinakita na connection na yung mga dating mga kasama ng presidente ay inappoint niya sa mahalagang ahensya ng pamahalaan dealing with law enforcement. DOJ, NBI, PDEA, PNP, At itong mga personalidad na to ang nagpalaganap nung policy na ito.
Alright. Professor, meron lang ako isang mabilis na tanong kasi syempre, di ba, the burden of proof laging nasa prosecution. Pero pagdating dito sa araw na ito, kung kailan submission of merits ng depensa, sila naman po ang magkakaroon ng pagkakataon magsilta. Ang tanong ko mamaya kung gaano kabigat yung ebidensya na kailangan nila ipakita. Pero bago noon, Professor, pakinggan na po natin dahil nagsisimula na po ang ikatlong araw ng pagdinig ng confirmation of charges hearing ng ICC.
Bonjour à tous.
Good morning, everyone. I'd like to welcome everyone in the courtroom, as well as those who are listening in from outside the courtroom. Court officer, please call the case.
Your Honors, situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Duterte, case reference ICC 0121-0125, and for the record, we are in open session.
Merci beaucoup.
Thank you very much. I would like to ask parties and participants to confirm that those present in the courtroom today are the same as the people in attendance on Tuesday. Mr. Prosecutor, the prosecutor. Good morning. The OTP is represented by the team. Mr. Ido Duke, Associate Trial Lawyer, is one additional. I myself, I am back after a short absence. The presiding judge, thank you very much. Legal representatives of victims, Ms. Masida. Ms. Masida, thank you. Good morning, Your Honor. It is the same team as Monday, not Tuesday, but Monday. The presiding judge, thank you very much. We can now turn to the defense. Mr. Kaufman. Good morning, Madam President, Your Honors. It is the same lineup as previous days. I will go no further than that in French. The presiding judge, thank you very much. We can now move on to the defense and their submissions on the merits. Mr. Kaufman, you may address the court.
Now, before I start, I would like to make one general comment, and it's a comment which every defense counsel who appears before this court is obliged to make. So if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defense's submissions, I hope that they will at least communicate the following faithfully. The defense does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be leveled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defense's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. it's not the defence's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defence's role is simply to persuade your honours that Mr. Rodrigo Duterte should not remain in detention for years to come, simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of this case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists and their editors have a tendency to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. The prosecution has had its opportunity to show you a selection of these speeches and seems to believe that the more they show, the greater the chances of convincing your honours to confirm the charges. But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the deputy prosecutor, actually contain an exhortation to the use of lawful self-defense. Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day to show you. This is a speech, the second speech that the deputy prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the deputy prosecutor read from this speech. So the police is under the DILG, so I have to believe the story of the police, for simply they are my subordinates and I am ultimately responsible for their deeds. Now let's look at what the deputy prosecutor didn't state from the same speech. And the order is simply this: go out, arrest them if you can, but if there is no peaceful method of doing it and you are presented with violent resistance, thereby placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL OTP 00001127 at page 5. And I quote, "But if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility." Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, just do it right. We have our trainings that you can only kill if your life is in danger, and you are there performing the duty of a law enforcer. That's about it. Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this, "I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat, again for all and for everybody's consumption, do not kill if you are not in danger of losing your life." Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact, the majority of these speeches, I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask your honors and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had a speech of 2 pages prepared, but to his regret, it didn't come from the heart. And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that in one city, Davao, hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to produce, the prosecution on the matter, is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432, in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages. So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory, with respect to the definition of the targeted population, is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting two alternative propositions, hoping that this pretrial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, that the civilian population attacked comprised prison detainees professing a certain political ideology. In so doing, Your Honours declined to issue an arrest warrant for El-Hishri, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El-Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10th February 2025, the prosecution rushed out its application for Mr. Duterte's arrest, believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025. The pretrial chamber, this same pretrial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that is his prosecuting before this court. After all, if we apply the resulting logic of Your Honour's decision in El Hishri to the prosecution's case theory in the Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the El Hishri decision, the gurus on the top floor of the Office of the Prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pretrial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely the second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, the segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society and thus rendering them susceptible to an attack. After all, how does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count 1, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you? It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purposes of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorizing an investigation in the Kenya situation, where at paragraph 81, the pretrial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly. Even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards. With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court? After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b. But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the pyramid of Giza. The most they can do is allege that their cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges leveled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defense has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte or even indicating his participation in or control over any one of the 49 incidents alleged in a document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents are not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters, I would respectfully submit, are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability levelled at Rodrigo Duterte. As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was, in addition, wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous, and, I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33, inclusive, of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty, which reaches more than a substantial degree of certainty, is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses, or witnesses. Where are they? Number one. Interviewee, at least more or less than 10 buy-bust operations. Where somebody was shot, asked the interviewer, yes, sir. Interviewer 1, okay. And on those 10 occasions, was the shooting justified? Interviewee, yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one, witnesses who said, the PNP never said kill those people. Another quote, from what I recall of the incidents that I was at, all of them had guns, and they were pointing them at the pusher buyers, or they were pointing their guns at the pusher buyers. At the operations I was at, I'm talking about the operations I was at, the reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication, and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals. That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Dev Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, thinking like a prosecutor, I would say that the reason why the prosecution has fixated
At yan po ang unang bahagi no, ng pag-sumite or submission of merits ng depensa dito sa ikatlong araw ng confirmation of charges hearing. At maraming mahalagang sinabi rin no, yung depensa na pwede nating ungkatin kasama si Professor Romel. Professor Romel, magandang hapon po ulit sa inyo. Alright.
Professor Bagares?
Nandiyan na po ba siya? Okay,
Actually, ongoing pa kasi si Attorney Kaufman mukhang nagkaroon lang ng problema yung live streaming from the ICC. Pero so far, medyo halos nakakaisang oras na rin. Itong si Attorney Kaufman, maraming rebuttals tayong narinig mula sa kanya. Direkta. Point by point, sinasagot niya yung mga ipipresenta ng mga prosecutors. Isa sa mga una niyang inatake, ika nga, yung konsepto ng crimes against humanity na walang polisiya, kahit pa naglabas ng kautusan ang PNP ng Oplan Double Barrel, hindi yun nangangahulugan na ito ay kailangang takihin na yung entire civilian population. Yun ang pinupunto ni Attorney Kaufman.
Parang sinasabi niya, hindi naman pwedeng sabihin widespread or systematic. Kung parang ganito lang kaliit, no? Kung parang small sample sa kanilang pananaw. Pero babalikan ko kasi 'di ba, ilang araw pa bago nag-umpisa yung confirmation of charges hearing, ipinupunto na ni Attorney Kaufman sa mga interview na wala naman kasi talagang criminal intent.
Correct.
Si dating Pangulong Rodrigo Duterte nang siya yung nag-utos na patayin o kung ano man no, to neutralize drug pushers or whoever's involved in the war on drugs. At ilang beses niya itong sinabi, ang paglalarawan niya dun sa mga naging utos noon ni Pangulong Duterte, sabi niya, an exaltation to lawful self-defense.
Yes.
So kumbaga sinasabi niya, hindi naman sinabi ni Pangulong Duterte na patayin mo. Ang sabi niya, ang sinasabi ni Pangulong Duterte, if you must use your right to self-defense, tsaka mo gamitin yung baril mo.
When under threat. Yun ang circumstance under which you can use force para protektahan ang iyong sarili. Nabanggit kanina ni Professor Bagares, bago tayo nag-pause for the live feed, yung kaso ng Gibagbo. Ito po ay dating head of state din ng Ivory Coast, kung saan nakasuhan siya sa ICC pero na-acquit dahil hindi na-establish na yung kanyang mga pananalita, parang malaking pagkakahalintulad ng kaso kay dating Pangulong Duterte, ang kanyang pananalita ang naging sanhi daw ng pagkamatay ng marami sa mga sibilyan ng Ivory Coast. Pero yan po ay na-acquit dahil hindi na-establish ng maigi yung causality, that's the word used, yung causal effect ng kanyang mga salita at yung utos na pumatay. Yan din ang pinupunto ni Attorney Kaufman sa kanyang paunang bahagi ng kanyang diskusyon kanina.
Sinasabi rin kasi nung panahon na yon na parang doon sa particular na kaso na yon, di ba, 2019, na parang media articles are not enough to establish or considered insufficient evidence. So hindi siya sapat para sabihin na kailangan na guilty, di ba? Hindi pwedeng sabihin na agad na gano'n. Pero pwede natin balikan yung sinabi rin ni Ivan, ni Dean Raul Panglangan nung unang araw ng confirmation of charges hearings, na kasi parang dito sinasabi ni Attorney Kaufman na yung hindi mo pwedeng sabihin na yung utos na ginawa ni former President Duterte ang siyang naging dahilan nga nung pagpatay. Ang sinasabi niya, yun yung interpretasyon nung nakatanggap ng utos. Pero ang sinasabi ni Dean Panglangan, may mga naging pagkakataon o kaso na kung saan sinabi na yung interpretation ng nakatanggap ng utos is also enough to prove na may kasalanan din yung nag-utos.
Pero Pia, may ibang pananaw din naman. Si Dean Ralph Sarmiento na nakausap naman natin sa Day 2. Ang sinasabi naman niya, mas madaling i-establish yung linkage dun sa Charge 1, yung time na mayor pa. Ayan na, nagpapatuloy po ang confirmation of charges hearing.
De La Rosa issued a pre-drafted command circular number 16 of 2016 on 1st of July of that year, formally launching the anti-illegal drugs campaign nationwide in express pursuance of Duterte's campaign promises. There is no dispute that CMC number 16 of 2016 mentions Project Double Barrel, which was indeed modeled after Davao City's policing strategy and was directed at the neutralization of illegal drug personalities nationwide. But here we come to the crux of the prosecution case. The manifestation of the criminal plan in writing. Neutralization as a euphemism for murder. Ms. Robin Croft certainly thought so when making her submission on behalf of the prosecution, highlighting the word in bright red and presenting us with a slide where the word neutralization forms an integral element of the common plan. To import an element of criminality into what would otherwise be a perfectly anodyne legal document, the prosecution resorts to relying on speeches and interviews given by Ronald de la Rosa Bateau within a day or two of him being appointed the chief of Philippine National Police. For example, in an interview relied on by the prosecution at footnote 136 of the pre-confirmation brief, De La Rosa explains how tok hang means knock and plead, and that it is a totally legitimate police strategy. However, the citations relied on by the prosecution to infer that tok hang was a criminal modus operandi are completely taken out of context. I shall just cite one question and answer from the media interview on which the prosecution relies at paragraph 27 to prove that De La Rosa, when talking about instilling fear in the hearts of drug users, was actually proposing a policy which was anything but criminal and totally supportive of the main tenet of the defense, namely that the only use of force would be that envisaged by way of self-defense. And I quote, question, "Sir, you mentioned about instilling fear. When you instill fear, how do you ensure that you do not violate human rights?" Answer, good question. We will see to it that the police operational procedures are being followed in every legitimate police operations. When they see that the police are really determined to go for them legally, he stresses the word, and many of them go down, maybe they'll get scared. That's PHL, OTP 000-16403 at page 13. In any event, what the prosecution has not told you, and what it has not shown you by way of its opulent images on the video screen, is that the supposed criminal blueprint set out in Command Circular 2016, number 16 of 2016, is totally negated by the content of the document itself. Let us take a look at paragraph 8E and F of the very same Command Circular, number 16 of 2016, which states quite clearly that all operations should strictly observe the rights of the accused enshrined in the Philippine Constitution, as well as international law and human rights. Why, I ask you, did Mr. Edward Jeremy, counsel for the prosecution, in his very eloquent and gilded address, not screen this part of the Command Circular? After all, this Command Circular, as elaborated by Ms. Robin Croft, was the very essence of his criminal common plan, in writing. This is the basis, so Mr. Jeremy stated, for the criminal agreement to kill high-value targets. And if that were not enough, the lawfulness of Command Circular 16 of 2016 was reiterated 3 weeks later on 22 July through the initiation and issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. I think there, Madam President, if I may, we can take a break, obviously with your permission.
Bien sûr, maître, je vous remercie, Kaufman, je vous remercie beaucoup.
Thank you, Council. Thank you very much. If you can also indicate the numbers of the documents that you have referred to, that will be good. Thank you very much, says Judge Motok. We will take a break now and resume at 11:30. Thank you very much.
Ayan, nag-break po ang confirmation of charges hearing kung saan nilalatag na ni Attorney Kaufman ang depensa ni dating Pangulong Rodrigo Duterte sa mga inilatag namang ebidensya at argumento ng prosecution sa nakalipas na 2 araw simula noong Lunes at Martes. Partner, kanina pinag-uusapan natin yung pag-establish ng cause and effect. Na yung pagsabi ng Pangulo ng ganito, hindi naman necessarily maililink doon sa mga nangyaring pagpatay. At sinasabi ni Attorney Kaufman, walang smoking gun ang prosecution. Ito yung sinasabi ni Professor Bagares kanina, ang smoking gun dito ay yung memorandum na kautusan na that basically gave life to Oplan Double Barrel, yung anti-drug campaign ng Philippine National Police noong 2016.
Pero base rin kasi dun sa mga naging pahayag nga ni Attorney Kaufman, bago pa siya nag-umpisa sa kanyang pagpresenta ng mga argumento at ebidensya, parang hindi na rin natin masyadong ikinagulat na ito yung naging takbo ng kanyang paglatag ng depensa. So sa punto ito, makakausap muli natin si Professor Romel Regalado Bagares. Professor Bagares, anong masasabi niyo doon sa unang bahagi ng submission of merits ng depensa?
So gaya nga ng ang kaso ng bago, napaka-relevant talaga dito.
Yes.
Walang ibang ebidensya, puro press release, human rights reports, NGO reports, yun kasi yung nangyari dun sa bago. No? Wala, pero sabi ko rin nga, sa bago walang written policy, dito meron. At sabi ko smoking gun yun, sinabi niya hindi smoking gun. Ano? Kasi nga, talagang ito yung pinagkakaiba dito sa ang kaso ni Duterte at ni Bago. At inaasahan ko rin talaga na sasabihin niya na bakit doon sa kaso ng Bago, wala namang matibay na ebidensya na maglilink doon sa mga sinabi ng Pangulo at saka doon sa mga pagpatay. No? So, inatake niya yung causation theory ng prosecutor. Isang malagang makita dito, sinabi niya rin, no? Tingin ko, medyo malakas yung puntos niya dito. Yung dokumento mismo, merong nagsabi na human rights ay ay susundin ng mga kapulisan, ano? Dahil at sinabi niya na ang dokumentong ito, hindi naman ito criminal modus operandi. Ang dokumentong ito ay patungkol sa krimen, kung paano puksain ang krimen at hindi patayin yung mga civilians. So nag-focus siya doon sa word ng neutralization at sabi niya, hindi ibig sabihin niya na patayin yung mga civilians without due process. Kasi doon mismo sa dokumento, merong nakalagay na susundin ng kapulisan yung human rights, no? So ang theory dito ni Attorney Kaufman, ganito, no? Kung meron mang pagpatay na illegal, hindi ito malilink doon sa dokumento mismo, kundi meron mga scalawags, no? Merong hindi sumusunod, deviation from policy. And you cannot blame that on the president. Yun ang sinasabi niya.
Attorney, balikan ko lamang itong punto na to sa dokumento. No? Ang pinupunto pa ni Attorney Kaufman, hindi naman daw ito kautusan na atakihin ang general population. Bagkus atakihin ang mga pinaghihinalaang kriminal. So what is he trying to establish or accomplish by arguing this?
Well, sinasabi niya kasi, yung kasing crimes against humanity, yung isang elemento doon, targeting civilians as a policy.
Okay.
Sabi niya, parang preposterous yung sinasabi ng prosecution na yung buong Pilipinas yung inaatake, ano, ng policy ng dating pangulo. Hindi ganyan, no? At in fact, doon sa as the policy is worded, sabi niya may discretion yung mga mag-i-implement. At yung exercise ng discretion na yun, hindi mo yun pwedeng sabihin na si Presidente Duterte pa rin na may kasalanan. So, sinasabi niya essentially na kung mayroon mga gumawa ng mali, no, o mali yung exercise ng discretion, hindi si Presidente yun, kundi nag-implement in violation of the policy. Yun ang depensa niya, no? And that is actually what was done in the case of Bagbo, ano? Dahil walang written policy, pero ang sinasabi ng Bagbo, yung mga generalized killings, no? Hindi ibig sabihin na dahil maraming pagpatay ay directed yung pagpatay. Kasi sabi sa Bagbo ng korte, wala namang ebidensya na talagang merong common control, may joint implementation, merong indirect co-perpetration circle of people. Dahil nga sa walang koneksyon na nakita yung korte doon sa mga pronouncements ni Laurent Gbagbo at yung mga pagpatay na sumunod.
Professor, sa punto po bang ito, mahalaga po ba na magpasok na ng aktwal o bagong ebidensya ang depensa kasabay ng kanilang pagkontra sa mga naging unang pahayag ng prosekusyon? No? I mean, kasi at this point, diba, rebuttal ang nakikita natin. Paano ba yan titimbangin ng mga hukom ng ICC?
Well, kasi of course, no, napakarami ng mga ebidensya na sinabit yung prosecution at yung depensa dito. Nakita lang natin yung summation, yung main outcomes, no, ng kanilang dokumento. So nakita natin kanina yung contextual arguments ni Attorney Kaufman. Sinasabi niya, taken out of context yung mga statements ni Duterte. At kahit yung ebidensya mismo ng mga prosecution, yung mga cooperating criminal witnesses, ano, or yung sa atin yung mga insider witness daw, yung mga statements ng mga insider witness ay tend to tell us that, you know, the operations were really proper. Na kaya lang sila gumante kasi tinutukan sila ng baril. Yun yung mga ebidensya, mga selected pieces of evidence na pinakita ng prosecutor, ano, ng depensa rather, no. So makikita natin, no, na yung mga standard na defenses ay ginamit naman ni Attorney Kaufman dito sa kanyang initial presentation.
Kasi nga po, ang sinasabi ni Attorney Kaufman, yung mga naging pahayag ni former President Duterte, hindi naman daw ito utos na magpatay, kundi utos na gamitin ng anumang kailangang gamitin para depensahan ng sarili kapag mag-aaresto ng mga umano'y drug pusher. So, kayo po, paano nyo titimbangin yung ganito? Kasi parang ano siya, parang very subject to interpretation. He said, she said, parang ganon.
Well, actually, he was addressing two other alternative modes of liability. Nakikita, ang madalas kasi nire-report dito sa atin, yung unang principal mode of liability, yung indirect co-perpetration. Actually, may dalawa pang alternative modes of liability dito na kasama sa charge sheet. Ano? Yung isa is yung ordering or inducing at yung pangalawa ay yung aiding and abetting. No? Yung ordering or inducing, walang common plan pero nag-utos siya at yung utos niya ay nagbunsod ng pagkamatay ng mga tao na illegal. Yung inducing naman, alam niya na merong kasama siya na gumagawa ng krimen, nagbigay siya ng tulong. So itong dalawang alternative modes of liability actually are accessory crimes. No? Hindi siya dito principal author or designer. No? Kung hindi, accessory lang siya. No? Nevertheless, yung range of penalties, if proven to have happened, will still be the same as the principal crime under the rules. So yun actually yung sinasabi dito ni Attorney Kaufman na well, meron kayong alternative na arguments, pero kahit yun, wala kayong direct evidence. No? Actually, yun din, no? Kasi hindi natin alam yung mga complete na data, hindi natin makikita dito, napakarami. No? Pero I think, halimbawa, doon sa policy, no? I think the prosecutor can address with the fact that, you know, all those 6,000, yung sa human rights argument, 6,000 plus official deaths arising from the tokhang, no, na supposedly nanlaban. Now, under the manual of operations of the PNP from 2013, which was active, which was live when Bato de la Rosa was PNP chief, sinasabi doon na tuwing may mamamatay sa police operation, dapat dadaan ng inquest yan. Meaning, i-inquest ng DOJ yan para patunayan na walang irregularidad na nangyari sa pagpatay, walang foul play. Ano? Ngayon, pag titingnan natin, dahil may kaso niya sa Korte Suprema, no, ay yung unang writ of amparo case against the drug war, ni isa walang maipakita yung PNP, no? Na report ng inquest. Ano ibig sabihin niyan? Well, sasabihin ng prosecutor, nakita natin na meron kasing inner circle. Yung mga tao ni Duterte nung siya ay nasa Davao, inappoint niya ngayon sa mga mahalagang ahensya ng pamahalaan. Kasama yung DOJ. Sino yung dapat gumagawa ng inquest? Yung DOJ. Bakit wala kahit isang report sa 6,000 pagpatay?
Attorney, para i-reinforce ang kanyang point dun sa pag-question sa causal link between the president's statement or former president's statements and the murders, sinabi ni Attorney Kaufman, wala daw ni isang witness na naipakita ang prosecution na in-order siya o inutusan siya and he actually went out and killed someone. Kailangan po ba ganun ka-direct, ganun ka-literal ang ma-establish na causality para maipin sa dating Pangulo ang liability?
Yung point na yun, I think doon yun sa second mode of liability, yung ordering.
Yes,
no? Pero doon sa indirect co-perpetration, hindi naman kailangan merong direct, no? Kailangan lang ipakita na meron isang grupo, merong common plan, merong joint control, merong criminal intent, no? At merong essential rule ang Pangulo doon sa joint commission of the crime na yon, no? And in this case, according to the prosecutor, meron talaga kasi may inner circle, meron silang policy. Kung ano yung ginawa sa Davao, nireplicate lang yun in a grander scale pagdating sa naging presidenteng Pangulo, nationwide na siya, at yung mga taong kasama niya doon sa Davao, in-appoint niya sa key law enforcement agencies to ensure the implementation, no, using state machinery to implement the alleged murderous policy.
At saka it has been widely reported, Attorney, na yung mga nagpakilalang dating DDS, sina Matobato, sina Las Cañas, hindi ho ba ang claim nila ay tumanggap sila ng direct orders mula sa dating Pangulo to carry out the killings?
Tama po yan. No? But right now kasi, no, at this stage, it's very rare really that the pretrial chamber allow the presentation of a live witness, no?
Okay.
Mangyayari doon sa trial talaga. Pero dito puro dokumento pa lang. So hindi pa po natin talagang, unless magkaroon ng exception. Pero wala naman tayo nakitang order at request on the part of the prosecutor to present a live witness, no? So hindi talaga ginagawa yan dito sa stage na to ng pre-trial.
Okay.
At Professor, nabanggit ni Attorney Kaufman na parang isa sa mga pinunto niya, bakit daw tumagal o bakit naghintay ng 4 na taon bago inimbestigahan? Why did it take the ICC 4 years after President Duterte pulled out before actually investigating? Sa tingin niyo po ba may merito ang ganitong klaseng argumento o pagpunto ng depensa?
Mukhang jurisdiction pa rin ang tinutumbok nila dito.
Jurisdiction yan. Yes. As I said kanina, pwede niya namang iulitin yun. Ano? Kasi pag na-address na yun ng pretrial chamber earlier, no, sinabi na wala, tapos na yan, no? Kasi malinaw naman na yung ibig sabihin ng judicial proceedings kasama yung gawa ng prosecutor, ano. At yung time element kasi yun ang sinabi ng minority view doon sa appeals chamber decision na nagsabi na may jurisdiction, ano. So inulit na lang yun. Pero actually, pag tingnan natin yung practice ng ICC, minsan yung kaso ng Afghanistan, 15 years na, no? Hindi pa tapos yung preliminary examination, tapos nagkaroon ng PI, tapos na-suspend, ano. So matagal talaga, based kasi nga yan sa mga evidensyang available, no. Pero ngayon, mas malinaw na kasi nagkaroon ng mga maliwakang reforma, no, pagdating sa timeline. So kagaya nito, alam natin 60 days merong period na binigay yung rules ng procedure ng ICC. Dan dapat after this pretrial proceeding, within 60 days meron ng ruling on the confirmation of charges. But nevertheless, you know, it really takes time because this is the nature of an international kind of proceeding, very complex kasi yung
Pero kasi nga po, 'di ba, parang sinasabi na nga po na eto nga nagkaroon na nga ng ruling on jurisdiction kasi nga pinayagan nga na umabot pa dito sa pre-trial chamber. Pero yung the fact na paulit-ulit siyang binabanggit ng defense even with previous rulings. Strategy na lang po ba ito para at least in the mind of the public parang isipin nila, nga no, parang may punto ba ito or hindi?
Well, aside from that, no, as a lawyer myself, no, you try your best to actually put into the record your objection on jurisdiction from the very beginning. Kasi it's part of legal strategy to show that you've always been a persistent objector to the claim that court had acquired jurisdiction over your client, ano? At consistent yan kasi meron silang pending appeal, no, sa appeals chamber on that very question from the pre-trial chamber order dismissing their motion to dismiss on the ground of lack of jurisdiction. So it's actually the defense being consistent with the argument.
Attorney, pati yung common plan, kinwestiyon ni Attorney Kaufman. Ano bang tinutumbok niya dito?
Yun nga, no? Kasi ang teorya ng prosecution mula sa Davao na export sa Manila, yung mga personalities na katuwang niya sa Davao, naging PNP chief, naging PDEA chief, naging DOJ chief. Ano? At kaya naging madali yung implementation. At kung hindi naman siya naging presidente, wala ding ganung klaseng drug war. No? Yun yung common plan doon. At sabi ng prosecutor, well, may written policy, yun yung circular na in-issue ng PNP. And in fact, hindi lang yan, no? May dalawa. Tapos yung Malacanang din, nag-issue din ng administrative order suspending the if you recall, to suspend the implementation of double barrel because of the Kian de los Santos killing. At pagkatapos ay binalik yun, reloaded na. So may mga written policies, but the principal one really here is the Oplan Double Barrel Memorandum Circular.
Tapos ang sinasabi niya, hindi nga daw, parang malabo naman daw na makakapagpresenta sila ng patunay na nag-meeting itong mga tinatawag na co-perpetrators para pag-usapan itong common plan. Is that even required?
Hindi naman. Ano? Kasi yun nga, maraming maaring, pwede kasi magkaroon ng inferences. Inferences at saka based on the actions carried out by the key personalities. And what goes well, at least at this point in time, because this is not yet a process requiring proof beyond reasonable doubt, for the prosecution, pinakita nila na meron talagang written policy na kakaiba. And this is unique kasi may written policy matching that with the pronouncement of the president, and then there's statistics, the scientific study showing the distribution of killings, that these are not random killings.
Yes.
There's a pattern to the killings, and the pattern shows that this is pursuant to the written policy.
Professor, kasi ilang beses rin binanggit ni Attorney Kaufman na parang kung ano man ang mga speech or pahayag na sinabi ng prosecution or sinight ng prosecution, meron din naman silang maipapakita ng mga naging pahayag ni dating Pangulong Duterte na pangontra din daw doon. So parang kumbaga pagdating doon sa mga naging statements ni Pangulong Rodrigo Duterte, meron daw silang pangontra doon. Pero kung titimbangin po yung mga naging statement ni Pangulong Rodrigo Duterte versus kung ano man ang sasabihin or ano mang naging pahayag ng mga testigo, alin po ba doon ang mas bibigyang diin ng korte?
Well, kung titingnan natin yung standards, yung preponderance of evidence, which is equivalent to a strong indicia of guilt, that if not rebutted could lead to a conviction, na mas marami yung mga statements ng Pangulo all those 6 years. If you correlate that with what happened the next, yung one time, big time, and I think it's very difficult actually to say that was not the intention of the president, and he, in fact, campaign promised na there's going to be bloodshed, and the prosecution actually had a theory for that. Na inatake ni Attorney Kaufman, sabi niya, merong parang dalawang anyo yung presidente, yung kaliwa niyang mukha sasabing hindi, yung pangkanang mukha bahagi na kanyang labi ay nagsasabi ng oo, Yun yung sinasabi ng prosecutor na sasabihin niya na legal pero babawiin niya rin, and that is consistent across all of the statements made by the president, and I think that the scientific studies will really go into that, yung patterns ng killings, yung scope ng killings, sino yung mga pinatay, mahalaga yun, And plus, of course, the one that I pointed out, that the very requirements of the PNP itself with respect to deaths arising from a police operation, no? Requirement yun na magkaroon ng inquest. Pwede mong i-excuse siguro yung 10 or 50 na walang reports. Pero 6,000 plus walang reports kahit isang maipakita yung PNP, well, that tells you something, no? And that should go into the argument of the prosecution in their submissions to the court.
Attorney, nabanggit nyo kanina, binigyang diin ng prosecution yung word na neutralize, to mean kill.
Exactly.
Ito ho, si Attorney Kaufman, ang sinasabi niya, ang neutralize ay euphemism. Hindi siya exactly equivalent to kill.
Patay. Well, alam niyo, naging beat reporter din tayo ng matagal at sa mga police reports.
Yes.
Pag sinabing neutralize, patay talaga yan. Di ba?
Correct.
Sa joint operation reports,
Yes.
pag sinabing neutralize, patay yan. So I think there should be some documentary submissions on the part of the prosecution on the meaning of neutralize in police reports.
Professor, balikan ko lang po yung naging tanong ko kanina kasi nga ang narinig natin, rebuttal pa lang so far, di ba? At ang inaasahan natin kasi, parang ang intindi natin kapag submission of merits, meron ka rin ipipresenta na bagong ebidensya. Aasahan ba natin na pagkatapos itong break na ito sa pagbabalik ng depensa, meron pa silang mga ibang ipipresenta or pwede bang ipagpatuloy lang nila hanggang bukas na puro rebuttal lang at okay lang yon?
Well, dapat meron pa kasi binigyan sila ng panahon ngayon para sa kanila, no? I would expect there should be more on the other details kasi ano pala ang natalakay dito, yung elements of the crime, yung mga statements ng pangulo. So meron pa dun dapat kasi detalyado yung presentation ng prosecution dun sa individual cases, So kailangan kasi sabihin ng prosecutor na yung mga pagpatay na yun ay walang pattern yun, no? Na there's yung individual na examples, yung non-exhaustive list or representative cases na pinakita na ng prosecutor. Kailangan ipakita yun ng depensa na well, these are really random and these are not pursuant to a policy, but if at all, sinabi niya na kanina, nanlaban, self-defense, puro self-defense, or deviation from policy by scalawags who wanted to embarrass the president. Remember, during the time, Senator De La Rosa, when he was PNP chief, was talking about ninja cops also. No? So, siguro, dadating sila dun sa punto na yun, papakita nila na kung meron mang pagpatay na illegal, hindi sa amin yan. Kung hindi, may mga scalawags. And in fact, we prosecuted them. I guess they should talk to that on that point with respect to the Kian de los Santos plus the other a handful of prosecutions dealing with foot soldiers rather than the brains of the policy.
Attorney, lihis muna ako sa mga specific points na ni-raise ni Attorney Kaufman at dumako saglit dito sa kanyang style. He is quite the speaker, he's quite the debater. Sa mga ganito mga proceedings, gaano kahalaga na magaling magsalita, convincing, passionate ang abogado ng either prosecution or defense? Kasi hindi naman ito jury system, hindi naman jury yung magde-decide ng kaso.
Hindi po. Mahalaga po kasi yung rhetoric dito kasi yung International Criminal Court is a mix of civil and common law, Yung common law part, yung advocacy talaga. And si Attorney Kaufman is one who was really raised in the adversarial tradition, like the Philippines,
Yes.
Na may adversarial tradition tayo. In fact, yung binanggit niya, I think he's on leave right now, si Karim Khan. He was noted as a defense counsel. Before he was appointed as a prosecutor, the head of the prosecutor, Karim Khan was well respected because he had won quite a few cases, not a few cases, as a defense counsel. So magkakilala sila dyan. At people really held in high regard Karim Khan as a very able lawyer, as a defense counsel. So this is actually the first time we're seeing that live here, right? Napapanood lang natin yan sa mga palabas.
Sa pelikula ko lang napapanood sa mga series.
Yeah, di ba?
Where
rhetoric is really important, And that's why it's also wrong to compare it to a jury, because the judges are not the jury, and the judges are trained lawyers. So when you say that, they tend to be, they might be influenced by the persuasion
Yes.
Oh, I don't think that goes into the heart of it, because in the first place, the judges here are trained. They're not ordinary citizens as in a jury.
Oo. So hindi sila basta-basta hindi sila basta-basta madadala sa galing ng pananalita.
Po. Pero yun nga, no, makikita natin may konting insulto,
Oo.
no, na swak, mga ganun talaga, no. In any British court, you will encounter those kinds of rhetorical strategies of lawyers.
In fact, nung day one nga, natanong ni Pia kay Dean Pangalangan, sino bang kausap talaga ni Kaufman? Parang nag-a-appeal siya to the Duterte supporters dahil yung kanyang paraan ng pananalita at mga argumentong kanyang pinalutang.
Tama po yun, no? And I don't think that politics can be discounted here, because in the Philippines, this trial is also connected to a lot of things in the Philippine political realm. No? 2020 it is just around the corner, and the results of the elections might also influence how things will turn out. No? So kaya importante din talaga para sa tingin ko, para kay Attorney Kaufman, na i-address yung malaking constituency na yan ng dating Pangulo.
Tingin niyo po ba, Professor Rommel, kapag nahahaluan ng politika ang mga argumento, either ng prosekusyon or ng depensa, nakakatulong po ba ito sa kanilang kaso? I mean, at least in terms of yung sa pagtanggap nito ng judges. Kasi syempre iba pag sa publiko eh.
Well, sa international legal processes, hindi talaga may iwasan. In fact, marami tayong kaso. Sa ICJ, that was raised, no? Has been raised in a few cases. At sabi lang ng mga international tribunals, possible na meron ng political angle, but the most important thing is that even if there's a political angle to it, there is also a legal angle. And our focus will be on the legal question. So we can set aside the politics, but that's really for the council to do, no? But the court will say, in the ICJ, we have several cases dealing with that. The WHO advisory opinion and such, leading cases, no? Sinabi ng ICJ, International Court of Justice doon. Now, whether or not there is a political reason for these actions, it's beside the point. What is important for us is that there is a legal question. And our ruling will address the legal question, not the political one.
Sa puntong ito, Professor, kasi syempre pre-trial pa lamang po ito, no? Hindi pa siya yung aktual na paglilitis kasi hindi pa natin alam kung matutuloy nga siya sa paglilitis. Pero kayo po sa inyong karanasan, dapat po ba lahat ng pinakamabibigat na ebidensya nilalabas na dito? Or dapat ba meron kang ititira pa sakaling ang umabot sa aktual na paglilitis?
Well, nasa strategy naman yan. No? At alam naman ng mga prosecutor yan na yung kailangan lang natin dito is substantial grounds. Hindi pa proof beyond reasonable doubt. And besides, as I've been saying, actually, wala naman ditong ebidensya na maitatago. Kasi yung ICC, pagkakaiba niya sa ibang korte sa kagaya sa Pilipinas, merong doctrine of equality of arms. Ibig sabihin, kung ano yung ebidensya na meron yung prosecutor, kailangan may access yung depensa dyan. Even, especially evidence that will tend to exculpate from liability a defendant or an accused. It's a mandatory requirement for the prosecution. Ganun din sa depensa. Kung meron siyang ebidensya, hawak nila, ano man yun, kailangan available din yun sa prosecution.
So unique ito sa ICC, Prof, no?
Yes, equality of arms tawag dyan, doctrine of equality of arms. Sa Pilipinas, hindi po ganun. Pwede
taguan ng ebidensya yan.
Oo nga, so walang gulatan. Wala
Itago
palang
mong
gulatan
ebidensya
dyan.
mo kasi, di ba? Keep it close to your chest.
Although, the court has tried to limit that possibility now because of the new rules, no? Pero generally, don't really have that rule. No? Walang express rule on doctrine of equality of arms in domestic courts. That's a standard that you will find observed strictly by the International Criminal Court.
Okay.
Attorney, bago magsimula itong day 3 ng confirmation of charges hearing, nagkaroon ng allegation na yung mga ICC investigators daw ay pinondohan ng certain political personalities at naglabas nga po ng pahayag yung Office of the Prosecutor, itinatanggi yung allegation. Ito hong mga ganitong developments, I don't know, can we call them noise surrounding the hearing? May effect ba ito at all?
I think what we're seeing here is an attempt to sully the legitimacy of the proceedings. Pero alam mo, yung Rome Statute, meron din yung rules dealing with that, yung obstruction or violation or an attempt to tamper with the administration of justice, no? Nasa Rome Statute. Pwedeng magkaroon ng sanctions ang International Criminal Court dyan, ano?
Sanctions against who?
Against the perpetrators, ano?
Okay.
Pwedeng magkaroon ng ganyan, no? Na magkakaroon ng reklamo, no? Kung magkaroon ng formal na complaint. But I don't think that will actually affect in any way the conduct of the proceedings, in a sense that, you know, the court will stop the proceedings, no? Because of that, no? Besides, the court is really very zealous of its independence, no? As we have seen with the response of the courts, no? But also, you know, look at the kinds of allegations being thrown at it, no? Yung credibility ng mga allegations na yun, dapat tinitingnan din natin kung meron pa talagang basehan. So, it's shot through with contradictions and such, no?
Professor, bago po tayo nag-umpisa kanina, nag-report po, nag-ulat yung aming kasamahan na si Marisol Abdurrahman, at sabi nga niya na syempre yung ibang mga kaanak ng mga biktima naroon, no? Kinakabahan sila kasi first time nilang maririnig kung anong sasabihin ng depensa. Tingin niyo po ba parang tamang estratehiya po ba yun na pagdating sa submission of merits ng depensa na naroon pa rin yung mismong mga kaanak ng mga biktima? Or tingin niyo po ba dapat minsan ipinagpapaliban na lang at iniiwan doon sa mga kanilang abogado na lang na sila ang makinig? Kasi syempre baka maapektuhan din sila sa pakikinig.
Alam po ninyo, sa teorya ng katarungan, no? Actually, it's part of giving justice to victims by actually allowing them to have access.
Okay.
No? Isipin po natin, nasa dahig po yan. At napakamahal ito para pumunta doon. At kaya nga po, meron pong office ng Common Legal Representative for Victims, di ba? Kasi disenyo yan na makikita natin sa ICC lamang. Merong specific na office that takes care of the interest of the victims. No? Dito actually, hindi po sila litigants. No? They are participants, but they are not strictly speaking parties. And that's why they need to have a separate lawyer. And the lawyers, the Filipino lawyers plus the one that heads that belongs to the office of Common Legal Representative, they don't get to decide what strategy will be used by the prosecutor, or whether or not new evidence will be presented, or whether or not the charge sheet will be amended. Hindi po yung pwedeng gawin ng mga victims, lawyers, ano? Pero pwede silang magsabit ng questions with leave of court, no? On a witness, for instance. Pwede rin po silang magsabit ng observations pagdating po dun sa protection ng rights and all that. No? That's why you see Attorney Butuin, Attorney Andres talking on behalf of victims, because that's part of the design of the ICC, that the victims are really given a voice. They only become proper parties pagdating po dun sa question ng reparations. Kasi may personal interest po sila doon, yung injury na personal sa kanila. Didinggin po ng korte yan pagdating doon sa reparation. So doon lang po sila properly parties. Hindi po sila litigants talaga in that sense. No? Iba po yung disenyo ng ICC for that question.
Minsan kasi 'di ba parang may tendency na makalimutan natin na iba talaga yung takbo pagdating sa international court. Kasi ang nakikita lang natin, ang nakasanayan natin, local courts, 'di ba? Parang dalawa lang yung partido, meron ka lang depensa, meron kang prosekusyon, meron yung biktima, meron yung suspect o yung nililitis, yung akusado. So, I guess kailangan importante na tandaan natin na iba yung takbo dito pagdating sa international courtroom.
Tama po, ano.
Attorney, yung latest pa, yung pinayagan ng korte ang dating Pangulo na hindi dumalo sa kanyang hearing on detention. Bukas, I think this is scheduled tomorrow. Tanong ko lang, how is it in the defense's advantage ang hindi pagdalo ng dating Pangulo?
Well, di ba, theory nila, walang jurisdiction yung korte. Na illegal, walang legitimacy in the whole proceeding.
So it's a statement, kumbaga.
It's really consistent with that approach. That they don't in any case recognize the legality and validity of the whole process. And that should supposed to be important because there's a rule in the ICC that you have to revisit every year.
Yes.
The question of whether it's still proper to hold someone in detention, someone who's facing a proceeding, no? So requirement yan, nakalagay sa rules yan, kaya every year. And, you know, I guess that's also their way of saying na we don't really recognize the jurisdiction of the ICC, and besides, you know, I'm being held against my my wish, my volition, and in fact, I was not properly taken to court. I was kidnapped.
Yes.
So whatever you say there, wala naman talagang masasabi kayong maayos dyan dahil in the first place, kinidnap ako.
Tapos, hindi ho kaya, may posible din na ang sinasabi ho kasi ng depensa, the president is frail and weak and incapable of standing trial. Pero sinasabi ng ICC experts, he is fit to stand trial. Hindi ho kaya parang pag hinarap mo sa paglilitis ng dating Pangulo, malalaman ng lahat na he is actually capable.
I think sa issue na yun, hindi kasama yun, no? Yun lang legal basis for holding him in detention.
Okay.
No? But there's a separate rule where the court can always monitor of course, halimbawa, after 2 years, the defense can say, well, this was the situation 2 years ago, but right now, I think that you have to look at the evidence. And the court can once again revisit that question of the fitness of the former president to stand trial. Because it goes into, the principle of due process.
Well, Professor, siguro 2 minuto na lang at mag-uumpisa na ulit, no, yung pagdinig. Ano po expectations nyo dito sa ikalawang bahagi ng pagdinig?
Well, yun nga, sabi ko kanya detailed, no? And I expect the defense to now attack the individual cases to show that these are not part of a pattern killing, nor are they related to policy.
So, kumbaga, iisa-isahin na dapat.
Ay, dapat yun.
Alright. So, titignan natin kung yan ang actually na magagawa nila. Kasi nga, so far, puro rebuttal pa lang ang naririnig natin. So, even kayo po, Professor, talagang inaabangan nyo na kung ano yung mismong maisusumiti pa nila. Maidadagdag pa.
At nire-rebut individual prosecutors.
Oo.
Sinabi ni ganito prosecutor, ganito, but it's not true or hindi consistent. So, anyway, abangan natin kung magkakaroon nga ng direct i-refute isa-isa, individually, yung mga individual cases na binanggit ng prosecution.
Alright.
Prof, babalikan po namin kayo mamaya. Thank you very much. Babalikan po natin mamaya si Professor Bagares.
Samantala, sa ikatlong araw po ng confirmation of charges hearing ng ICC, tinabla ng Lead Defense Counsel ang ilan sa mga argumentong prinisenta ng prosekusyon sa mga nakalipas na araw. Balikan po natin ang mga ipinunto ng prosekusyon sa ulat ni Marizo Mali.
Demonstrates the systematicity of the attack.
Kabilang sa mga ipinunto ng prosekusyon sa ICC, ang pagiging malawakan at sistematiko ng mga pagpatay sa drug war na may pattern umano. Giit ng prosekusyon, ikinasa ito sa tulong ng National Network alinsunod sa isang government policy. At ang mga nagpatupad binayaran, tiniyak na di paparusahan at pinangakuan ng promotion.
Police and those working with them were often paid reward money per kill. Your Honours, these killings were not random. Targets were pre-identified, listed, and then subject to operations based on that list.
Para patunayan ang kanilang punto, binasa o ipinapanood ng prosekusyon ng ilang pahayag o talumpati ni dating Pangulong Rodrigo Duterte.
Giving you 48 hours. Pag nakita ko kayo, papatayin ko kayo dito.
Binasa rin ang pahayag ng ilan nilang saksi, kasama ang ilang nagpakilalang miyembro ng Davao Death Squad sa Davao City na anilay kinabibilangan ng mga pulis, lokal na opisyal at sibilyan.
This witness said that they personally killed hundreds of people. They described their job as the DDS as being, quote, just to kill small criminals, petty criminals. Out of the almost 300 people that I have killed, I never actually got to kill a drug lord.
Para patunayang ginawang nationwide ang dating operasyon lang sa Davao City, ipinakita nila ang memorandum circular ni Bato de la Rosa na inilabas sa unang araw ni Duterte sa palasyo na nagsaad na iniutos umano ni Duterte ang pag-neutralize sa mga kriminal. Kasama rin sa mga ebidensya ang accomplishment report ng PNP at FIDEA.
The administration admitted that 3,967 drug personalities died in anti-drug operations in the first year and a half of Mr. Duterte's presidency. The Philippine Drug Enforcement Agency, or PDEA, admitted that 5,281 drug personalities died in anti-drug operations. These admissions corroborate the widespread nature of the attack. They show that thousands of individuals were killed.
At para patunayang nationwide ang mga patayan, iminapa nila kung saan-saan ito naganap.
Purple dots indicate an area with 1 to 10 killings, while yellow indicates 500 killings. This is how the killings progressed throughout the presidential period.
Ipinaliwanag din ang sistema ng DDS operations. Pinaka-leader si Duterte. Pero may mga co-perpetrators siya, tulad ni De La Rosa. May handler naman ang mga death squad members na karamihan ay mga pulis at mga hitman. Halos iisa lang din anila ang kwento ng patayan. May informant na magtuturo sa target, napapatayin ng malapitan ng mga nakamotorsiklo. Tataniman nila ng ebidensya mga ito at makakakuha na sila ng reward kada napatay. Ang ilan pinapatay sa mismong police operation.
Police often tried to legitimize the operations, so they would stage a Nan Laban or fight back scenario to make them to appear to have been in self-defense.
Ipinakita rin ang mga kasabwat umano ni Duterte mula Davao City na binigyan niya ng mga national position ng maging pangulo para sila rin ang mga siwa sa nationwide drug war. Ipinapanood din ang pahayag nila na pareho umano sa pananalita ni Duterte.
Patayan talaga ito sa drugs. Kaya kayong mga drug lord dyan, humanda na kayo at talagang sasagasaan ko kayo.
Idiniin naman ng isa sa mga abogado ng biktima na mahirap ang karamihan sa biktima. Binasa rin ang ilan sa mga nasambit nila sa kanilang kaanak bago sila patayin.
As recounted by this victim, and I quote, "My son kept repeating, 'Mama, don't leave me.' So I blocked the way. He pleaded again, saying, 'I will come with you, just don't kill me. Mama, don't leave me.'"
Ang kanilang mga naulila umaasa sa confirmation of charges para mabigyan man lang sila ng dignidad. Lalo't kinondisyon daw ni Duterte ang lahat na tama lang patayin ang mga biktima.
For the victims, the confirmation of charges is not merely a legal step. It is a recognition that their loved ones mattered. It is an acknowledgement that what happened to them was wrong. It is a message that they have not been forgotten. These proceedings offer something they had been denied in years: hope. Hope that the truth will be established, that the one responsible will be held to account, that future generations will not endure the same suffering. Justice cannot restore their loved ones, but it can restore dignity.
So, Madam President, Your Honours, before the break, we were discussing Command Circular number 16 of 2016 and the issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. This directive instructed investigative units on how to perform their responsibilities in the case of armed confrontation during the implementation of Operation Double Barrel. The document also included an exhortation to monitor human rights violations perpetrated by PNP operating units. The term neutralization itself is, of course, not defined anywhere in any of these documents as meaning to kill, a point the prosecution itself conceded at that moment in time when it was seeking the opening of an investigation. And I refer, Your Honours, to ICC 01 on 21, document number 7. So, the prosecution, throughout its pre-confirmation brief, invites this chamber to find, by inference, that neutralization means murder, and even carves it in stone as its formal statement of the common plan. But we, the defence, can show that the term neutralization can only mean the use of self-defence where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa, Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, De La Rosa, testifying before the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, "A police intervention in strict accord with the use of force continuum and/or principle of proportionality on the use of force purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect." It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't, because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The court observed that the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP Manual on Anti-Illegal Drugs Operations and Investigation. In other words, the term formed part of the existing police vocabulary. The court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional, especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. the judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
I'm sorry to interrupt, Counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
if I may, Madam President,
Merci beaucoup,
of course,
Thank you very much.
an understanding with the Learned Chamber's legal officers that we would be able to provide references after the hearing. But of course, the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald de la Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 0000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 00090340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part that I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated, and even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief. None of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations, Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will elaborate shortly. The eighth factor, purportedly evincing a plan of agreed criminality, is set out
Mga kapuso, ayan. Muli nagkakaroon yata ng problema ang live stream ng ICC dahil ongoing pa itong pag-argue ni Attorney Kaufman. Iniisa-isa niya, partner, itong mga, kasi nasa number 8 siya ngayon eh. May mga pinupunto siya, mga argumento na para gibain yung mga pinipresenta ng prosekusyon. At
inidiin niya talaga yung paggamit ng salitang neutralize.
Yes.
Ang sinasabi niya, hindi kasi nangangahulugan na to kill. Sabi niya, sa kanyang pananaw, incarcerate, not kill. Yun ang ibig sabihin nung ginamit yung salitang neutralize. At ang sinasabi rin niya na, sabi niya, katanggap-tanggap naman yung pagbanggit o pagtawag sa mga drug user bilang mga, and I quote, beasts pagdating sa political discourse. So parang sinasabi niya, lahat ito very subjective, relative to kung ano man yung interpretasyon ng sino mang nakikinig.
Obviously, very lengthy yung naging discussion ni Attorney Kaufman dito sa paggamit ng salitang neutralize. Dahil ito, the prosecution also relied heavily dito sa salitang ito na ginagamit to mean exactly to kill. Ang sinasabi naman ni Kaufman, hindi, wala yan sa dokumento. Ito sa PNP PNP manual at maging doon sa memorandum, yung number 16, Command Circular 16, series of 2016. Yan mismo yung nakasaad yung Oplan double barrel. Ang sinasabi, hindi dyan nakadefine ang neutralize to mean kill. In fact, ang kanyang, ayan na, nagpaturo na.
Concerning and coming to the 9th category of circumstantial proof for a common criminal plan, the prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published. In 2 government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station was sent for retraining. To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law and written proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan, we turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted, with all respect, in a misleading fashion. The tables used by De La Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not De La Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly supporting the mutually agreed nature of the criminal plan. And this is the fact that the extrajudicial killings, to quote the prosecution's words, followed the same patterns and modus operandi, with the perpetrators covering their tracks. But here, let me ask a question which begs an answer. If the Duterte administration was so barefaced as to openly declare its intent to kill drug users and pushers and celebrate this, as the prosecution argues, in official governmental publications, why would it encourage the perpetrators to go to such lengths to disguise such an intent? I mean, of course, anything's possible. But I'm just pointing out the internal contradiction in the prosecution's case theory. In any event, as they say in English, there is more than one way to skin a cat. And the differing types of modus operandi that we have encountered in the prosecution's 49 incidents of murder involve all conceivable modes of butchery, ranging from strangulation, suffocation, to stabbing and shooting. Now, assuming that the prosecution can overcome the hurdle of proving the existence of a common criminal plan, how has it shown that the so-called co-perpetrators coordinated between themselves to reach a mutual agreement to execute it? Well, it hasn't. All it can do is show a selection of comments made by Mr. Duterte's closest colleagues in government, and all of which take their rhetorical cue from him. The prosecution then artificially defines the intended individuals, the identified individuals, as a collective of co-perpetrators. Now, common law jurisdictions, such as the one I come from, are familiar with these issues in the context of the law of conspiracy. The federal rules in the United States, for example, allow the statements of co-perpetrators to be used as circumstantial evidence, one against the other, to establish the existence of a conspiracy, but require that these statements be made during and in furtherance thereof. Narrative venting, which is what all these supposed co-perpetrators did, the ones identified by the prosecution, does not further the criminal objective. In furtherance thereof means that the statement relied on must advance the objectives of the conspiracy, such as through reassurances, updates, or actions taken to avoid detection. Now, I do realize, Your Honours, that there isn't too much jurisprudence on this matter, but let us look at it logically. Where can one really draw the line if it is sufficient to infer a mutual agreement to execute a criminal plan if we rely only on the statements of the people in the vicinity of a criminally verbose suspect because of the same quality of verbosity it alleges? This is what could be called bootstrapping logic. building on limited information with the very same information in an attempt to validate that information or to create a structure there without. Put simply, the prosecution has advanced its cart before its horse. It has merely selected a number of individuals working alongside the former president who made similarly offensive comments and has then called them co-perpetrators. Instead of seeking evidence which might shed light on the interactions of these individuals between one and another, and construing a criminal conspiracy therefrom, should the evidence even support such a hypothesis, the prosecution has taken its preconceived and predetermined premise of a criminal plan and forcibly superimposed it on these individuals. The artifice of the prosecution's working methodology in conjuring up this criminal collusion becomes even more apparent if we examine the evidence emanating from the crime-based perpetrators themselves on a granular level, especially from the prosecution's own star witnesses, 2 of 3 of whom supposedly formed the hardcore of a more limited organization referred to earlier in my submissions. I'm trying to comply with redactions. P1, for example, a self-confessed murderer whose recruitment by the prosecution will be examined elsewhere, was asked about the common criminal plan of his associates up to 2017. And this is what he had to say. Every time somebody was at fault against the government of Rodrigo Duterte, we didn't bother to send them to prison. We would just kill them. That's PHL OTP 0001 2584 at lines 248 to 250. Okay, and that was the audio which I just quoted, and here we have the transcript. PHL OTP 0001 2376 hyphen R02, lines 248 to 250. So, having given you that quote from P1, I would say that as far as this witness was concerned, the common plan was not a refined policy of cleaning up the streets, but rather a killing frenzy of the political opposition. Obviously, no such policy existed, and no such policy is alleged. P3, whose evidence relates to the presidential period, describes a similar orgy of killing without rhyme and without reason, but not drug addicts, nor alleged criminals, but rather
Mga kapuso, yan po ang pagpapatuloy pa rin ng pagdinig sa ikatlong araw ng confirmation of charges hearing ng pretrial chamber. Mga kapuso, minsan po talagang nagkakaroon po ng mga bahagi ng hearing na talagang hindi na ine-ere o hindi na sinasama sa live stream. Ito po yung mga posibleng redaction. Yun po yung mga parte kung saan minsan may mga pangalan na nababanggit o di kaya hindi pwedeng isa publiko, kaya sadyang nire-redact o hindi na ipinapakita ito sa live stream. At paglilinaw nga po kasi ito po ay 30 minutes o 30 minutong dinedelay ang live stream para nga po sa ganitong purpose, no? Para kapag may mga binabanggit na hindi dapat isa publiko, may pagkakataon po na magkaroon ng redaction. At sinabi nga po ni Attorney Nicholas Kaufman na sinusubukan niya mag-comply sa redaction. Kanina po, may ilang beses naman na hiniling ni Judge Julia Motok na banggitin ni Kaufman yung mga partikular na dokumento na kanyang binabasa o ipinupunto kasi may pagkakataon na binabanggit lamang niya yung mga dokumento pero hindi niya nasasabi kung saan mismo galing ang mga ito. Pero sa pagpapatuloy po no, ng pagdinig, isa po sa mga nabanggit ni Attorney Nicholas Kaufman, sabi niya, Duterte, if he was so barefaced in his declarations, bakit pa raw kinailangan na magkaroon pa ng disguise yung mga perpetrator? Ibig sabihin, kung talaga namang ipinag-utos daw ni dating Pangulong Duterte ang mga pagpatay, bakit pa nila kailangang mag-disguise o mag-iba ng anyo kapag sila ay nagsasagawa ng ganitong mga klaseng aksyon? So yun ang isa sa mga ipinunto niya. At sinasabi rin niya, no, yung PNP Annual Report 2016, yun yung isa sa mga kinote niya. At partner, di ba sabi nga niya, parang these are testaments to former President Duterte's respect for the rule of law.
Ayan. Napansin ko naman, may mga punto si Attorney Kaufman na talagang very lengthy yung kanyang discussion. Isa sa mga idadagdag ko dyan sa mga binabanggit mo, yung paggiba niya sa role ng co-perpetrators. Basically, binibreak niya yung linkage between the co-perpetrators and the former president sa kanilang pagbuo ng tinatawag na common criminal plan. Dahil apparently dito nakasalala yung alegasyon ng prosecution na along with the co-perpetrators ay gumawa sila ng isang common plan, ng isang national policy para gumawa nitong mga pagpatay. Anyway, let's call in Professor Bagares. Sir, welcome back.
Hello, magandang gabi na uli sa inyong lahat.
Yes, again, so far, ano yung naging observations mo?
Well, kanina, bago nagsimula uli yung kanyang presentation, nabagit ko yung manual of operations, di ba?
Yes, correct.
At nag-focus siya. At nagulat ako na hindi yung kasama sa ebidensya na present nung prosecution, according to Attorney Kaufman. Ano? Actually, 2 punto yun. Yung sinabi niya na hanggang ngayon wala pa rin decision yung Korte Suprema. Actually, si Attorney Buto yun tsaka si Attorney Andres involved sa kaso na yun. Sila po yung kasama sila sa nag-file ng petition na yun, no? Yung writ of amparo. Yung manual of operations na binamagit ni Attorney Kaufman, it's the same document that says that every time somebody is killed in an operation, you need to generate an inquest. And there are at least 40 documents, pre- and post-operations, that you need to submit in that inquest. 6,000 deaths, not a single report.
Okay.
And that's actually what the petition was trying to tell the Supreme Court. Now, remember, there's an issue here of complementarity, and it goes into that question. After 4 years, hanggang ngayon, wala pa rin decision ng Korte Suprema natin, no? With due respect to the Supreme Court. But that's a fact that was actually also highlighted by Attorney Kaufman. Yes. In other words, walang remedyo talaga sa Pilipinas kasi kahit yung Korte Suprema, 4 years ng petition, hanggang ngayon walang decision. But the constitutionality of the Tokhang operations of the PNP, ano? And then secondly nga, yung statistical presentations, the arguments, I think that can be easily dismantled by the prosecution. You just look at it right this way. Yung language mismo ng manual, sabi din ni Attorney Kaufman, continuing from arrest to use of force, right? Tapos sabi niya 100,000 arrest. Think about that, 6,000 every non-laban case, patay, ang galing bumaril ng mga PNP. Every single non-laban case, patay, 6,000. Yun yung eksakto 6,000 non-laban cases or death under investigation. You can say that all of these things are deaths arising from killings.
Attorney,
for the one time, big time.
Attorney, sorry to interrupt. Nagpapatuloy na po ang rehearing.
Sige po.
Now, I ask you, how can P3 have been operating under a clear criminal direction to target drug users for murder, criminals for murder, when he states that on occasion he would perform so-called clean arrests? Prosecution's witness, P3, is not clear when he's actually following their supposed criminal theory or when he's is. What are clean arrests? These are arrests subsequent to which the apprehended criminal would be handed over for a judicial process. And so with that, I believe, I have exhausted the first limb of the objective requirement for indirect co-perpetration and have shown conclusively that there was no mutually agreed common criminal plan. Madam President, there are 10 minutes to go. I will start with the concept of essential contribution, which is indeed the second limb that I want to talk about with respect to this mode of liability, which requires the prosecution to show objectively that Mr. Duterte himself made an essential contribution to the furtherance of this scheme of criminality, and what is more, that subjectively he was aware that he was making such a contribution. This is what us Latin-speaking lawyers, would call the sine qua non test. Or to put it another way, did these 49 murders, which the prosecution has identified, occur specifically because of Rodrigo Duterte's involvement? Or, to make the logic a whole lot simpler, would Rodrigo Duterte's withdrawal from this criminal scheme to target suspected criminals, as alleged by the prosecution, have led to the avoidance of these 78 deaths? Let us see where this test is set out in the Ali Koshaib trial judgment. Paragraph 796. And I'm going to quote the essential part for the purpose of the essential contribution. The accused must make an essential contribution without which the commission of the offence would not be possible. To hold an accused liable as a co-perpetrator under Article 25(3)(a) of the statute, it has to be established inter alia that he or she had control over the crime by virtue of his or her essential contribution to it and the resulting power to frustrate its commission. Well, here, I would like to show you the statistics pertaining to the rate of killings since the former president has left power and the responsibility for law and order has passed into the hands of President Ferdinand Marcos Jr. I rely on a report published by academics at the Third World Studies Center in the University of the Philippines in the context of what is called the Dahas Project. And trust me, the authors of this report, comprising weekly statistics on the first year of the Marcos administration from 2022 to 2023, are no great friends of the former president, Mr. Duterte. This report was even cited, I remember, in a Rappler article, but it's to be found on our list of evidence at PHL D36 0006-0001, pages 006 to 0010. The report for the first year of the Marcos administration showed that out of 342 killings, 160 were at the hands of state agents. And the figures and the statistics just kept on rising, with the second year of the Marcos administration, 2023 to 2024, showing an increase in deaths at the hands of vigilantes, albeit a decrease in deaths at the hands of law enforcement officers, from 46.8% to 34%. Hardly a statistic to be proud of. So, with all the prosecutions, fancy bar charts, I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. The conclusion is that there is no reason to believe that Duterte's disappearance from the political scene would have frustrated the ongoing incidents of murder at the hands of state agents or vigilantes. Clearly, I'm forced to ask myself whether anyone on the other side of this room has thought of investigating the Marcos regime and the related phenomenon and holding someone accountable. Why are my colleagues sitting to their right, the victims' representatives, not clamoring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention center? I've reached a natural break, Madam President, in my submission. With your permission, I would like to continue after lunch.
Judge Motok. Thank you very much, Mr. Kaufman. We will suspend the hearing now for 90 minutes to resume at 2 p.m. Thank you very much.
Ayan, nakasalukuyan na pong tumawag ng lunch break ang confirmation of charges hearing. Partner na nagtapos ang pagpresenta ng Defense Counsel ng dating Pangulo sa kanyang pag-question dun sa paglilink sa dating Pangulo sa mga murders. Dahil sinasabi niya ngayon, pagbaba ni Pangulong Duterte, ganun pa rin naman, mataas pa rin ang bilang ng mga namatay. So, ibig sabihin, wala siyang kinalaman doon.
Oo, kasi binanggit niya, di ba, pagdating ng unang taon ng administrasyon ni kasalukuyang Pangulong Bongbong Marcos, out of 342 killings, 160, sabi niya, killed by state agents. Tapos tumaas pa raw noong 2023 yung bilang ng mga pagpatay ng mga tinatawag niyang vigilante. So parang yun yung ginagawa niyang comparison, no? So, maganda tanongin natin si Professor Bagares, gaano ba kahalaga yung ganitong kailangan banggitin pa, no, at magkaroon ng comparison sa administrasyong Duterte at nitong administrasyong Marcos?
Ito ay suporta do sa argumento niya na essential contribution. Ano ba ang naging kontribusyon ng dating Pangulo dito sa mga iniuugnay sa kanya na mga murders? Andiyan na ba si Professor Bagares? Professor?
Magandang gabi ulit.
Professor Bagares, please tell us more about essential contribution. Bakit nagdodwell dito si Attorney Kaufman?
Well, kasi nga, important element po yun ng common plan and joint control. Criminal intent. Yun kasi yung important element ng indirect co-perpetrator theory ng prosecution. Na kung wala yung si Presidente Duterte, walang ganong klaseng drug war. No? Kasi mangyayari lamang yung kung Presidente si Duterte at siya yung nag-utos, siya nag-design, siya rin nagtalaga ng mag-i-implement ng policy. Yung argument actually is more rhetorical really kasi hindi naman on trial yung Marcos government dito. Yung kaso tungkol sa Duterte, di ba? So irrelevant actually yung point na yun. Ang pinag-uusapan dito, ano yung ebidensya na patungkol sa nangyari nung si Duterte ang presidente? Sa pinyong Marcos. So that's actually, you know, what we call what aboutism, di ba?
Okay.
Hindi yun para it's a logical fallacy basically. But it strikes like emotional response. If you're not careful. Ano. Pangalawa, meron siyang sinabi tungkol dun sa wala kahit isang tao, witness, kahit na yung mga bumaliktad, sabi niya, that tied the president directly, no, to the killings na narinig. Actually, hindi kailangan yun sa ICC kasi nga, sa jurisprudence ng ICC, ang common plans and linkages, makikita yan sa mga official documents, policies, minutes, public speeches, patterns of conduct, coordinated implementation across regions, chain of command structures, forensic and contextual evidence, testimony of victims, intermediaries, and experts. Kasi nga naman, yung madalas mangyari yung pinuno, mag-uutos lang yan sa sikreto, di ba?
Yes.
Hindi mo maririnig yan kasi yung mag-o-implement sa baba. Kakaiba nga dito sa kay Pangulong Duterte, according to the prosecutor, the allegation is that there was an inner circle and people were there, and that it was all replicated in a national scale, and then there are documents, no? So in the cases before Lubangan, similar cases, the court recognized that characteristic of what happens when you have people at the high levels of leadership who are part of a common plan. They don't usually say things to the people below, okay, you kill, no? So hindi yun ang required element ng common plan, establishment of a common plan.
Actually, Prof, I was going to ask, ano ba ang evidentiary proof? Kasi nakikita natin, very lengthily nag-discuss si Attorney Kaufman dito sa pag-question sa conspiracy between the co-perpetrators and the former president, na wala naman daw para maipakitang ebidensya na bumuo nga ng common plan, nagsabuatan itong mga co-perpetrators para dito sa mga pagpatay na ito.
So yun nga, sinabi ko kanina, di ba, official documents, policies, circulars, minutes, public speeches and statements, pattern of conduct, coordinated implementation across regions, chain of command structures, forensic and contextual evidence, and testimony of victims, intermediaries, and experts. So yun mga things that the prosecutors need to show to establish common plan. At nung the first 2 days, yun ang ginawa nila.
So the fact na in-appoint ng dating Pangulo ang mga dati niya mga tauhan sa Davao and put them in national positions to carry out the same plan, sa tingin niyo po sapat na yon?
Yun ang sinasabi ko, no? Na may na-establish yung common plan sa ganung klaseng paglalatag ng prosecutor. Yung again mahaba yung discussion niya sa world and neutralization, ano?
Yes.
Talagang yun nga sa manual, and as I said earlier, na-suppress ako na hindi kasama yun sa ebidensya ng prosecutor. Pero tingin ko importante yun kasi yung ang kasong binabanggit sa Korte Suprema, yung documentation kasi na required sa police pag may namamatay sa police operations. Sabi ko nga, at least 40 documents yan, pre and post. What does that tell us if 6,000 incidences, there's not one report that the PNP can produce? May ano ibig sabihin nun? We can excuse, as I said, maybe kahit 100 na hindi na-produce, di ba? Pero 6,000. And then yun nga, of all the self-defense cases nanlaban, lahat patay, no? Statistically, that's quite questionable, no? Na pare-pareho yung pattern. So I would have expected the prosecution actually to include that in their submissions. Na yung requirements mismo, that manual of procedure actually was drafted with a grant from the European Union, no? At bago naging PNP chief si Senator De La Rosa ay nalatag yan. Nagkaroon mga revisions pero part talaga yan ng professionalization ng PNP nung panahon ni Professor ni Pinoy, ano? At yun dapat yung sinusunod ng PNP. Kaya nga nakalagay doon na tuwing may namamatay sa police operations, kailangan may inquest yan. Tapos 40 documents dapat ang sa each case of killings, no? Whether self-defense or encounter, kailangan idaan mo sa inquest yan. So tatanungin dapat prosecutor, sino yung head ng PNP nung time na yon? Sino head ng DOJ nung time na yon? No? Bakit walang na-generate na inquest report for all of these 6,000 cases? At bakit every time na mayroong nanlaban, patay lahat, no? 6,000.
So these things that you're mentioning, attorney, pwede pa kayang erase ito during the trial? Should this go to trial?
Pwede siguro nilang, I guess sa cross-examination, pwede nilang introduce na nun. At I think sa closing statements, dapat i-address ito. Ano?
Right.
But as I said, no, walang control sa theory at saka sa amendments yung victims' lawyers dito. This is wholly the show of Office of the Trial of the Prosecutor of the ICC. You know, I could understand why they did not include that, precisely because the arguments made today by Attorney Kaufman. You have to give it to him.
Yes,
he is really, you know, the kind of criminal defense lawyer that you would like to be on your side.
Yes.
As we have seen in the argumentations he made today, they're quite strong. And I'm sure that a lot of people must have actually paused a bit listening to him and saying, "Parang totoo yung sinasabi niya, Kaufman."
In support of his efforts to question this common plan, meron ho sa mga binanggit na statistics Doon ho sa mga sinasabing deaths daw, ito raw ay small fraction lamang. 3% lang daw ang deaths. In fact, 85% ng arrests. The rest are voluntary surrenders. 1,900 daw yung investigations. May na-dismiss na 375 na kapulisan. Ano naman ang take niya dito?
Well, yun nga, yung comparison might not be rather appropriate kasi yung issue kasi dito is ang claim ng police lahat yan self-defense, And lahat ng nanlaban patay 6,000. Pag kinumpara po natin sa giyera, the entire time na for 20 years na yung pong the US was prosecuting its war on terror in Iraq for 20 years. Ang namatay po over the 20 years, bakbakan pa po yan, may bomba, may machine gun, about 4,000 or 5,000 soldiers. Over a span of 20 years. Ito po in just yung 6,000, I think that's the initial figure for the first 3 years, at paulit-ulit po yung kwento, na nanlaban and self-defense. The accuracy of the police will defeat the record of a lot of of people who have who are highly skilled in shooting, in target shooting, given the circumstances of the case. So those things should be highlighted by the prosecutor. Yung lack of reports. Why is there not a single report on inquest made on all these killings? When the people that Duterte appointed to office were the ones controlling these agencies. Because remember, there's a requirement. You should be able and willing to investigate all these killings, pursuant to our obligations under the Rome Statute at that time, because we were part of the Rome Statute, we had that obligation.
Yes.
So yun yung complementarity doon So that's why I was surprised to hear from Tony Kaufman. I don't know if he's telling the truth, maybe perhaps because it's access to the documents of the other side, right?
Yes,
to hear from him that manual was not submitted by the prosecution as their own evidence.
Attorney, meron ding Pia, would you like to? Sige.
Yeah. Actually, attorney, gusto ko sanang balikan yung sinabi nyo kanina na yung pagkumpara, yung pag-bring up or pagbanggit sa Administrasyong Marcos. Sabi nyo, irrelevant point po ito, the comparison. Ibig po ba sabihin ito automatic na hindi ito bibigyan ng kahit anong diin ng mga judges?
Well, ang magiging objection nga ng prosecutor dyan, that's really relevant because what is being tried here is the Duterte the time when Duterte was president. And nevertheless, in fact, he actually shows that the same report actually faults the Marcos administration and saying that the killings have not stopped. I've actually read that report, I think, at some point when I was reading up on these cases. And the same report actually also calls on for an investigation on the Marcos administration, why it's not doing what it should have done, despite its decision to surrender Duterte. And it's actually good that Attorney Kaufman brought that out, because from the standpoint at least of policy, we're not talking about this trial, but the policy of the government today on the drug war must also be revisited, precisely because we have this case, right? If we have this case, why are the killings still happening according to that report?
So ano pang ina-expect nyo, Attorney Professor Bagares, kapag balik nito after the 90-minute break?
Yung kanina sinabi ko, yung sa mga individual cases, kasi kailangan niya ipakita nga. So hindi pa, parang nagsisimula pa lang siya doon. At yung mga allegations na may pattern talaga ito, I think he might want to address that, Kasi meron pa siyang mahaba-habang time mamaya. But what we can say right now really is that Attorney Kaufman really prepared for this, no? And he has strong points about his arguments. And it's very, very persuasive when he's presenting that, especially with respect to the question of neutralization. No? So siguro yung issue ng nanlaban, dapat i-focus na yun. Talaga bang self-defense ito? Kasi nakikita ko yung argument niya nga ganito eh. May policy. Yung policy hindi yan para patayin ang mga tao. Pero merong nagdi-deviate talaga dyan. At hindi yung kasalanan ni Duterte. In fact, merong prosecution, di ba? Kian de los Santos. So binigit niya na kanina na merong na-dismiss na police at merong prosecute. Ano? And maybe he will go into further detail on that. Kasi yun yung argument niya. The policy itself does not tell you that it is a criminal document, meaning it has criminal intent. No? But it's just that there are people who exercise the discretion improperly or they deviated from the policy. And the deviation cannot be attributed to the president. That's his argument.
Pero Professor, para linawin lang din po natin muli, no? Kasi dito sa punto ito, hindi pa talaga natin nililitis yung kaso. Parang nandun pa rin tayo doon sa whether or not there are substantial grounds to pursue with an actual hearing. So, kayo po, base sa nakikita po ninyo sa paglatag ng ebidensya so far, meron ba kayong mga leanings at this point?
Well, gusto kong sabihin din na hindi lang indirect co-perpetration ito. Diba? May dalawa pang alternative mode. Saka kalimutan natin.
Yung aiding and abetting.
Ordering. At saka yung aiding and abetting. Kasi kung pwede kasi hindi siya mag-confirm doon sa una. Or pwedeng depende sa ebidensya. Actually, yun yung gusto ng ICC. Pwedeng merong indirect perpetration for one set of for one count, merong ordering and inducing at meron ding aiding and abetting. Kasi remember, may allegation din na nagbibigay ng reward tuwing may namamatay. And that's aiding and abetting. Kasi ibig ng aiding and abetting pwedeng hindi siya yung architect ng pagpatay. Merong inner circle na gumawa, nag-decide na sige, gawin natin tong gusto ng presidente, pero hindi naman yun ang intention ng presidente. Pero nung nalaman niya yun, at may namatay, sige, sabi niya, okay, magre-reward ako sa inyo. Accessory crime yun. But nevertheless, it's still a crime and part of crimes against humanity in the Rome Statute. No? So, tatlo, actually, isipin natin, there are three modes of liability here. The first one, which is what we are most familiar with, is indirect co-perpetration. But there's also ordering and inducing. Nag-utos siya, at tumalima yung mga inutusan niya, may pinatay. At yung pangatlo, yung aiding or abetting, at hindi sila mutually exclusive, depende kung ano yung kaso at ano yung ebidensya.
And has the prosecution established that sufficiently sa tingin ninyo, Attorney?
Well, I think kahit doon sa aiding and abetting, meron, no? Kasi may nilagay na sinabi na nagpalabas ng reward system yung Pangulo, no? At lalo na doon sa one-time victim. Yun yata yung last na point ni Attorney Kaufman, ano? Na gusto niya yun yan, natutuwa siya at merong mga reward system na in-implement na ini-institute for that, no? That does not require of the president that he be the author and architect of a policy. It's just that he came to know about it and he supported it and provided material, moral, financial support for that policy that he was not responsible for.
Attorney, dito naman sa overall defense strategy, if I may call it that, hindi po nire-refute ng depensa na nagkaroon ng mga pagpatay. But they are justifying it or pinning it on somebody else.
Yes.
Tama po ba yung, from a non-lawyer, ganun po yung nakikita ko.
Yes. Tama po yun, may pagpatay, pero hindi si Pangulong Duterte may kasalanan dyan. No? May policy, pero ang policy hindi sa pagpatay. Kung may pagpatay man, dahil yan sa number one, nanlaban. Pangalawa, yung gumawa niya na hindi sumunod sa tamang proseso. At pangatlo, yung mga hindi sumunod sa tamang proseso, we prosecuted them. Pinala namin ang kaso, tinanggal namin sa serbisyo.
Did you expect this? Did you anticipate this direction?
Yes, in fact, that's really the standard, part of the bag of tricks of the defense for cases like this. No?
Right.
Sa bag, ganun din yung arguments, no? Na argument ang babaw sa COMPLA, wala. Ang basehan niyo puro reports, puro media reports, human rights NGO reports, mga hearsay, no? Pero wala kayong malinaw na policy na yung papakita na talagang merong sinabi at essential contribution doon sa common plan. There was a state machinery deployed by that common plan and by that joint control. So
Hindi umubro yung inference lang, no?
yes. Nakikita mo na ito sa ibang kaso din na nagkaroon ng acquittal in that case. Although may confirmation of charges. So it's also quite possible no, na magkaroon ng confirmation of charges dahil nga it's just substantial ground. Pagdating sa trial, ibang usapin naman yung kung masasatisfy mo na guilty beyond reasonable doubt.
Alright, salamat Professor. Mamaya babalikan po namin kayo, Professor. Hingi lang po muna tayo ng update mula po sa ICC. Sa The Hague, naroon pa rin ang aming kasamang si Marisol Abduraman. Marisol, anong latest dyan? May mga lumabas ba? May mga nakausap ka during the break?
Pia, oo, actually kanina pa tayo nakaabang kasi ganitong nangyayari dito kada break. Nag-aabang tayo ng mga lumalabas at may hinga ng mga reaksyon at mga updates na nangyari nga doon sa pagpapatuloy pa rin itong hearing sa confirmation of charges. Earlier, nakausap natin kanina si Attorney Sal Panelo pero napakabilis lang. Wala siyang masyado pang naibigay sa atin na detalye. Basta ang sabi lang niya, the defense team of the former president did not disappoint me. So babalikan natin siya mamaya para ipa-elaborate natin kung ano-ano doon yung mga striking na presenta nitong si Attorney Kaufman para mapabilib nga sila dito sa naging presentasyon ng defense team ngayong araw. We're trying to get Attorney Nery Colmenares pero naunahan lang tayo ng iba kasi ang nangyayari dito, Pia, pagka may lumalabas na mga pwede nating ma-interview, especially the family, yung mga lawyers, nag-uunan tayo naghahatakan dito na para makapaname sila. Hopefully, in few seconds, makukuha na natin siya. Pero mabanggit lang natin, Pia, tahimik pa rin ang buong paligid ngayon ng ICC, except of course, na nananatili pa rin dito mga taga-suporta ng dating Pangulo. Meron nga dito mga nagsinating galing pa sa ibang bansa, galing pa ng France, at sa iba-iba pa lugar na dumating ngayong araw lang daw dahil ngayon nga nagpapakita sila ng kanilang suporta. Bukod sa kanilang ginagawang the usual na tipon-tipon ng salo-salo, hindi nga lang natin maipakita sa piano but sa isang side doon, sa daanan papunta dito, inside the ICC compound, meron sila doon mga ginagawang exhibit. Yun naman daw yung isang paraan ng taga-suporta ng dating Pangulo para maipakita nga ang kanyang pagmamahal dito nga kay dating Pangulo. At kanina naman, meron din tayong mga nakita dito na ating mga kababayan na galing naman from Canada. Wala raw silang kinikilingan, hindi raw sila anti, hindi raw sila pro, hindi raw sila taga-suporta, hindi raw sila kontra, pero sila raw ay para sa katotohanan lamang. So, Pia, aantabayanan pa rin natin ang mga kaganapan dito. Unfortunately, medyo napako si Attorney Nery Colmenares doon. Sayang siya nga, maganda nga sana makakuha tayo ng update sa kanya. Pero we'll try again in a while, Pia, at patuloy tayo mag-aantabay pa rin dito sa mga kaganapan sa ICC. Balik muna sa inyo.
Marisol, yung mga nakakausap mo dyan sa paligid ng ICC at sa labas ng ICC, nakakapag-monitor din ba sila doon sa mga nangyayari sa loob habang naghihintay sa labas?
Yes, alam mo, Pia, karamihan dito, if not all of them, na nakaantabay lang dito sa labas, nagmo-monitor sila sa live streaming. Although we understand meron siyang 30 minutes delay, pero talagang nag-aabang din sila talaga, nagmo-monitor din sila sa mga nangyayari doon. Kaya kahit yung mga sabi nga ng mga ordinaryong taga-suporta lang, or ordinaryong kumukontra lamang doon sa dating Pangulo, ay talagang nakatutok pa rin doon sa nangyayari doon sa loob. Kaya sumasabay din sila sa atin. Kung meron tayong mga, Pia, I think Attorney Colmenares is already available. Attorney, sorry, naunahan ako. Sabi ko, naunahan ako sa iyo.
Oo, kasi this.
Anyway. I'll just make this fast kasi I believe pabalik na kayo, Very quick lang, Attorney. Although I believe may mga tanong po sa studio si Pia. Gusto ko lang malaman, kumusta po, ano masasabi po ninyo sa defense team na naglatag na ngayong araw ng kanilang mga ebidensya at
except
argument?
for some political statements and propaganda, medyo legal na ang discussion ng depensa ngayon.
Okay.
Yun nga lang, mahina pa rin ang pagkalahat niya. Kung tama ang mga sinabi namin noon pa na walang ebidensyang maipresent si President Duterte sa trial para sabihin na wala siyang kinalaman sa trial. So ang ginawa na lang talaga nila, instead of presenting evidence then to say that, yung akin na lang sa ebidensya ng prosecution. At I think it's still weak. Kasi dapat makumbinsin niya ang court based sa arguments niya. Na una, maliit lang naman pala na bahagi ng populasyon yung pinatay niya, di ba? I doubt if the court will... Oo nga naman, 7,000 lang pala namatay dyan I doubt kung sabihin niya na hindi yan attack sa populasyon kasi very very defined naman yung drug suspects. Hindi naman yung buong populasyon ng Pilipinas. For me, wala namang requirement na buong populasyon. Basta attacks on civilians. At pangatlo, ay yung mga sinasabi niya na hindi binabanggit na sa speech ni President Duterte, minsan, hindi sa lahat ng speech, minsan may mga ending siya na sinasabi niya, self-defense dapat, di ba? I doubt din na panigan niya ng korte, makumbinsi niya ang korte dyan kasi haba ng speech mo, gaano ba kahaba si President Duterte mag-speech? 1-2 oras, tapos yung buong 90% ng speech mo, kill, patayin mo yan, huwag kayo mag-alala, ako ipapardon ko kayo, i-amnesty ko kayo, bigyan ko kayo ng reward. Tapos sa ending, magsingit lang siya ng isang sentence na, self-defense naman tapos na yung sabi na ng korte, absolve ka pala kasi sa ending ng mahaba mong speech, sinabi mo self-defense. I don't think makonvince niya ang court yan. So para sa akin, medyo mahinang exposition ng depensa, pero mabuti na rin na pumunta na sila mainly sa legal except for some political statements.
Okay. Attorney, are you saying na despite the presentation, although nakabreak pa lang naman, may mga susunod pa siyang oras, still he was not able to debunk doon po sa charge talaga na si the former president talaga ang nanguna, nag-utos, at allegedly may mga money reward pa dito sa mga pagpatay.
He tried to debunk that by saying wala namang ebidensya ang prosecution ng common plan. Nag-usap-usap ba itong 8 co-perpetrators at si President Duterte para pag-usapan at nag-agree sila? I don't think may requirement na kailangan magkita silang 8 ng sabay-sabay. Pwede namang kausap ni President Duterte si Aguirre at si Bato. Aguirre, Bato, ito gawin natin. Yes, sir. Kausap naman si Albayalde at si La Peña. La Peña, hindi mo masabing walang agreement sa common plan. And secondly, I doubt kung makonvince niya ang korte na itong nangyari sa Pilipinas, itong libo-libong patayan, walang common plan yun. Walang nag-implement doon. Na parang there are thousands of policemen na may problema sa utak na pumatay lang ng addict randomly na walang nag-utos sa kanya. Parang imposible kahit sino makikinig nun. I think the court talagang sasabihin, hindi pwedeng mamatay yung libo-libo. All over the country, very systematic na walang common plan at walang order sa subordinates. At hindi pa napoprosecute, hindi pa na-imbestigan except for some, sacrificial lambs. So, pattern yun A pattern yun na sa tingin ko, ang sasabihin ng korte dyan, no, there is a plan. Hindi pwedeng random ito na parang by chance lang na namatay itong mga kaanak ng biktima.
Alright, at punta naman ako doon sa mga families ng mga victim. How are they? Kasi kanina earlier, nung bago sila pumasok, nakausap natin, medyo may kaba sila this time na defense team time na.
Yes,
unlike before na they were 100% confident. Pero kanina medyo nagkaroon sila ng konting agam-agam na baka hindi nga naman ito mauwi doon sa pag-usad ng kaso. Based on your observation, how are they po during this third day of hearing?
Lahat naman kasi hindi natin alam kung ano sasabihin ng depensa. So of course, medyo ano kayang sabihin niya, no? Pero nung ang narinig nila actually, parang may mga nag-comment kanina doon na parang mini-minimize niya ang amin kasi maliit lang daw na number, hindi naman daw attack on the population yan. Parang yung pagkapatay sa anak ko, parang ano lang yon, parang napaka-minimal. Parang hindi naman natatama. So yun ang sabi ng iba na parang nasaktan sila doon, no? So in any case, ang sabi lang naman namin ng mga abogado, siyempre kailangan niyang i-minimize yun kasi to prove na hindi crime against humanity ang kaso. So in any case, naintindihan naman nila na ganun talaga yan sa bakbakan sa trial, may tatamaan dyan, of course. Nag-aaway siyempre ang prosekusyon at ang depensa, pero ang biktima siyempre sila ang tatamaan diyan sa trial.
Basta as far as you are concerned, so far, attorney, you're saying is mahina ang depensa.
Mahina ang depensa. As far as the victims are concerned, maybe we should ask them later kung kamusta naman ang lagay nila.
We will. Alright. Pia, baka may karagdagang tanong pa po para kay Attorney Colmenares.
Yes.
Oh, I'm sorry. You have...
Attorney Neri, sir? Si Ivan, good evening mula sa Pilipinas.
Hi.
Si Ivan, napakahaba ho nung diskusyon ni Attorney Kaufman.
Si Ivan. Hi, Ivan.
Good evening from the Philippines. Napakahaba po na naging diskusyon ni Attorney Kaufman sa pakahulugan ng word na neutralize. Hindi
Yes.
naman daw ibig sabihin patayin,
Neutralize.
arestuhin o tanggalin yung threat but not kill.
Well, ang pinagbatayan niya lang doon sa neutralize, hindi yung normal na pakahulugan. Kasi intelligence or military term kasi yan eh. Ang pakahulugan dyan, normally sa Pilipinas, sabi nga ng prosecution, kahit dito sa Netherlands, pag neutralize, patayan. Patayan.
Pero ayun nga, yung
Nawalan
of course,
daw ako ng audio.
we
Ivan?
expect an exchange of arguments dito, sasabihin ng depensa ganito, sabihin ng prosecution ganito. May kanya-kanya po silang mga posisyon. But of course, wag po tayo maliligaw.
Nawalan-
Ito ho ay
nawalan ng
confirmation
audio
of charges. Pinag-uusapan dito kung dapat bang litisin si dating Pangulong Duterte.
Very interesting yung sinabi ni Attorney Nery Colmenares, no? Kasi nga, di ba, parang sinasabi ni Attorney Kaufman na ang punto nila dito ay parang may mga bahagi ng speeches ni former President Duterte na sinasabi niya na we're not telling you that you should kill completely, sa ganyan. Pero ang pinupunto ngayon ni Attorney Nery Colmenares, 90% of the speech, yun ang sinasabi niya. Tapos hindi mo naman daw pwedeng baliwalain yung 90% of the speech na ang sabi ni Attorney Nery na kill, kill, kill with just one statement. Diba? So parang yun yung parang
Actually,
talagang ipinunto ni Attorney Colmenares base dun sa mga napakinggan niya habang nasa loob.
Gusto ko rin
Opo, ibalik
itanong
mo.
din sa kanya to kasi nung if you remember nung opening statements, binanggit ni Attorney Kaufman yung salitang cherry picking.
Oo.
Para bang pinipili nyo lang yung mga speech niya na makakatulong sa naratibo ninyo, sa mga ebidensya ninyo. Ngayon, parang ganun din naman ang ginagawa niya. Even the statistics that he's been citing, of course, are those that will support his position. Itanong din natin kay Attorney Nery kung mababalikan pa natin siya. Ano sa tingin niya ang Attorney? Attorney Nery?
Hello, nababalikan niyo na ako. Hello, yes, nandito na
Ang
ako.
problema, hindi natin
Yes,
narinig
oo.
si Attorney
We're
Nery.
back naman.
Oo. Narinig
Yes.
ata tayo ni Attorney pero hindi natin siya naririnig.
Okay, narinig niyo na kami?
Oo. So, baka pwede natin ayusin muna no,
okay.
yung linya ng ating komunikasyon at mamaya babalikan natin si Attorney Colmenares. Pero,
Ayan, go ahead.
Okay.
Go ahead. Sola?
Nako.
Sola? We can hear you now.
Okay.
Ay, Attorney Nery! Can you hear us?
Tawagin natin ulit si Attorney kasi naririnig na natin sila.
Attorney Nery. Attorney,
pasensya
sorry.
na.
Okay.
Ang
Pasensya.
kasi dito kasi ang dami nakabang din sa kanya eh.
Anyway,
Yeah. Well, narinig ko yung tanong nyo.
yes, go ahead please.
Hinggil
Go
sa
ahead.
neutralize.
Yun tungkol sa neutralize. Go.
Yes. Una, ang policy, ang element kasi ng crime against humanity, isang part niyan is the policy na ini-implement. Ang policy, according to the prosecution, dalawa yon. Una, yung policy, yung mga order niya to kill doon sa public. Yung mga public pronouncement niya na kill, 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 di ba? Yung second part ng policy, ang proof ng prosecution, is yung Oplan Double Barrel, yung memorandum circular. Doon siya nag-focus sa memorandum circular, sabi niya neutralize. At ang neutralize, ang pakahulugan niyan, ayon sa memorandum circular, is hindi naman ibig sabihin patayin. Sa akin naman, hindi naman talaga pwedeng sabihin patayin kaya walang kalaban-laban. That's a legal document. And parang, hindi ko gusto maisip. Halimbawa, na sinabi ni President Duterte, I will abide by the Constitution of the Philippines. Nakalagay sa Constitution ng Bill of Rights, right to life ng mga mamamayan. Therefore, hindi ako guilty kasi I took my oath to abide by the Bill of Rights. Parang, no. Sa Pilipinas, maraming batas, maraming kung ano-anong mga circulars na binaviolate ng ating mga authorities. Nakalagay naman dyan sa anti-graft law na huwag kang magnakaw Pero hindi nila pwedeng sabihin, yung ethics na pinag-oath namin, sabi, hindi kami magnakaw. So anyway, sa amin, yung neutralization is just a secondary aspect doon. Ibig sabihin yan, killing, pero ang isa pang dagdag dyan, yung order mismo ng Pangulo sa mga public statements niya. That's the policy. That's proof of the policy. At kung sabihin niya naman na sa ending ng speech niya, sinabi niya naman human rights, at least sa ilang speech niya, hindi sa lahat kasi maraming speech niya, wala talagang self-defense. Hindi ibig sabihin ma-exonerate si President Duterte doon. Tingnan natin. Maniniwala ba ang korte? Isang oras, 2 oras ang speech, 80-90% doon. Sasabihin mo, kill, kill and I will pardon you. Di ba? I will give you rewards. Tapos may isang sentence lang siyang ipasok sa ending ng speech niya na self-defense ha. Absuelto na siya. I don't think the court will
So,
buy
yes.
that. Sabihin ng court, no, that was an order. Kaya para sa akin, mahina pa rin yun.
So, attorney, yun ang itatanong ko sana kanina, yung nung opening statement kasi ni Attorney Kaufman, binanggit niya yung cherry picking daw yung prosecution eh. This time sa tingin ba ninyo, based on what you're saying, siya naman ang nag-cherry pick ngayon. Pinipili lang yung mga quote that supports his position.
Correct. Correct. Tama ka dyan, Ivan. Kasi siyempre, prosecution ka, depensa naman yung kabila. In any case, pwede namang buuin yan. Lahat ng speeches niya, wag na tayo mag-cherry pick. And in the end, kahit hindi tayo mag-cherry pick dyan, either the defense or the prosecution, klaro ang speeches. Inuutusan niyang pumatay. Ini-encourage niyang pumatay. I-pardon ko kayo. I-amnesty ko kayo. At may reward pa para pumatay. So, for us, yun ang crucial. And I don't think the statements of the defense so far will dissuade the court from confirming the charges.
Attorney Colmenares, tingin niyo po ba mahalaga pa na binanggit nila yung comparison, no? Kasi naglabas sila ng mga numero na kinumpara nila yung Duterte administration sa Marcos administration. Binanggit po ito ni Attorney Kaufman bago po siya nagtapos before the break. Sabi niya, out of 342 killings in the Marcos administration, 160 daw were killed by state agents at tumaas pa raw yung bilang ng mga vigilante deaths from 2023 to 2024. Tingin niyo po ba matimbang ang ganitong klaseng mga numero pagdating sa kaso against former President Duterte?
In the first place, hindi naman talaga nahinto ang EJK. Whether panahon ni Marcos, ni Duterte, Aquino, Arroyo, lahat naman yung EJK was still there. Ang ginawa lang ni President Duterte talaga, lumampas dun sa extent ng killings ng mga dating administrasyon. Wala kaming sinasabi ever na EJK was stopped. Tapos nag-allege pa siya, kayo, bakit hindi nyo naman kinukondem si President Marcos doon sa human rights violation niya? Yan ang problema. Hindi niya kasi alam ang Philippine politics at Philippine situation. Kami, nagrally nga kami kahapon sa sentrum ng Hague para kondinahin ang human rights violation, corruption sa ilalim ng Marcos administration. Kaya wag niyang i-charge yung victims na, Marcos, politically motivated kayo. Politically motivated. 2018 namin na-file ang kaso. Si Duterte ang presidente noon. Wala kaming anino ni Marcos noon. Hindi nga namin alam na si Marcos mananalo. So how could Marcos have funded this Trump-up case against Duterte way back in 2018? Really, medyo nakakaano pa rin yan, nakakaano sa victims din na parang charge sila na ganun na lang ba ang pagtingin niya sa amin? Wala namang talaga kaming kaso, hindi naman talaga namatay yung kaanak namin, gawa-gawa lang to namin. Really, it's really, parang doon sila nasaktan, doon sa statement na yan. At pangalawa, yung statement din na malit na bahagi lang yan ng populasyon. Parang medyo naano rin sila doon na ganun na lang bang trato sa pagpatay sa 3 kong anak.
Alright, Attorney, mukhang marami-rami na po yung oras na nakain namin dun sa 90-minute break po ninyo. Pero maraming salamat at nakapanayan po namin kayo. Mamaya po makikibalita ulit kami sa inyo. At of course, sa ating kasamang si Marisol Abduraman. Thank you po.
Salamat, Attorney and Sola. Samantala, sinubukan po naming makapanayam mga Filipino legal team ni dating Pangulong Rodrigo Duterte na nasa The Hague. Pero nagsabi po sila na magbibigay sila ng panayam pagkatapos na lang ng pagdinig. Samantala, mula pa rin sa The Hague, makibalita naman tayo. Mula kay Mariz Umali. Mariz, anong latest dyan sa'yo?
Yes, Evan at Pia, sa ngayon ay naka-break nga. Kanina binanggit nyo na medyo nakain nyo yung 90-minute break ni Attorney Colmenares. So hanggang mag-alas 2 ng hapon o alas 10 ng gabi dyan, ay naka-break pa ang pre-trial chamber 1 o yung confirmation of charges hearing. So sa ngayon, nakakadalawang session na sa araw na ito. At ito nga ay purely nakatutok o nakalaan para sa pagsusumite ng mga argumento ng depensa. At sa pagpapresenta nga ng argumento ng depensa, inisa-isa nito yung mga butas sa argumento naman ng prosekusyon. Matatandaan natin o dapat nating isaalang-alang na ang sinasabi ng depensa, hindi sa kanila yung burden of proof dahil ang burden of proof ay nasa prosekusyon. So sa kanila, ang ginagawa nila, talagang tinitibag nila o iniisa-isa yung mga butas argumentong ipinresenta na ng prosekusyon at ng mga hanay ng mga biktima. No? So may bahagi, kapansin-pansin din, Pia at Evan, na may bahagi na nagsagawa ng closed o private session ang hukuman kahit nagpapatuloy sa kanyang mga argumento si Attorney Nicholas Kaufman para sa depensa. At tumugon din sa loob ng closed session na ito ang taga-Office of the Prosecutor naman na si Julian Nichols. Tumagal ito ng mga 6 na minuto at muling binuksan sa publiko ang pagdinig. Dapat nating tandaan na ang default ng International Criminal Court ay laging open court proceeding. Pero nagkakaroon ng closed session para sa mga exceptional circumstances o cases. So karaniwan, limitado lamang ito sa mga bahaging talagang may sensitibong nilalaman. Hindi natin alam kung anong pinag-usapan dahil kahit tayo ay nasa court gallery at naka-headset tayo, nag-mute yung sa headset. So wala tayong naririnig kapag naka-close session. So ano ba marahil ang mga dahilan? Hindi natin alam for sure kung ano yung dahilan kung bakit nila hinold for 6 minutes yung session na yon na naka-close session. Pero ano-ano yung mga posibleng dahilan? Proteksyon ng mga saksi, number 1. Pwede rin may confidential na evidence na kailangan pag-usapan at sila lang ang dapat na nakakarinig. Pwede rin security concerns, sensitive investigative methods, pwede rin yan. Legal arguments na may confidential annexes, proteksyon ng karapatan ng mga akusado, interim procedural matters. Ilan lamang yan sa mga posibleng dahilan kung bakit hinold for a few minutes na naka-close session yung bahaging yon ng session. Samantala, sa kanyang pagpapatuloy naman ng kanyang paglalatag ng mga argumento, 2 mahalagang bagay ang ginawa ni Attorney Kaufman. No? Una, patunayang walang mutually agreed common criminal intent sa mga nangyari during the drug war. At number 2, patunayang hindi naging indirect co-perpetrator si dating Pangulong Rodrigo Duterte. So, ilan sa mga argumento niya, binigyan din ni Kaufman yung PNP Command Circular number 60 na niya ay may laman ng panawagan na i-monitor ang mga posibleng paglabag sa karapatang pantao sa loob ng Philippine National Police. Para sa depensa, mahalagang basahin ang dokumentong ito sa konteksto ng PNP framework at hindi hiwalay sa mas malawak na balangkas ng batas at operasyon ng pulisya. Tinutuligsa rin ni Kaufman ang definition ng Office of the Prosecutor sa salitang neutralization na batay sa International Criminal Court 01-2021, Document 7, sa confirmation brief nga ng prosekusyon. Ang kahulugan kasi ng Office of the Prosecutor dito sa salitang neutralization ay bilang pagpatay at inilahad dito bilang mahalagang bahagi ng umano'y common plan. Subalit giit ni Kaufman at sa larangan ng judicial at law enforcement practice daw, ang neutralization ay nagpapahiwatig ng self-restraint at hindi ibig sabihin agad na lethal force. Binanggit niya ang isang public clarification noong 2017 ni dating PNP Chief Ronald Bato de la Rosa na ang neutralization daw ay nangangahulugan ng pag-aresto. Dagdag pa niya ang salitang ito ay nakaangkla sa PNP Operational Procedural Manual at partikular sa page 130 ng 2021 edition. Ayon sa depensa, ang police intervention daw ay isang mahigpit at legal na proseso at ang neutralization ay maaaring tumukoy sa pag-aresto, pagkakapiit, pagsuko o iba pang paraan ng pagsugpo sa mga hinihinalang suspect. Tinawag din ni Kaufman na mind-boggling na hindi umano isinaalang-alang ng Office of the Prosecutor yung manual na ito doon sa kanilang presentasyon. Giit pa ni Attorney Kaufman, ang pamahalaan ay hindi nagbigay ng license to kill at hindi rin idineklarang labag sa konstitusyon ng Korte Suprema yung drug war at yung mga nakapaloob ng mga operasyon dito. Anya, instructive ang mga tugon ng Korte Suprema kaugnay ng issue. Binanggit din niya ang 2011 revised PNP Manual on Anti-Illegal Drugs. So sa kabuuan, Pia, Evan, talagang sa pagbutas or sa pag-isa-isa niya ng mga butas ng mga argumento ng prosekusyon, pinapatunayan lamang niya na walang indirect co-perpetrator or hindi naging indirect co-perpetrator si dating Pangulong Rodrigo Duterte at wala ring common plan para isagawa yung mga operasyon sa drug war na nagresulta nga sa mga pagpatay na ito. Kumbaga,
Maris?
yung mga, even the witnesses that were interviewed daw ng prosecution ay hindi tumutukoy sa mismong common plan, kundi random lang yung nangyari. So yan muna, ang latest na sitwasyon mula pa rin dito sa Media Center ng International Criminal Court. Balik sa inyo, Pia.
Maraming salamat, Maris. Balikan ka namin mamaya at puntahan muna natin muli Marisol Abderrahman, kasama po niya, Attorney Salvador Panelo. Sol?
Ivan, okay, kasama natin nga dito si Attorney Panelo. Sir, alam namin nagmamadali ka pero you came here as an observer but being kaalyado at abogado ni former President. Ano ho ang masasabi ho ninyo sa unang pagsabak po nitong defense team ni Attorney Kaufman ngayong araw?
Well, Attorney Kaufman did not disappoint me because obviously he has prepared himself for the case for today's submission. He has thoroughly studied this case. He read all the speeches of the President and he pointed out the obvious fact that the prosecution has been lifting portions of the speech of the President when in fact the very speeches would show exonerating statements contrary to what the prosecution is saying. He also read all the pertinent documents cited by the prosecution and pointed to the fact that the very documents presented by the prosecutions are the very documents that will exonerate the President.
Sir, anong pinaka-striking doon, if there's any po, sa mga, anong striking doon sa mga, if there's any po sa presentation kanina ni Attorney Kaufman?
Yung unang-una, yung mga speeches na sinasama lang nila yung mga kill. Yung pala doon at the end of the speeches of the President, palagi sinasabi niya, if your lives are in danger, then you can kill under the principle of self-defense. You have to follow the rules of the law. Lahat ng mga speeches niya gano'n eh. Matagal ko na nga sinasabi yun noon pa. Pangalawa, importante yung mga dokumentong pinipresent ng prosecution nakalagay doon to neutralize. Sabi nila, neutralize doon, ibig sabihin, kill. So parang lumalabas na yun ang dokumento that will show the murderous intent of the President at pinapakita yung communality of design ng mga di umanong accused and the co-perpetrators. Pero lumalabas, yung mismong dokumentong yon, habang nakalagay yung neutralized, na mali nga ang basa nila, nakalagay mismo doon na umaresto kayo nang naaayon sa batas. No, kaya nabuking sila.
Attorney, pero sabi ni Attorney Nery Colmenares, mahina ang depensa.
Ang depensa, hindi pa pwedeng maging mahina. Ang prosecution, ang burden of proof to show na may ebidensya sila. The defense need not prove anything. Ang ginawa nga ng defense kanina, tinalakay niya lang yung mga ebidensya nila, pinakita yung kahinaan ng ebidensya nila.
But Attorney Kaufman, according to Attorney Nery, failed to debunk yung mga niraise po ng prosecution in the earlier part of the hearing po.
Alam nga naman sabihin ng abogadong yun na maganda yung presentasyon ni Attorney Kaufman. Natural lang yun. Alam mo, as I was telling one foreign journalist, kasi he was saying na yung mga sinasabi ni Attorney Kaufman, narinig niya na sa akin yun noon pa. Kasi mga komentaryo ko, pareho lang kami. Sabi ko, alam po ninyo, if you're an objective lawyer, you will be saying the same things that he has been saying in his submission and that I've been saying in my commentaries. But if you are a biased lawyer, you will be parroting the prosecution's line. Kailangan ka maging objective ka.
Alright. Ivan, Pia, may karagdagang tanong for Attorney Panelo?
Attorney, si Ivan, good evening from the Philippines. Nabanggit nyo nga ho, may observation din yung nakausap yung foreign journalist that what Attorney Kaufman has been saying, you have also said previously, especially when you were presidential spokesperson. Ang itatanong ko, I was going to ask, meron ho ba kayo naging input sa mga naging arguments ni Attorney Kaufman?
Yung ngayon, wala. Ang naririnig ko lang sa interview niya, yung dati, sinasabi niya na pinupuri niya ako, marami raw siyang, nakatulong daw ako sa kanyang mga mga pagpreparasyon. Kasi naririnig niya siguro yung mga discussion ko. Kasi hindi ba, I have a daily show and I've been discussing this case for how many years na? 3 taon na yata. Noong pang spokesperson ako hanggang hindi. Ganun pa rin. In that sense siguro, nakatulong ako.
Yes.
But talagang, I think Attorney Kaufman did his job well.
I remember you saying last Monday, dun po sa first day, nung pagkatapos mag-deliver ng opening statement ni Attorney Kaufman, sinabi ninyo okay naman yung opening statement pero sana mas pukpukin pa yung issue on jurisdiction. Satisfied ho ba kayo with how he raised the jurisdiction issue so far?
Siguro oo naman, di ba? Pero siguro sa final summation niya, baka ipapasok pa yun. Kasi alam mo ang jurisdiction, the issue of jurisdiction can be raised anytime at any stage of the proceedings. So kahit na hindi mo yan i-raise ngayon, pwede mo i-raise yan at the end of the trial.
Okay.
Attorney, magandang gabi po, si Pia Arcangel po ito. Alam po namin na wala po kayong pagkakataon na makausap si dating Pangulong Duterte ngayong linggo. Pero pagkatapos po ba ng confirmation of charges hearing, may balak po ba kayo na bumisita or bisitahin si dating Pangulong Duterte para i-report kumbaga kung ano yung nangyari? Kayo po mismo.
Unang-una, yung balak hanggang balak lang yun kasi bawal nga bawal na bumisita nga sa kanya, hindi ka pa pwedeng bumisita.
Kahit hanggang
Only
sa
members
pagtatapos
of
po?
the defense team, accredited, kahit hanggang kailan. Kailangan maging membro kami ng defense formally accredited para kami makabisita kay Presidente.
Pero yung pamilya po ni Pangulong
Sige
Duterte.
tayo. Attorney, speaking of that, di ba nagpa-accredit na kayo? Ay, sorry.
Ano yun? Ano yun?
Well,
Go ahead,
first,
Pia.
okay, first of all, yung question nga ni Sola, kasi nga, hindi po ba
Ano sabi niya?
nagpa-accredit na po kayo? And also, yung isa ko pong tanong is, kung hindi po mismo kay Pangulong Duterte kayo
Hindi pa.
nakikipag-ugnayan.
Teka muna. Yung accredit... Pia,
Yes, go ahead, attorney.
yung accreditation is a long process. Mag-a-apply ka muna. May mga requirements yan. Hindi ganun kadali yan.
Alright, so kung hindi po kayo makakapunta mismo kay Pangulong Duterte or former President Duterte, kamusta naman po yung pakikipag-usap po ninyo or pakikipag-ugnayan po ninyo sa kanyang pamilya na naririto sa Pilipinas?
Ay, hindi pa kami nag-uusap ni VP Sara kaugnay sa kaso. Maliban doon sa sinabi niya, meron akong space sa seat gallery, sa gallery, may seat ako, and nagpasalamat siya sa Diyos na mga safe travel ko.
Alright,
Hindi
so
pa kami
wala
nakausap.
so wala ho siya mga karagdagang tanong po para sa inyo sa mga sandali ito. Okay, sige, attorney, alam po namin, maiksi lang din po, no, yung 90 minutes. Mabilis maubos yung 90 minutes. Yes, attorney, meron pa po kayong gustong idagdag?
Hindi, siguro kaya hindi kami nakakausap ni VP Sara. Alam niyang nasa loob kami. Kayo lang nga nakakapasok sa amin. Yung break time lang kami nakakausap.
Pia, maisingit ko, but attorney, do you intend to brief the Vice President after this trial, after this pre-trial hearing? Do you intend to brief the Vice President kung anong nangyari lahat? All your observations
Filipino
po?
team na create ng pamilyang Duterte, siyempre we will give feedback to them kung anong tingin namin.
Alright, Pia?
Alright, maraming salamat, Sola, at syempre maraming salamat din sa
thank
inyo, Attorney Salvador Panelo.
At balikan po natin ngayon si Mariz Zumali. Mariz, gusto ko lang itanong sa iyo since nandyan ka sa loob, ano? Nung nagdi-discuss, naglalatag ng kanyang mga argumento si Attorney Kaufman for the defense, ano naman ang naging reaksyon ng pamilya, ng mga biktima?
Yes, Ivan, they were intently listening. Itong mga pamilya ng mga biktima ng extrajudicial killings, extrajudicial killings. Ang kapansin-pansin, kumpara noong Tuesday, kung saan talagang very graphic yung paglalatag ng mga argumento ng hanay ng mga biktima o yung counsel for victims, common legal representatives for victims, ay talagang emotional sila. This time, stoic, poker face. Pero sinasabi nila na kung walang common plan, paano mo ipaliliwanag yung napakaraming mga kamatayan? At specifically si Shira, nung natanong natin, paano mo ipaliliwanag yung pagkamatay ng kapatid ko? Parang ganun. Yun yung kanilang reaksyon. Of course, hindi pa natin sila totally makuhanan ng mahabang interview pa kanina. Pero that was just the initial reaction nila dun sa mga naririnig nila habang nilalatag. No?
Naitanong
yung,
ko, Maris,
argumento
kasi
ng depensa. At madagdag ko lang, kanina naputol tayo dun sa pagpuna ng Defense Counsel na si Attorney Nicholas Kaufman dun sa testimonya ng mga saksi ng Office of the Prosecutor. Ang sinasabi kasi rito, dun sa mga binanggit nilang mga witnesses na in-interview nila, ang dalawa sa mga witnesses, ang sinabi, ang neutralized daw ay nangangahulugan ng pag-aresto o pagkakakulong. Habang yung dalawa naman na witnesses ay nagsabing ang lethal force ay lumitaw lamang kapag nanganib na ang buhay ng mga opisyal. So parang ang pinopoint out dito ni Kaufman, even the witnesses of the prosecution, hindi sinasabing ang neutralization ay pagpatay automatically. Tapos sa puntong ito ay pinutol naman ni Judge Motok si Kaufman at hiniling na magbigay ng tiyak na reference. So, giit ng depensa na ang PNP manual ang posisyon ng pamahalaan sa harap ng Korte Suprema at ang mga testimonya ng mga saksi ng Office of the Prosecution ay nagpapakita na ang neutralization ay hindi polisiya ng pagpatay. Muling binatikos din ni Kaufman ang Office of the Prosecutor na anyay sa halip na maghanap ng ebidensya upang linawin ang mga interaksyon ng mga taong sangkot ay gumamit umano ng isang preconceived premise ng common plan at ito ay ipinatong daw sa mga pangyayari. Binanggit din ni Kaufman yung saksing P1 na inilarawan bilang self-confessed murderer na anyay nagpakita ng umano'y common plan ay hindi isang pinong polisiya ng paglilinis ng mga kalsada laban sa droga, kundi pagpatay sa mga kalabang politikal. So, basically, dito makikita natin na talagang they were putting the burden of proof dun sa prosekusyon at wala naman sila talagang bagong mga ebidensya na inilalatag. Sa kabuuan, iginiit ni Kaufman na ang halimbawang ito ay hindi nagpapakita ng isang mutually agreed common criminal plan at sa kanyang ikalawang bahagi nga kanina sinabi ko na dalawa yung ginawa ng depensa. Yung mga isinumitin nilang argumento tungkol sa mode of criminal liability, binigyan din ni Kaufman ang konsepto ng essential contribution at iniangkla ito sa prinsipyo ng sine qua non. Tinanong niya kung ang 49 na pagpatay ay nangyari dahil tiyak na may partisipasyon si dating Pangulong Rodrigo Duterte o kung sa logical na pagsusuri ang pag-urong ni Duterte sa umano'y common plan ba ay magre-resulta sa pagkamatay nung 78. So sa pangwakas, iginiit lang ng depensa na hindi napatunayan ng prosekusyon ng isang malinaw na pinagkasundo ang common plan o isang polisiya ng pagpatay at hindi rin umano na ipakita na may essential contribution ang dating Pangulo sa mga insidenteng binanggit sa kaso. Let me just point out before kung ibalik sa inyo Pia at Ivana na before nag-end yung second session, binanggit din ni Attorney Kaufman na hindi naman daw basically nawala yung mga namamatay because of vigilantes and law enforcers sa panahon ng Administrasyong Marcos. So kung hindi naman daw nawawala yung mga pagpatay, bakit siya rin hindi daw ireklamo sa International Criminal Court? Pia, Ivan?
Maris, natanong ko kanina yung tungkol sa mga biktima kung ano nag-reaction nila because I heard at least 2 points raised by Attorney Kaufman na maaring nakasakit sa kanila. Una, yung para bang pagmaliit doon sa bilang in relation to the total number of those who surrendered or who were arrested. Para bang maliit na bilang lang naman yung mga namatay daw in this whole anti-drug campaign. And another was when Attorney Kaufman mentioned yung mga words na para bang dehumanizing language na pinupunto ng prosecution na hindi naman daw yata dehumanizing, especially in the context of political discourse.
Sorry, merong part ako na hindi narinig. What is the question, Ivan?
Yes, kaya ko tinanong dahil ano kaya ang naging reaksyon nila doon sa mga puntong yon na binanggit ni Attorney Kaufman na maaring nakasakit sa kanila, masakit sa mga biktima.
Alam mo, sa totoo lang, Ivan, ay talagang handa na ang mga pamilya ng mga biktima, no, sa mga ganitong klase. Kasi even last night, nung nag-cover tayo doon sa paggunita ng ilang mga grupo, especially yung Duterte Panagutin na Europe Network, ng ika-4 na anibersaryo ng EDSA People Power Revolution, ay nagsalita si Attorney Cristina Conti at sinabi niya na you have to be prepared tomorrow. Talagang pipilitin talagang tibagin ng depensa yung mga argumento ng prosekusyon, and in the course, talagang posibleng masaktan ng inyong damdamin. Marami silang sasabihin na baliwala ito, napakaliit, gaya ng binanggit mo nga rin, at dahil ito yung nanggaling doon sa argumento nila na napakaliit nung bilang na sinasabi compared to yung mga inaresto lang naman at hindi namatay. So, kumbaga, kaya ako kanina nasabi na parang habang tinitignan ko yung mga mukha nila, poker face, talagang, I'm sure talagang yung kanilang mga pakiramdam ay talagang hinanda na nila para sa mga posibleng maririnig nila na pagtibag nga doon sa argumento ng prosekusyon. So, hindi na sila naapektuhan dito dahil alam nila na sa panig ng prosekusyon at yung panig ng hanay ng mga counsels na nagre-representa sa mga biktima ay talagang naniniwala sila na matibay yung mga argumentong ipinresenta ng prosecution. So kahit na anong gagawin daw ng depensa na pagtibag dito ay hindi na sila maapektuhan ng husto. Ivan?
Okay, Maris, babalikan ka namin dyan. Maraming salamat. Samantala, balikan po natin muli si Professor Romel Bagares. Prof?
Good evening ulit, Professor. Professor, may napansin lang po kasi ako dun sa pag-usad ng confirmation of charges hearings. Kasi the first 2 days dun sa prosecution, di ba napansin natin, Ivan, parang pinapasa, hindi lamang si Deputy Prosecutor Mame Niang ang nagsasalita, kundi parang may mga punto, pinasa kina Attorney Robin Croft, Edward Jeremy, pati na si Julian Nichols. Pero so far today, sa depensa, ang naririnig lang natin...
One-man show.
Yes, Attorney Nicholas Kaufman. Tingin niyo po ba, by design po ba yon? Or traditionally po ba, pagdating sa depensa, iisa lamang talaga ang tumatayo?
Yung analysis ko sa team kasi ni President Duterte, yung isa academic, usually ganun sa defense. Meron kang, kahit sa defense, ano? So si Professor Dobbs actually, yung partner ni Attorney Kaufman, is not a full-time practicing lawyer. He's an academic.
Okay, so kumbaga hindi po siya trial lawyer na nagsasalita sa courtroom.
Actually, he is the one who, before this case became part of the ICC, this proceeding itself, siya yung nag-theorize na yung question ng jurisdiction ng korte. Sabi niya kasi nakalagay sa Rome Statute ay judicial proceedings. Since nung nag-withdraw yung Pilipinas, nasa preliminary examination pa lamang ito ng prosecutor, Office of the Prosecutor, hindi ito yung judicial proceedings na sinasabi sa Rome Statute. Kaya wala ng jurisdiction yung korte nung magkaroon ng grant ng preliminary investigation authority, yung pre-trial chamber.
May isa pa po akong tanong, Professor, kasi nabanggit kanina ni Attorney Panelo. Si Attorney Panelo ata nagsabi na yung jurisdiction at any point during the hearings or maybe later on in the trial, pwede daw i-bring up. Tama po ba yon? At any point, pwede pa rin i-revisit yung itong question of jurisdiction?
Well, may specific rules kasi yung ICC dito, ano? Yung unang point kasi, yung unang procedures kasi, hindi pa kasama dito si Presidente Duterte, yung gobyerno pa lang ng Pilipinas, yung Article 15 challenge na doon sa preliminary examination na unang nagkaroon ng desisyon doon yung appeals chamber. Sabi ng appeals chamber, merong pagkakataon yung Pangulo na i-address to specifically pagdating na dito sa issuance ng arrest warrant or itong process na to under Article 19 man ng Rome Statute. So yun yung una niyang pagkakataon na i-raise yung question. Kasi magkaiba yung proceedings doon. Yung unang proceedings talaga hindi pa partido yung Pangulo, yung Presidente, ay yung Pilipinas as state party. nung nagkaroon na ng arrest warrant at na surrender at inarrest si Pangulong Duterte, yun yung first time niya. At that's actually what the prosecutor, the defense did. They challenged the jurisdiction before the pretrial chamber, and the chamber said pretrial
Attorney?
before the chamber. Yes.
All right. Medyo
Napuputol-putol lang kasi, attorney, yung signal niyo. Are you there? Can you hear us?
Yeah, I can hear you. Can you hear me?
Ayan.
Yeah, so I was saying actually na in the Rome Statute, medyo defined kasi yung rules. Yung unang procedure kasi, hindi pa partido si Pangulong Duterte doon as a respondent. No? It was the government of the Philippines when the question of jurisprudence was first raised. Nagkaroon lang siya ng pagkakataon na i-question ito nung siya ay inaresto na. At ito nga yung ginawa kaagad-agad ng depensa. Nag-file sila ng motion to challenge the jurisdiction of the court. No? At dinina ito ng pretrial chamber. Kaya naka-apela ito ngayon sa appeals chamber.
Attorney, kanina may binabanggit kayo yung you were surprised na hindi ito binring up ng prosecution. Itong sinasabi ng depensa na hindi nga walang Supreme Court ruling about this ano ba to, this memorandum or this order. Bakit ho mahalaga? Again, please walk us through the importance of that particular document or that particular order para po sa kaso ng prosecution.
Una kung gusto ko maging malinaw, no? Kasi I just recall that Attorney Kaufman was referring to a 2022 version of the document, no?
Okay.
So I'm not actually sure what version we're talking about here, because the one that was in operation that was applicable when Senator Bato was PNP chief was the 2000 version. No? And when I searched for that online, I couldn't find it anymore. Now, Attorney Kaufman was referring to a new version that has a definition of neutralization that might be different from the 213 version. But nevertheless, that's a caveat that I must say now, no? Because maybe I haven't looked at the records, but perhaps the prosecution was using a different version. So I cannot say with definitiveness right now kung yun ang situation. Pero may iba't ibang versions kasi. And for all we know, the new version might have corrected the errors of the first one. No? But nevertheless, importante kasi yun dahil may mga requisitos nakalagay doon pag may namamatay sa police operation. No? Kailangan mag-submit ng mga documents as our count by last was 40 plus. Pre and post operation. Kasama doon yung inquest. And mandatory yun, tuwing may namamatay sa police operation, kailangan mag-inquest. For 6,000 official deaths nanlaban, sa proceedings sa Supreme Court na binabanggit din ni Attorney Kaufman, wala kahit isang dokumentong na-iproduce yung PNP. No? So that tells you a lot. No? 6,000 cases of nanlaban, wala kahit isa.
Okay.
And as I said, I noted, each case should have at least 40 documents generated, including an inquest report. Now, who was the PNP chief? Who was the PNP chief at that time? That was Bato. Who was the DOJ secretary who was in charge of the agency in charge of inquest? Attorney Vitaliano Aguirre. So those things would be important from the perspective of the prosecutor.
So what does that prove, attorney? What will that prove?
Diba, meron kasi obligasyon nung time din we were still under the Rome Statute to investigate the killings that are accessible by the International Criminal Court. Yun yung principle ng complementarity, tayo muna. At ang nakalagay doon kasi sa obligasyon sa Rome Statute, hindi yung mga foot soldiers ang imbestigahan, sino yung mga brains, sino yung most guilty.
Okay.
No, kasi yung design ng ICC hindi yung mga nag-pull ng trigger, yung nag-design ng policy, yung nag-utos.
That will support the allegation na may policy, na may common plan to carry out the killings.
Yes. Kasi walang investigation. Sino ba dapat imbestigahan nun under the ICC rules? It's the President himself. It's Bato de la Rosa. It's the people who crafted the plan and implemented it at the high levels. No? Yun kasi dapat ang ginawa under the rules of the Rome Statute for purposes of complementarity. But nakita natin sa lumalabas, yung mga pumatay kakiyan, yung mga low-level officers lang. No? At wala kahit isang investigation that was carried out. What is known as the same suspect, same case test. No? Kung sino yung inimbestigahan ng ICC, dapat yun din yung inimbestigahan sa baba. Ngayon sa ICC, sinong inimbestigahan? Yung mga brains behind the policy. Hindi yung mga sarhento, mga korporal. Kung hindi, yung mga nasa itaas. Yun kasi yung design ng International Criminal Justice with respect to the International Criminal Court.
Professor, ilang beses po tayo nagkaroon ng breaks during these particular hearings, no? Parang ilang beses nagkaroon ng private session, yung tinatawag nilang private session, may mga bahagi ng hearing na talagang redacted. And hindi natin alam kung bakit, hindi natin alam kung ano yung nilalaman, syempre, nung bahaging yun ng hearing. Pero what does this tell us about where the discussion is going, where the arguments are headed?
Well, it may just be, some administrative matters that are that the court thinks should only be left to the discussion to a what we call in the Philippines as a sidebar discussion. No, that and the court's discretion decided that at the court discussion, they decided that they should, to make it to make the discussion faster. That it could just be as simple as that.
So
also the schedules, perhaps the how the next steps will be taken up. I would hazard that these are the things that were discussed with the court there.
So hindi necessarily sensitive information na magugulat na lang tayo na parang very damning evidence on one part.
Well, not necessary kasi nga, di ba, unang-una, lahat naman ng ebidensya nandun dapat may access lahat. It's just really how the parties will use the evidence.
Attorney, nung opening statement, the Attorney Kaufman, he promised that he will show evidence that is fundamental and crucial para hindi na ho magpatuloy itong hearing nito and not go to trial. Sa tingin ninyo, nailabas na ba niya yun o hindi pa?
Well, yung importante para sa akin na malakas yung kalang argumento, kung hindi mo mahimay ng maayos, yun nga yung sinasabi niya, sa anong sinasabi ninyong policy. Pag binasa yung policy na yan, yung context, may human rights dyan. Huwag niyong sabihin sa amin na that policy is a murderous one because it actually talks about human rights safeguards. And the word neutralization there is not about killing, but it actually talks about a range of actions from arrest to the use of force where needed. Right? But actually, even that explanation, so if you actually look at the details, you will see that in the word neutralization as defined in the document itself, it includes killing. Right? And then, so the prosecutor has to show that, well, for all the self-defense cases that you cite, that you say were actually what happened, 6,000, all of them were self-defense cases, all of them were killed. All the people in those operations were killed, which is statistically very questionable to begin with. And then, of course, the evidentiary requirements required by that very manual you cite were not fulfilled by the PNP and the DOJ itself because it's a two-agency collaboration. Where are the inquest reports for all those 6,000 killings? Nothing was done. Nothing was produced in that Supreme Court proceeding. You also cite as has been running for the last 4 years or sitting on that case for the last 4 years.
All right. Well, so Professor, syempre kapag sinusubukan kasi nating makita yung tinatawag nilang bigger picture kasi pangatlong araw na po ito eh. Tapos although hindi pa tapos, 'di ba? Dahil meron pang pangatlong bahagi ang depensa sa araw na ito. Can you tell? Nasasabi niyo na po ba kung may lumalamang o hindi?
Well, halimbawa, dun sa common plan, ang argument kasi ni Attorney Kaufman, wala kahit isang testimony. But we know from jurisprudence that for common plans of this sort, where you have high-level of officials making decisions, you don't need an insider witness for that. And as I said earlier, in the cases that we cite, Lubanga, which was the foundational case for this, the policy can be seen from public statements, right? From speeches, from policies. And we have this smoking gun of a policy here that was used to actually implement the double barrel. It's not just one document, but there's the reloaded document, and then there's also the issuance from Malacanang itself, a memorandum. No, so I think the prosecutor was able to show that there was a common plan at least, no. And also pointed out that there are two other modes of liability, yung aiding and abetting. No? So dun sa aiding and abetting, I think there was already evidence to show that the president actually supported. But it's a different theory of liability. These are alternative theories of liability, and they do not necessarily cancel each other out because you have 3 counts, and in one count you can have aiding and abetting. In another count, you can have direct orders and inducement, and then the last one can be a case of indirect co-perpetration.
So kailangan, attorney, tandaan rin po natin no, na posible na may confirmation of charges on one count, merong
Exactly.
confirmation of charges on two counts, pwede rin isa lang ang meron, yung dalawa wala.
And on different modes of liability. Sabi ko nga pwedeng mix yan. Pwedeng yung isa indirect co-perpetration, yung isa aiding and abetting, yung isa naman ay ordering and inducing. So wag natin kalimutan na may tatlo po yung modes of liability na pinag-uusapan dito at hindi lang indirect co-perpetration.
Ito hong other modes na tatakal na ba ni Attorney Kaufman sa basa ninyo?
Yung sinabi niya kanina na wala namang kahit isang may order, nakarinig na ng order. Doon yun sa ordering and inducing.
Okay.
So yun lang at least yung naalala ko na in-address ordering and inducing.
So, Attorney, babalikan po namin kayo maya-maya lamang. Sa ngayon po, balikan natin ang ilan sa mga iniharap na argumento ng depensa ngayong ikatlong araw ng Confirmation of Charges hearing sa ICC. Kabilang po sa iginiit ng abogado ng dating Pangulo, hindi sapat ang hawak na ebidensya ng prosekusyon para magtuloy sa paglilitis ang reklamo.
President, Your Honors,
Giit ni Kaufman, hindi sapat ang hawak na ebidensya ng prosekusyon para litisin ang dating Pangulo ng crimes against humanity of murder and attempted murder para sa mga pagpatay sa madugong drug war nung mayor pa siya ng Davao City hanggang naging Pangulo ng Pilipinas. Sabi ni Kaufman, wala raw dahilan para dalhin si Duterte sa ICC kundi lang dahil sa nakagugulat na pananalita nito. Pero ang mga talumpati ni Duterte na ginagamit laban sa kanya, hindi raw nagpapakita ng criminal intent at sadya raw pinili ng prosekusyon ang gagamiting sample sa korte para umakma sa kanilang naratibo. At hindi nito pinansin ang mas marami raw na pahayag ni Duterte na nagdidiin sa prinsipyo ng self-defense na naaayon sa batas. Sa 20 speeches daw na ipinresenta ng prosekusyon, nakakita ang depensa ng 35 na nagpapakita ng paghimok ni Duterte sa mga alagad ng batas na sumunod sa batas. Nagbigay si Kaufman ng mga ehemplo.
Let's look at what the Deputy Prosecutor didn't state from the same speech. And the order is simply this: go out, arrest them if you can, but if there is no peaceful method of doing it and you are presented with violent resistance, thereby placing your jeopardy in your life, you shoot. Well, the son of the Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Once again, on shielding criminal agents from prosecution. And I quote, "But if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility." Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, just do it right. We have our trainings that you can only kill if your life is in danger, and you are there performing the duty of a law enforcer.
Sa mapa namang inilabas ng prosekusyon para ipakitang malawakan ang naging pagpatay sa Pilipinas at sa Davao, sinabi ni Kaufman na wala raw nag-uugnay sa mga insidenteng ito sa extrajudicial killing. Kinontra rin ni Kaufman ang sinasabi ng prosekusyon na ang mga pagpatay ay nakadirekta sa populasyon ng Pilipinas. Ang katwiran niya, ang target ay limitado sa isang grupo lamang ng mga umano'y kriminal.
How does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count 1? It is not as if criminals have identifying features, such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purposes of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection. The prosecution must prove that the attack was not directed against a limited group of randomly selected persons.
Dagdag ni Kaufman, hindi raw naiugnay ng prosekusyon ang mga sinabi ni Duterte tungkol sa paghabol sa mga kriminal at sa aktwal na pagpatay sa kanila.
It is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case.
Ang sinasabi ng depensa, wala raw nakuha ang prosekusyon ng witness na nagsasabing narinig nila mismo si Duterte na nag-utos ng pagpatay kaugnay ng mga insidenteng tinukoy ng prosekusyon sa kanilang akusasyon.
There is no smoking gun in this case. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone.
Mariz Umali nagbabalita para sa GMA Integrated News.
Sa confirmation of charges o pagsusuri sa mga ebidensya laban kay Pangulong Rodrigo Duterte sa International Criminal Court, isa sa mga biktima ng drug war na binanggit ang 17 anyos na si Kian De Los Santos na pinatay noong 2017.
As usual, the police claimed that Kian De Los Santos shot at them and they were forced to shoot him dead in self-defense.
Pinanood ng tiyuhin ni Kian na si Randy De Los Santos ang pagdinig na sinasaksihan ngayon ng buong mundo.
Matagal ko nang hindi nakita yung larawan eh. So nakita ko uli. Siyempre masakit. Masakit na muling mabalikan ng mga kwentong ito. Pero kailangan eh.
Sa kabila ng kirot, mahalagaan niyang mailahad ang matagal nang di pinapakinggang kwento kabilang ang sa ibang biktima.
Yung mga kwento, hindi lang ni Kian, baon namin yung mga kwento ng iba sa program Paghilom. Sa hearing naman, may chance sila ipagtanggol yung kanilang sarili. Itong mga pamilya ng mga biktima, yung kaanak namin pinatay, hindi nga kami dumaan ng korte. Hindi nga dumaan ng barangay eh. Patay agad.
Isa lamang ang kay Kian sa mga publicly named na kaso sa kinakaharap ni Duterte na kasong crimes against humanity of murder and attempted murder sa ICC. Kasama rin dyan ang kaso ni dating Osami City Mayor Ronaldo Paruhinog Sr. na pinatay rin noong 2017 sa bahay nila sa Osami sa isang police operation. Kasamang namatay ang asawa niya. Si Alvera Leyte Mayor Rolando Espinosa Sr. at si Raul Yap na nakakulong na noon sa Baybay City Leyte nang mabaril din ng mga pulis. At si Benjamin Visda na pinatay sa Tondo noong October 5, 2016. Ipinakita rin sa pagdinig ang tumatak na imaheng ito ng pinaslang na si Michael Sharon habang kalong ng kinakasamang si Jeneline Olaires. Ang insidente na cover din ng ibang media. Katunayan, bago ang kuhang yun ay na-videohan din ang mga unang reaksyon ni Olaires na hindi malaman noon ang gagawin o kung kanino hihingi ng tulong. Ayon sa prosecution, hindi man nila isinama sa mga kaso ang insidente, isinama nila ang reaksyon dito ng Pangulo na tila minaliitan niya ito at tinawag na gumagawa ng drama. Isa sa mga kaanak ng mga biktima na nagsumite ng kanilang salaysay sa ICC, si Ella, hindi niya tunay na pangalan.
Parang gusto kong sumigaw na sana makamtan namin yung katarungan. Umuulit-ulit yung kwento na nangyari. Narinig ng mga tao na, sir, hindi po ako lalaban. Pero pinalabas nila na nanlaban ang anak ko. Masakit sa akin yung
78 na mga biktima ng murder at attempted murder mula sa lampas 40 na mga insidente ang ebidensyang inihain ng prosekusyon laban kay dating Pangulong Rodrigo Duterte para sa kasong crimes against humanity.
While there are countless victims, we have focused the charges in this case to these 49 incidents and these number of victims in order to ensure that this trial can be expeditious. They're representative of Mr. Duterte's larger killing campaign.
Joseph Morong nagbabalita para sa GMA Integrated News.
Please be seated. Veuillez vous asseoir.
Bonjour à tous.
Judge Modoc, good afternoon. I'd like to begin with an oral ruling regarding the redactions made to the transcript and direct broadcasting today. The Chamber notes that redactions were made to the transcript and to the direct broadcast of the hearing subsequent to an application by the prosecution and which was opposed by the defense. The application of the requested redactions apparently would be a problem and could lead to hearings being held in closed session. The Chamber wishes to recall an earlier ruling during which the Chamber stressed that it is up to the parties and participants to ensure that their submissions are worded in such a way as to avoid going into closed sessions, thus ensuring the transparency of the proceedings and to avoid the disclosure of confidential information. The Chamber would remind the parties to comply with these instructions. Furthermore, the Chamber is of the view that the information that was asked to be redacted and also from the direct broadcast today were limited to identifying information of witnesses and victims mentioned during the submissions. The defense disclosed information on several occasions that allowed for the identification of victims and witnesses. For example, positions held and nicknames, things that must not be disclosed so as to ensure the protection of witnesses and victims. The redactions had only to do with identifying information and were not as general reductions to the events within the case. This was the appropriate recourse to implement the Chamber's duty to protect the safety and well-being, including psychological well-being, the dignity and privacy of victims and witnesses in accordance with Article 68 of the Rome Statute, without having to hold the hearing in private or closed session. Thus, the Chamber has decided to maintain the redactions that were applied earlier and reminds the defense not to disclose information that may not be necessary and information that could identify witnesses and victims in accordance with Article 8 of the Code of Conduct of Counsel. I thank you very much. And Mr. Kaufman, you may now proceed and continue your submissions on the merits. You have until 3 p.m. Thank you very much.
Thank you, Madam President. As you can see, we have a number of yellow post-its on our table here. These are the document identification numbers of all the matters that I'll be talking about. But since we only have until 3 and until 1 hour tomorrow morning, I can provide the ID number if necessary, but I will move on, and we promise to give the Chamber at the conclusion of the hearing the full ID numbers of everything that I've talked about. And if the prosecution obviously wants something as well, he can.
Afternoon, Madam President. I would just ask my friend if he can read out the tab numbers, because every item per the Chamber's instruction has a tab number. So even if my friend doesn't read out the entire ERN of the page he's citing, the lines, if he gives us a tab number, at least we can check his homework in real time.
Merci beaucoup.
Thank you very much. Counsel, are you in agreement with this position taken by the prosecution?
Du procureur.
Well, the representative of the OTP. Mr. Kaufman, yes, ma'am. Judge Motek, please proceed.
Come to ask myself another question concerning the nature of a common plan theory which applies equally to its subjective requirements. Has the prosecution shown substantial grounds to believe that Rodrigo Duterte's implementation of its fantasy criminals scheme was of such a nature that the murders detailed in its 49 charged incidents would have ensued as a virtual certainty in the ordinary course of events, and that he foresaw that they would occur as a virtual certainty in the normal course of events? Let us take a moment so that I can assure you that these wonderful words, virtual certainty, actually do exist in the court's case precedent and are not a fiction of my own. If you will, please display the first of two citations from the Abdul Rahman, otherwise known as the Ali Kushaib trial judgment from 2025. First of all, paragraph 795. While the common plan between individuals need not be specifically directed at the commission of a crime, it must nevertheless involve a critical element of criminality, meaning that in the context of the specificities of the case, it was virtually certain that the implementation of the common plan would lead to the commission of crimes. We can have a look at paragraph 706, and it talks about the general knowledge requirements, which I am sure Your Honours are very familiar with. So, with respect to the question whether the common plan entailed the occurrence of murders as a virtual certainty, the answer is an emphatic and resounding no. First of all, let us recall what the prosecution defines as the former president's list of high-value targets, what the media calls the kill list, and what one of Mr. Edward Jeremy's quoted witnesses referred to as the dead list. The number of individuals on this so-called kill list, the very list on which the prosecution relies to show that the knowledge that death would ensue, is 4,817. Those who are actually neutralized dwarfs in comparison and stands at 248. So, assuming that neutralized actually means killed, which it does not, then there is no virtual certainty attributable to Rodrigo Duterte that death would ensue from this kill list. Rather, a 5% chance. Let us have a look at a bar chart for exactly the same figures used by the prosecution as distributed geographically. I now turn to the issue of control, as it did or did not manifest itself in the crime base. In other words, can it safely be argued that substantial grounds exist to believe that Mr. Duterte's supposed diktat filtered its way down from his mouth and via his co-perpetrators to those who were supposedly going about committing these murders? How has the prosecution shown the concept of automatic compliance, or even virtually automatic compliance, so essential to its pyramidal structure? Well, by and large, and judging from Ms. Robin Croft's submissions, it would appear that the concept of automatic compliance is substantiated by reference to subjective comments made by perpetrators who talk about their will being controlled. For example, transcript, page 37, line 7 onwards. I felt like that I didn't have any choice but to follow their orders. It wasn't possible not to obey his commands. Another example, transcript, page 38, line 17. Co-perpetrators controlled the will of the physical perpetrators. End quote. According to the prosecution, members of the Davao Death Squad had to seek clearance from Mr. Duterte to conduct killings in Davao City. For this wild assertion, the prosecution relies once again on the evidence of criminals it has recruited, all of whom are inherently unreliable because of their being self-confessed vicious murderers, testifying in return for virtual immunity from proceedings at the ICC. We shall analyze the testimonies emanating from these individuals in detail later in my submissions. Now, I can see Mr. Nichols scribbling away there, but I shall be referring to what are called statements of limited use. As for the other modes of liability charged, ordering under Article 25(3)(b and Article 25(3)(c), aiding and abetting, as I have said, no smoking gun, no evidence of a direct order, solicitation, or inducement with respect to any one of the 49 incidents. No documentary record exists of a presidential order. So how could these orders have been transmitted for the purposes of Article 25(3)(b)? Well, unless Mr. Nichols envisages mental telepathy, I think that we can discount ordering. The prosecution has failed to elaborate in its oral submissions what it means truly by soliciting. If it means the ambiguous public speeches, then it is difficult to reconcile the frequent exhortations to self-defense with soliciting, unless, of course, you accept that Mr. Duterte super craftily inserted these exonerating comments into his speeches in order to craft himself a defense when the day of reckoning would come. As the prosecution asserts, speaking with a forked tongue, sometimes speaking his mind, sometimes saying what he wants you, your honours, to hear. Furthermore, generalized statements months before specific incidents do not establish causation or instruction. For aiding and abetting, there is no reliable evidence that Mr. Duterte provided practical assistance, encouragement, or moral support that substantially affected the commission of a crime, with knowledge of the perpetrator's intent. And finally, on modes of perpetration, modes of liability, I would beg you not to take heed of Ms. Paulina Maceda's assertion that Rodrigo Duterte failed to prevent or punish. The prosecution has not charged command responsibility under Article 28. And the reasons for that are clear. It is the same reason why it cannot prove ordering. there is no ascertainable chain of command descending from Duterte at the top via the co-perpetrators, so-called co-perpetrators, all the way down to the crime base. As I said, it all breaks down at the level of the co-perpetrators. And I would ask you very respectfully not to exercise your discretion to requalify pursuant to Regulation 55 of the regulations of the court. But if you do, and you shouldn't, I respectfully submit, you should order the prosecution to resubmit its document containing the charges and its pre-confirmation brief as amended, and to release Mr. Duterte in the interim. Now, I have finished that section of my submission, and I will now turn to the witnesses themselves, and I will be very careful not to mention anything that I'm not meant to. And I will discuss, first of all, the general reliability. A genuine criminal investigation is meant to be directed at establishing the truth. It is meant to elicit facts in an impartial manner and not to present witnesses with a preconceived idea and to seek confirmation thereof, whether it be by way of leading questions or anything else. By this, I mean that the golden thread linking practically every one of the interviews of the prosecution's so-called insider witnesses, who are, for the most part, ruthless criminals, is the a priori targeting of Rodrigo Duterte. In my submission, no real attempt was made to perform this duty of examining exonerating circumstances, or even to establish the existence of other actors who might be responsible for the high incidence of deaths in the context of the war on drugs. Most prosecutors will collate the evidence and thereafter analyze it and decide whether to prosecute with a view to obtaining a reasonable prospect of conviction, which is indeed the standard supposedly applied since Mr. Karim Khan assumed the role of chief prosecutor. A prosecutor is not meant to choose his target in advance and then find the evidence to support a preconceived desire. Now, I'm not going to engage upon a wholesale forensic analysis of the credibility of each and every witness. I am long enough in the tooth to appreciate that issues of credibility and weight are not normally litigated at confirmation, but are left to trial. This case, however, is unique. And as I have said, the prosecution's star witnesses are self-confessed murderers. And most of their statements were taken by the prosecution's investigators with the assurance of limited use. Namely, that anything self-incriminating would not be used against them in proceedings at the ICC. Although Mr. Nichols will undoubtedly tell you that these agreements of limited use are not to be understood as the grant of immunity from prosecution, for all intents and purposes, they are. And I am prepared to wager that we will not see even one, not one, of these incriminating witnesses in a dock at this court, nor in a dock at any court anywhere in the world, after they have been rehoused and given protection at considerable expense to the state parties funding this court. I do not think that I would be alone either in believing that there is something morally repugnant or even questionable from a public policy standpoint to shield not only one, but a number of murderers from prosecution at the ICC just in an attempt to nail Rodrigo Duterte. Indeed, in many common law jurisdictions, the use of a self-avowed murderer to convict an alleged murderer would normally entail vetting and scrutiny of the highest order. Those words, if I'm not mistaken, come from the Crown Prosecution Service's instruction manual. Public source. In fact, I would suggest that it would normally only be approved, firstly, when it is considered of more value to have a suspected person as a witness than as a possible accused. Secondly, whether obtaining the conviction of an alleged murderer is more important than the release of a self-confessed murderer. And finally, whether it is likely that a conviction could be obtained without the cooperation of the self-confessed murderer, or a number of them. Even after this vetting process, most courts and common law jurisdictions require an evidentiary supplement before relying on the sole testimony of a cooperating criminal witness, or what is otherwise called an accomplice witness. Such an evidentiary supplement in legal parlance is called corroboration, and rules exist governing what may be deemed suitable corroboration. I'm pretty sure that these considerations were never considered by the prosecution, for one very simple reason. At least two of the most prominent accomplice witnesses were offered up to the prosecution on a silver platter, and I cannot say by who in open session. Neither the Rome Statute nor its accompanying texts regulate the way statements of limited use are employed. I would like the pre-trial chamber to consider the way academics and the prosecution itself has qualified the implementation of limited use statements in the past. And I quote from paragraph 49, which is open source, of a chapter on the Office of the Prosecutor in the 2022 edition of the Max Planck Encyclopedia of International Law, written by no less than Judge Betty Hohler of this court. And I quote, "One of the agreements the OTP may enter into during the investigation is an agreement with a person suspected of committing crimes within the jurisdiction of the court, is to provide a statement of limited use. The idea is that the person provides the Office of the Prosecutor with an oral or written statement for the purpose of pursuing leads or developing additional information or evidence on the condition that the statement will not be used against the interviewed person except as stipulated in the agreement. The purpose of such agreements is to ensure cooperation of so-called insider witnesses whom the OTP does not intend to prosecute, but are expected to provide key information or evidence against other, usually more senior suspects." Judge Hohler was effectively relying on footnote 20 to the prosecution's own filing, number 1118, in the Bemba Article 70 case, which states the same thing. Both sources stress that limited use statements should be used as a rule to pursue leads or to develop information, but not apparently, outright at any rate, to serve as the key and main testimony against a suspect. In my opinion, there is a good reason for this, and it is contained in the wording of Article 54, 3D of the Rome Statute, which is cited as the statutory basis for limited use statements. The prosecutor is entitled to enter into such agreements granting limited use on condition that the agreement would not be inconsistent with the statute. And I stress those words, not inconsistent with the statute. Using the evidence of self-confessed murderers to obtain leads or develop evidence from other sources, I would suggest, is consistent with the statute, as mentioned by Judge Betty Hohler. To give a get-out-of-jail card, however, to a whole bunch of murderers in order to fix liability to another, albeit pre-selected individual, also selected of murder, is, in my opinion, totally and wholly inconsistent with the object and purpose of the Rome Statute, which, according to its preamble, oft cited by the victims and the prosecution, is dedicated to the eradication of impunity. In my opinion, granting immunity to a murder suspect for core international crimes would be seen as undermining the object and purpose of the Rome Statute. Accordingly, I would ask the Chamber to find the statements of those witnesses afforded such limited use and to be of negligible evidentiary weight. Another issue pertaining to the general credibility of the prosecution's witnesses is the way in which they were recruited. In my opening remarks a couple of days ago, I talked about the general fairness of pursuing charges brought by a prosecutor who was formerly a representative for more than 100 victims of Mr. Duterte's alleged crimes. I also talked about a recorded telephone conversation in which one of the participants bragged about acting as President Marcos Jr.'s silent partner for channeling witnesses to the ICC. Apparently, I raised the presidential spokesperson's hackles considerably. So let me quote a bit more so that I can assure her that my cognitive faculties, which she doubted, are in fact intact. And this is what this covertly recorded individual, who I'm forbidden from naming, said. They cooperate through me, since I don't hold a position, redacted. But we are able to do it. So what? What happened here is an ICC investigator will give me a list of witnesses, documents they need to bolster the case against Duterte. Then I provide it. I give it to the different agencies so it can be approved. There are witnesses who need a pardon. I get the authority from the president, and they are granted a pardon. Basically, like that, it becomes a priority mission of the government. I don't think I've disclosed here, Madam President, any working methodology of the Office of the Prosecutor. So now I turn to the incidents themselves, the 49 incidents. The prosecution invites you to view these incidents as the manifestation of a much larger pattern. To quote the prosecution's very words, in filing number 330 at paragraph 5, the 49 incidents are a non-exhaustive list of examples of the conduct underlying the charges. Indeed, the prosecution speaks of thousands of victims in toto, data sets, and patterns of violence. Now, the defense does not deny that much drug-related violence did occur. It was occurring before Mr. Duterte assumed the reins of power and continued, as we have shown, by way of a sharp increase after he left office. But these grandiose visions of the prosecution are of no avail if the core criminality and incidents alleged in its document containing the charges are not made out. So the question before you is whether there are substantial grounds to believe, firstly, that each of these specific incidents were unlawful killings, namely deliberate acts of murder, and secondly, that they were knowingly committed to further the criminal objective of the so-called common plan or the state organizational policy with which it has been conflated. And finally, that they are indeed attributable to Mr. Duterte under a recognized mode of liability. Preempting a possible defense, always a good tactic for a prosecutor, unsure of the strength of his own case, there is a heavy reliance on expert analysis of data sets to argue that reported instances of self-defense were statistically improbable. Let me stress that it is the defense's view that if the contextual case depends on the scale of victims, namely thousands, as alleged by the prosecution, then establishing the evidentiary integrity of each charged incident is imperative. In other words, the defense firmly submits that the pretrial chamber should not commit any one of the 49 incidents to trial unless it concludes that there are substantial grounds to believe that Mr. Duterte's criminal linkage and liability has been established for each one. When these 49 incidents are disaggregated and examined one by one, as the statute requires, we submit, what becomes apparent is not the cumulative strength, rather the recurrence of certain symptoms of inherent weakness in the evidence. These weaknesses fall into 6 broad categories. The first is the over-heavy reliance on the testimony of cooperating witnesses who are inherent criminals with an inherent propensity to be unreliable and whose statements, as I mentioned, are not corroborated by external evidence. The second, hearsay attribution, or in less legal parlance, incriminating statements heard from a source twice or even 3 times removed. The third weakness, which infects the evidence, is the fact that some of the victims are unidentified, making it virtually impossible for the defense to pursue its own lines of inquiry. This weakness affects at least 9 out of the 49 incidents. The fourth weakness, documentary records, such as police and forensic reports, are at variance with and are contradicted by testimony of a single prosecution witness. Fifth, the hoary old chestnut of conflicting statements emanating from 2 or more witnesses testifying to the same event, some contradicting one another, some contradicting even themselves. And finally, the sixth weakness being the repeated absence of any evidence to link the hitmen to our client, despite the prosecution's best efforts to chivvy such linkage out of them. The defence will now show how these identified weaknesses reduce below the substantial grounds threshold the evidence for these incidents in the three counts as they appear in the document containing the charges. Count 1, the alleged murders during the mayoral period. Count 2, alleged murders of HVTs, the high-value targets, during the presidential period. And count 3, barangay clearance operations also during the presidential period. So I shall start with count 1. As we know, the first cluster of incidents falling under count 1 concerns the so-called and totally fictitious Davao Death Squad period. This concerns incidents 1 through 9 of the document containing the charges. The prosecution's attribution theory here is straightforward, that Rodrigo Duterte, as mayor, authorized killings through intermediaries. But when the evidence for this count is examined, as I've already mentioned, not one witness can say that he heard the mayor give an order to kill. The attribution of criminality to Mr. Duterte arises, for the most part, out of assumption layered on top of hearsay and follows a repetitive pattern which would, as a rule, entail the same mechanism of attribution. Namely, a hitman witness for the prosecution would state that his handler said that clearance came from, and I quote, above. But what does the word above mean? It means an unnamed superior and nothing more. The mode of liability imputed to Mr. Duterte, namely indirect perpetration, requires the prosecution to establish a stable chain of command through which the common enterprise filtered. If there indeed existed a structured approval process, as the prosecution alleges, one would expect operational consistency, not variability. The incidents contained in count 1 are also marked by internal inconsistencies which cannot be reconciled and which are indicative of the fragility of the prosecution's overall case. Incident number 1, for example, is based on the evidence of 2 witnesses who contradict each other on fundamental and materially crucial issues. Let me explain in more detail. P26, who presents himself as a participant, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told that it was the mayor on the phone. Was told that the mayor was on the phone. Pure hearsay. The prosecution seeks to reinforce this through P2. Yet P2 was not present at the time. He was inactive, for reasons I can't mention, and relies entirely on what he heard from the redacted third party and another individual at a later date. P2's account is therefore pure, unadulterated hearsay. More significantly, it diverges from P26's version on fundamental points. The year of the incident, 2014 and not 2013. The number of victims, 2 rather than 3. The identity of the perpetrators. The channel through which alleged clearance was conveyed, via driver and bodyguard, to a different DDS member rather than through redacted. And if that is not enough, the method of killing, strangulation rather than stabbing, these aren't minor inconsistencies. They concern the core factual matrix. If the pre-trial chamber is unable to determine even these basic circumstances which establish opportunity, method,
Mga kapuso, pansamantalang pinutol ang live stream mula dyan sa International Criminal Court. Sa mga pagkakataon pong ganyan, tulad na nabanggit ng kasama natin si Marie Zumali, ay may mga kailangang i-redact o tanggalin mula sa live stream dahil sa iba't ibang dahilan. At pangunahin nga dyan, may mga pinapangalanan na hindi dapat mapangalanan para na rin sa kanilang mga seguridad. At tulad nga po ng nabanggit ni Professor Romel Bagares, may mga kailangang butasin, kailangang i-refute ang depensa pagdating po dun sa mga inihain ng prosekusyon. Balikan natin si Professor Romel Bagares. Prof?
Ay, Ivan.
Yes, nabanggit nyo kanina yung sinasabi ninyong modes of liability. At yan na nga mismo ang dinidiscuss ngayon ni Attorney Kaufman. How did he fare based sa inyong pagpakikinig sa kanya?
Well, nagulat ako dun sa systematic way na nilahad niya, no? Lalo na dun sa issue ng statistical inference. Naalala mo, dinidiscuss ko yun kanina yun. At napaka-surprising at a very, how should I put it, very strong yung argumentation niya doon sa use ng statistical inference. But before that, unahin ko yung sinabi niya na inulit yung meron siyang phrase na sinabi sa simula, yung Finnegan's Wake. Ito yung nobela ni James Joyce na Stream of Consciousness. At I think ko ginamit niya ito para ipaliwanag kung ano daw yung state of thinking or mind ni Presidente Duterte, kung hindi pwedeng sabihin na yung mga sinasabi niya na pagpatay ay yun talagang ibig sabihin nun, no? Dahil ambiguous daw yun, no? At wala daw malinaw na ebidensya ang prosecutor na magsasabi na talagang ang intensyon ng mga statements ng dating Pangulo ay patayin yung mga suspects na involved sa drugs. Ano? At yung pangalawang punto, I think it goes into the ordering and abetting, yung sinasabi nga niya na wala namang kahit sinong testigo yung prosecution na magsasabing narinig talaga nila in person ang no? But that's effective, I think, for ordering, for the mode of liability of ordering or inducing, but not for common plan for indirect perpetration. Kasi hindi requirement yun sa mga jurisprudence, sa common plan. Sinabi ko na kanina, maraming examples na pwedeng gamitin, speeches, written policy, yung pattern.
Attorney, nagpatuloy na po.
Of the Rome Statute does not permit charges to be confirmed on the basis of conjecture, on the basis of such a weak evidentiary basis. Now, since the prosecution made such a big deal out of Incident 3 on Monday and screened the video of the hit job itself, if you recall, the one in a marketplace which was supposedly viewed with approval by our client, I would like to devote a few words to it. If your honours follow the transcript that accompanies this video viewing session, the prosecution fixated on the comments of Mr. Duterte telling the person operating the video not to zoom in.
Balikan natin si Professor Bagares. Nagkaroon na naman ng redaction. Prof, you were saying?
Sinasabi ko nga kanina, yung sa common plan, no, hindi naman kailangan doon ng direct testimony. No? Tingin ko maraming nasabi doon yung prosecutor. Pero doon sa mode of liability ng ordering and inducing, importante doon yung direct testimony na nagsasabi na narinig niya yung presidente mag-order na pumatay. Ano? Yung isa doon na mahabang section, actually it goes into the credibility of the insider witness. Ano?
Yun nga,
Kasi,
yung may part on limited use dun sa mga statements ng mga star witnesses o yung mga self-confessed criminals, ika nga, ni Attorney Kaufman. Go ahead.
Kasi sa ICC, wala po tayong diretsang rules na kagaya sa atin na pwede kang magbigay ng general immunity clause. Ano? Pero somehow na nare-reflect doon yung standard natin na basta hindi siya yung the most guilty. No, pwede. At hindi po pwedeng mangako yung prosecutor na sige, meron kang immunity. No? Ang pwede lang in-observe in practice is that the ICC leaves it to the prosecutor's discretion whether or not to charge. At dito yung nagkakaroon ng mga issues sa credibility kasi nga pwedeng magsabi yung isang tao na sige ako testify ako para lang i-exculpate yung sarili niya kahit na wala naman siyang alam or kahit na mas talagang marami siyang ginawa na hindi dapat i-excuse by the prosecution. Ano? Yun yung sinasabi ni Attorney Kaufman. Ano? Hindi natin alam kung ano pero sabi niya parang pinapahiwatig niya na mukhang may mga pinangako tong prosecutor na hindi dapat pinapangako sa ganitong klaseng konteksto. At dahil ang pinag-uusapan natin dito ay yung mga self-confessed criminals na sabi nila malalim yung kanilang involvement sa movement ni sa DDS, ano? Kung pag ganun hindi pwedeng sabihin na meron kang general immunity. Kasi sinasabi niya baka itong prosecutor na lingid sa kaalaman ng tao wala silang authority to grant general immunity. So it's actually an attack on the credibility of the insider witnesses. Ano? At meron kasing kaso niyan noon din, Lubuanga, yung confidentiality agreements kasi. Di ba, naalala nyo kanina sinabi ko merong equality of arms. Ano?
Yes.
Equality of arms, you are required to disclose. Pero nung yan sa Lubuanga, may mga insider witnesses, nagkaroon sila ng confidentiality agreements nang hiningi ng depensa yung mga dokumento, sabi ng prosecutor, may confidentiality requirement kami. Sabi ng hindi pwede yan kasi merong requirement ng equality of arms. Ano? So nagkaroon ng scandal yun nung sa kaso ng Buanga, na-suspend yung trial, the accused was released subject to appeal. No? And eventually the appeals court intervened and recalled the release but said that there is a requirement really to observe the strict procedures for these things. No?
So, attorney, by questioning the credibility of the star witnesses, ika nga, ano ang gustong mangyari ng depensa dito? Totally ma-disregard ang testimony nitong mga witnesses, ma-strike out of the record na hindi talaga isasali? What are the scenarios?
Yun ang reading ko. No? Sinasabi niya na may problema tayo dito kasi kung sinasabi ng mga insider witness na ang dami nilang pinatay, hindi dapat pinapalagpas yan. No? Hindi pwede yun, sabi niya. Kasi hindi ka at ang parang ini-imply niya kasi na itong mga prosecutors mukhang merong sinabi na hindi dapat sabihin o nagbigay ng pangako na hindi naman niya pwedeng ipangako. Yun yung basa ko doon sa sinabi niya. No?
Tapos, attorney, mukhang may gusto rin siyang i-point out na political angle dito sa mga witnesses. Kasi sinabi niya, these witnesses were offered on a silver platter daw by people na hindi niya mapangalanan.
So again, that's a credibility attack, no? Na how are we sure that the testimony is not colored by anything? Because the prosecution, it appears to me, according to him, is doing something out of bounds. And if they simply depended on this guy whose telephone call was recorded, we don't know even how it was recorded, whether it can be admitted in the proceedings. But his trust is that the testimony of these people is unfortunately tainted and cannot be relied upon. Yun ang sinasabi.
Attorney, tapos pinunan niya rin yung inherent na kahinaan daw ng ebidensya pagdating dito sa 49 incidents on count 1. What do you make? What do you make of those?
Yeah, yung sa DDS, yung sinasabi nga niya, unang-una, wala namang direct testimony.
Second-hand attributions, unidentified daw yung victims, wala daw documentary records, may mga ganun sa mga pinupunto.
So, sa tingin ko tungkol sa ordering 'yun 'no, na merong direct orders presidente kasi nakasama 'yun sa yung ordering on inducing na kasama din 'yun sa count 1 eh, no, na alternative na charge na nakalagay sa document containing charges ano. Pero sa pagdating sa common plan hindi naman siya required ano.
Yes.
Um, 'Yun yung aking puna doon sa punto na 'yun.
Attorney, nung sa pagsisimula nitong fourth session na to, may binanggit siyang Al-Rahman case just last year. May kinukote siya mga trial judgment doon eh. Are you familiar with this case?
Well, it is a recent case. I'm not sure about this no, because he's saying that the phrase virtual certainty was discussed there. It has to do with knowledge na near impossible, or how should I put it, na it's near inevitability, no?
Yes.
Na kung ano yung sinabi ng isang tao, eh mangyayari talaga. It would lead to certain consequences, ano? Sabi niya mahirap itong walang ebidensya na ganito yung kasi nga doon ito sa connection, yung causation between statements and the results, ano? So he was citing that. So I'm not sure about that kind of jurisprudence because it's a recent one. And the commentaries we have right now is only from 2022 and he was citing a case from 2025. We have
itong Al-Rahman, hindi niya masyado
we have
dinetalye
cases-
rin eh.
Yes, meron tayong kaso kasi sa other courts, International Criminal Tribunal for Yugoslavia, mas strict yun actually, no? But the earlier cases sa ICC are not that really mas broad yung kanilang requirements. So, pero it's a very technical ground being raised by Attorney Kaufman here, no? Still on the existence of a common plan that was implemented from top to bottom. So sinasabi niya kung talagang kung galing sa taas yan, paano yung sa baba? Meron bang expectation na kung pag sinabi ng nasa taas, yun din yung gagawin ang pagkaintindi ng nasa baba, no? So meron daw malaking gap doon sa structure na yan na pag may malaking gap, hindi pwedeng sabihin na may kinalaman ang presidente, yung dating presidente Duterte doon.
Dito naman sa count 2, doon sa high value targets, may sinite siyang statistic eh. 4,817 daw ang nasa listahan, pero ang napatay 248. A mere 5%.
Yeah, well, alam mo, yung crimes against humanity kasi, hindi naman yan sa bilang. Ano? Wala yung minimum, walang maximum. Kasi pakita mo yung pattern. So, yung double barrel kasi may high value target and then may barangay enforcement, barangay sweep. Ano? And you combine them, so ang general characteristic talaga niya is it's widespread, it's systematic, no? And it's targeted towards a civilian population. So you can see that there are cases before in the ICC also or in other courts involving, say, 100,000 torture cases, no? Or 200 or such, no? At ang representative cases ay less than 100.
Yes.
So I think that argument that falls flat on its face, no? Kasi ina-isolate niya yung high value targets against the entirety of the representative cases. So I think that can easily be surmounted by the prosecution.
Tapos, Attorney, twice tonight, at least twice, narinig ko si Attorney Kaufman. Una kanina sinabi niya, I don't know if that struck you. Yung sinabi niya, hindi guilty, kailangan umuwi na tayo. Walang ebidensya, umuwi na tayo. Ito naman, may pinanggit naman siya ngayon. Ang prosecution dapat i-resubmit ang kanilang document containing charges and Mr. Duterte or the former president should be released in the interim.
Well, yun yung example ko nga doon sa credibility question, no? Kasi nangyari nga ito sa Lubuanga na because of certain insider witnesses, no, that entered into confidentiality agreements with the with the prosecution, no? It gave rise to problems with respect to the availability of the evidence, no? Kasi kung ano ba yung confidentiality requirements na yun at ano ba yung dinisclose, ano yung agreements na nakapaloob doon, ayaw ibigay ng prosecutor, no? So I think he was taking that to that incident, tawag dyan disclosure crisis ng International Criminal Court, no? And it led to tighter regulation. So he was really hitting that kasi nangyari nga doon, merong order to release yung trial chamber. Kay Lubanga, no? Habang pending yun kasi habang hindi pa nagkaroon ng malinaw na desisyon doon sa questions na itinaas nung depensa, ano? At kasi sinasabi niya essentially kung wala ding pangalawa, no, na based nga doon sa discussion niya yung statistical inference, sabi niya.
Yes.
Kasi yung ebidensya daw dito ay largely an academic study, ano. Pero sabi niya meron kasing requirements, so na parang ang ini-imply niya na itong statistical inference yun lang yung ebidensya at wala nang iba. At kung ganoon lang, tama naman siya doon, no? Kasi kung statistical evidence lang at walang iba, mahina nga ang kaso. No? But I think the prosecutor can say that this has been corroborated and that the statistics here is matched with the wide patterns of killings throughout the Philippines arising from the implementation of Oplan double barrel. Ano? And then yung iba-iba pang mga aspects, no? Yung policy, yung mga statements. So if indeed if the whole case of the prosecutor only rests on statistical inference, then it's going to be a case.
So, yung mga scenarios po dito sa confirmation of charges, of course, if it's confirmed, we go to trial. If it's not confirmed, the former president can be set free. Or, yung isa pa pong option, i-resubmit ng prosecution ang kanilang charges. Posible rin po pala na i-release ang dating Pangulo. Pwede rin yung ganong scenario.
Yeah, may example ko nga ginawa yung kay Lubanga dahil din sa credibility ng witnesses, ano, kay Lubanga rather. So may examples ng ganun, ano. Pwede rin kasi sabihin ng korte na kulang pa yung ebidensya, kuha pa kayo ng bago, pero that does not automatically mean i-release, no.
Yes.
So i-determine pa rin ng korte kung in the meantime pwede pa rin nasa detention ang dating Pangulo.
Prof, tumatagal yata yung yung parang reduction nila. What could be happening? Ano bang posibleng nangyayari ngayon? Sorry.
Ito na. Oo.
Today's hearing, the third day. The hearing shall resume tomorrow at 10 a.m. Thank you, parties and participants. I thank our interpreters, the registry, the technical staff, and all those who have allowed this. Yes, Mr. Nichols?
To interrupt, Your Honors, just at the end of the day, but I wonder if we could go into private session for 1 minute before you leave the bench.
Oui, Mr. Nichols.
Yes, Mr. Nichols?
Kakaroon ng private session with the judge bago mag-adjourn for the day. Ang confirmation of charges hearing ng pretrial chamber 1 at nabanggit nga ni Judge Motok na magpapatuloy ulit 10 a.m. sa local time ang huling araw, ika-4 at huling araw ng confirmation of charges. Balikan natin for his final thoughts si Professor Romel Bagares. Prof, your final thoughts. Anong assessment mo sa unang araw ng paglalatag ng ebidensya at argumento ng depensa?
Well, itong last session na to, no, meron palang sorpresa talaga ang abogado ni dating Duterte. Very strong arguments on the credibility of the witnesses, on the nature of the statistical evidence presented to the prosecutor, and also on, as I said, I expected that the specifics of the cases, whether in fact these are connected to any statement by the president or any common plan or policy, hinimay-himay niya, no? Meron siya very compelling arguments doon, no? And this will now be submitted really to the appreciation of the judges and after the close of the confirmation of charges proceeding. And so this really shows to us that the confirmation of charge like this can have surprises, but I would say that I think the prosecution has given some strong counterweight to what was said. But at the same time, tingin ko doon sa ordering and inducing, mukhang successful doon si Attorney Kaufman, no, na sabihin na wala namang ebidensya. I would give that to him, yung ordering and inducement. But for common plan and for aiding and abetting, tingin ko meron pa ring ebidensyang nailahad na maayos ang prosecutor para dito. And then lastly, you know, whether if this is confirmed, it's just confirmation, no? It doesn't automatically mean na may conviction kasi ibang standard naman doon. Yun yung guilt beyond reasonable doubt. So we should not forget that. This is just confirmation of charges on the question of whether he should go to trial.
Any more surprises tomorrow? May mga ina-anticipate pa ba kayong mga pasabog bukas?
Well, itong I think itong mga sidebar na ginagawa nila tungkol ito sa identities ng witnesses. At sinasabi ng prosecutor na hindi pwede kasi may security issues kaya hindi pwedeng i-disclose yung mga pangalan nila at kung nasaan sila.
Dean, thank you very much for lending your expertise sa ating discussions tonight and for helping us make sense of all of this. Maraming salamat. Professor Romel Regalado Bagares, sa inyong oras sa ating pag-unawa po sa sinasagawang hearing. At mga kapuso, tayo po'y magpapatuloy bukas para sa special coverage ng GMA Integrated News sa confirmation of charges hearing ni dating Pangulong Rodrigo Duterte sa International Criminal Court. Magandang gabi.
Young Rodrigo Duterte.
Session, Madam President. Donc, merci, j'étais
Judge Mochok, I was thanking the participants and parties, and then we had a few moments in private session, and now I would like to wish you a pleasant afternoon. We will see you all tomorrow. And once again, I thank everyone. And this hearing is now adjourned. We will see one another tomorrow.
Rodrigo Duterte. Nakapagsumiti na po ng kanilang mga ebidensya at argumento.